8.3 shares of LGUS in national taxes Pimentel v. Aguirre. Facts: on December 1997, the President issued AO 372. On December 1998, President Estrada issued AO 43, amending Section 4 of AO 372, by reducing to 5% the amount of internal revenue allotment to be withheld from the LGUs. Petitioner contends that by issuing AO 372, the President exercised the power of control over LGUs. Moreover, withholding 10% of the IRA is in contravention of Sector 286 LGC and of Sector 6 Article X of the Constitution, providing for the automatic release to each of these units its share in the national internal revenue. The Solgen claims that AO 372 was issued merely as an exercise of the President's power of supervision over LGUs. Section 4 of Article X of the Consti confines the President's power over local governments to general supervision. This provision has been interpreted to exclude the power of control. In Mondano v. Silvosa, the SC contrasted supervision and control. Thus, supervision means overseeing or the power or authority of an officer to see that subordinate officers perform their duties. If the latter fail or neglect to fulfill them, the former may take such action or step as prescribed by law to make them perform their duties. Control, on the other hand, means the power of an officer to alter or modify or nullify or set aside what a subordinate officer has done in the performance of his duties and to substitute the judgment of the former for that of the latter. In Dryland v. Lim, the difference between control and supervision was further delineated. Officers in control lay down the rules in the performance or accomplishment of an act. If these rules are not followed, they may, in their discretion, order the act undone or redone by their subordinates or even decide to do it themselves. On the other hand, supervision does not cover such authority. Supervising officials merely see to it that the rules are followed, but they themselves do not lay down such rules, nor do they have the discretion to modify or replace them. If the rules are not observed, they may order the work done or redone, but only to conform to such rules. They may not prescribe their own manner of execution of the act. Thus, members of the cabinet and other executive officials are merely alter egos of the President. As such, they are subject to the power of control of the President, at whose will and behest they can be removed from office, or their actions and decisions changed, suspended, or reversed. In contrast, the heads of political subdivisions are elected by the people. By constitutional fiat, they are subject to the President's supervision only, not control, so long as their acts are exercised within the sphere of their legitimate powers. Hand in hand with the constitutional restraint on the President's power over local governments is the state policy of ensuring local autonomy. In Gonzon v. Court of Appeals, we said that local autonomy signified a more responsive and accountable local government structure instituted through a system of decentralization. The grant of autonomy is intended to break up the monopoly of the national government over the affairs of local governments. XXX not XXX to end the relation of partnership and interdependence between the central administration and local government units XXX. Paradoxically, local governments are still subject to regulation, however limited, for the purpose of enhancing self-government. Decentralization simply means the devolution of national administration, not power, to local governments. Local officials remain accountable to the central government as the law may provide. The difference between decentralization of administration and that of power was explained in detail in Limbana v. Mangelen as follows. Now, autonomy is either decentralization of administration or decentralization of power. There is decentralization of administration when the central government delegates administrative powers to political subdivisions in order to broaden the base of government power and in the process to make local governments more responsive and accountable. and ensure their fullest development as self-reliant communities and make them more effective partners in the pursuit of national development and social progress. At the same time, it relieves the central government of the burden of managing local affairs and enables it to concentrate on national concerns. The President exercises general supervision over them, but only to ensure that local affairs are administered according to law. He has no control over their acts in the sense that he can substitute their judgments with his own. Under the Philippine concept of local autonomy, the national government has not completely relinquished all its powers over local governments, including autonomous regions. Only administrative powers over local affairs are delegated to political subdivisions. The purpose of the delegation is to make governance more directly responsive and effective at the local levels. In turn, economic, political and social development at the smaller political units are expected to propel social and economic growth and development. But to enable the country to develop as a whole, the programs and policies effected locally must be integrated and coordinated towards a common national goal. Thus, policy setting for the entire country still lies in the President and Congress. As we stated in Magtages v. Price Properties Corp., Inc., municipal governments are still agents of the national government. Issue 1 Section 1 of AO 372, insofar as it directs LGUs to reduce their expenditures by 25% is valid. Held yes ratio, under existing law, LGU, in addition to having administrative autonomy, enjoy fiscal autonomy as well. Fiscal autonomy means that local governments have the power to create their own sources of revenue in addition to their equitable share in the national taxes released by the national government, as well as the power to allocate their resources in accordance with their own priorities. It extends to the preparation of their budgets, and local officials in turn have to work within the constraints thereof. They are not formulated at the national level and imposed on local governments, whether they are relevant to local needs and resources or not. Hence, the necessity of a balancing of viewpoints and the harmonization of proposals from both local and national officials, who in any case are partners in the attainment of national goals. Local fiscal autonomy does not, however, rule out any manner of national government intervention by way of supervision, in order to ensure that local programs, fiscal and otherwise, are consistent with national goals. Significantly, the President, by constitutional fiat, is the head of the economic and planning agency of the government, primarily responsible for formulating and implementing continuing, coordinated and integrated social and economic policies, plans and programs for the entire country. However, under the Constitution, the formulation and the implementation of such policies and programs are subject to consultations with the appropriate public agencies, various private sectors, and local government units. The President cannot do so unilaterally. There are therefore several requisites before the President may interfere in local fiscal matters: an unmanaged public sector deficit of the national government, consultations with the presiding officers of the Senate and the House of Representatives and the presidents of the various local leagues, and the corresponding recommendation of the secretaries of the Department of Finance, Interior and Local Government, and Budget and Management. Furthermore, any adjustment in the allotment shall in no case be less than 30% of the collection of national internal revenue taxes of the third fiscal year preceding the current one. While the wordings of Section 1 of AO 372 have a rather commanding tone, and while we agree with petitioner that the requirements of Section 284 of the LGC have not been satisfied, we are prepared to accept the Solicitor General's assurance that the directive to identify and implement measures XXX that will reduce total expenditures XXX by at least 25% of authorized regular appropriation is merely advisory in character, and does not constitute a mandatory or binding order that interferes with local autonomy. The language used, while authoritative, does not amount to a command that emanates from a boss to a subaltern. Rather, the provision is merely an advisory to prevail upon local executives to recognize the need for fiscal restraint in a period of economic difficulty. Indeed, all concerned would do well to heed the President's call to unity, solidarity, and teamwork to help alleviate the crisis. It is understood, however, that no legal sanction may be imposed upon LGUs and their officials who do not follow such advice. It is in this light that we sustain the Solicitor General's contention in regard to Section 1. Issue 1. Withholding a part of LGU's IRA is valid. Held no ratio. Section 4 of AO 372 cannot, however, be upheld. A basic feature of local fiscal autonomy is the automatic release of the shares of LGUs in the national internal revenue. This is mandated by no less than the Constitution. The LGC specifies further that the release shall be made directly to the LGU concerned within 5 days after every quarter of the year and shall not be subject to any lien or holdback that may be imposed by the national government for whatever purpose. As a rule, the term shall is a word of command that must be given a compulsory meaning. The provision is, therefore, imperative. Section 4 of AO 372, however, orders the withholding, effective January 1, 1998, of 10% of the LGU's IRA pending the assessment and evaluation by the Development Budget Coordinating Committee of the emerging fiscal situation in the country. Such withholding clearly contravenes the Constitution and the law. Although temporary, it is equivalent to a holdback, which means something held back or withheld, often temporarily. Hence, the temporary nature of the retention by the national government does not matter. Any retention is prohibited. In sum, while Section 1 of AO 372 may be upheld as an advisory effected in times of national crisis, Section 4 thereof has no color of validity at all. The latter provision effectively encroaches on the fiscal autonomy of local governments. Conceitedly, the President was well-intentioned in issuing his order to withhold the LGU's IRA, but the rule of law requires that even the best intentions must be carried out within the parameters of the Constitution and the law. Verily, laudable purposes must be carried out by legal methods. 4. Abatement of nuisance. Estate of Gregoria Francisco v. Ca. Fax. A Quonset was constructed by the American Liberation Forces in 1944. It was purchased in 1946 by Gregoria Francisco. It stands on a lot owned by the PPA and faces the municipal wharf. By virtue of Proclamation No. 83 issued by President Elpidio Quirino, said land was declared for the exclusive use of port facilities. The PPA issued to Tan Jin San, spouse of Gregoria Francisco, a permit to occupy the lot where the building stands for a period of 1 year, to expire on December 31, 1989. The permittee was using the Quonset for the storage of copra. On May 1989, the mayor notified Tan Jin San to remove or relocate its Quonset building, citing Ordinance No. 147, noting its antiquated and dilapidated structure, and stressing the clean-up campaign on illegal squatters and unsanitary surroundings along Strong Boulevard. Since the notifications remained unheeded, the mayor ordered the demolition on May 24, 1989. Petitioner sought a writ of prohibition with injunction and damages before the RDC of Basilan. The RDC denied the writ and upheld the power of the mayor to order the demolition without judicial authority pursuant to Ordinance 147. On September 6, 1989, petitioner's Quonset building was completely demolished. In its place sprang shanties and nipa huts. The CA reversed the RDC and ruled that the mayor was not vested with power to order summarily without any judicial proceeding to demolish the Quonset building, which was not a nuisance per se. However, upon reconsideration, the CA reversed itself and ruled that the deficiency was remedied when petitioner filed a petition for prohibition and injunction and was heard on oral argument. Issue 1. The mayor could summarily, without judicial process, order the demolition of petitioner's Quonset building. Held no ratio. Ordinance No. 147, enacted on December 27, 1977, and relied upon by respondents, is entitled An Ordinance Establishing Comprehensive Zoning Regulations for the Municipality of Isabela. It is not disputed that the Quonset building, which is being used for the storage of copra, is located outside the zone for warehouses. It is referred to in ordinance as a non-conforming structure, which should be relocated. And in the event that an immediate relocation of the building cannot be accomplished, Sector 16 of the ordinance provides: a certificate of nonconformance for all nonconforming uses shall be applied for by the owner or agent of the property involved within 12 mo from the approval of this ordinance. Otherwise the nonconforming use may be condemned or removed at the owner's expense. Even granting that petitioner failed to apply for a certificate of nonconformance, the provision should not be interpreted as authorizing the summary removal of a nonconforming building by the municipal government. For if it does, it must be struck down for being in contravention of the requirements of due process, as originally held by the CA. Moreover, the enforcement and administration of the provisions of the ordinance resides with the zoning administrator. It is said official who may call upon the city fiscal to institute the necessary legal proceedings to enforce the provisions of the ordinance. And any person aggrieved by the decision of the zoning administrator regarding the enforcement of the ordinance may appeal to the Board of Zoning Appeals. That a summary remedy cannot be resorted to is further evident from the penal provisions. Violation of a municipal ordinance neither empowers the municipal mayor to avail of extrajudicial remedies. On the contrary, the local government code imposes upon him the duty to cause to be instituted judicial proceedings in connection with the violation of ordinances. Respondents cannot seek cover under the General Welfare Clause authorizing the abatement of nuisances without judicial proceedings. That tenet applies to a nuisance per se or one which affects the immediate safety of persons and property and may be summarily abated under the undefined law of necessity. The storage of copra in the Quonset building is a legitimate business. By its nature, it cannot be said to be injurious to rights of property, of health, or of comfort of the community. If it be a nuisance per accidens, it may be so proven in a hearing conducted for that purpose. It is not per se a nuisance warranting its summary abatement without judicial intervention. While the Sangguniang Bayan may provide for the abatement of a nuisance, Local Government Code, Seconds 149, it cannot declare a particular thing as a nuisance per se and order its condemnation. The nuisance can only be so adjudged by judicial determination. Petitioner was in lawful possession of the lot and Quonset building by virtue of a permit from the PPA when demolition was effected. It was not squatting on public land. Its property was not of trifling value. It was entitled to an impartial hearing before a tribunal authorized to decide whether the Quonset building did constitute a nuisance in law. There was no compelling necessity for precipitate action. It follows then that the public officials of Isabela, Basilan, transcended their authority in abating summarily petitioner's Quonset building. They had deprived petitioner of its property without due process of law. The fact that petitioner filed a suit for prohibition and was subsequently heard thereon will not cure the defect, as opined by the CA. The demolition having been a fait accompli prior to hearing and the authority to demolish without a judicial order being a prejudicial issue. Technology Developers, Inc. v. CA. Facts: petitioner received a letter from private respondent acting Mayor Pablo N. Cruz, ordering the full cessation of the operation of the petitioner's plant located at Giyong, Sta. Maria, Bulacan. The letter requested plant manager Armando Maines to bring with him to the office of the mayor on February 20, 1989 the following: A. Building permit, B. Mayor's permit, C. Region 3 Pollution of Environment and Natural Resources Anti-Pollution Permit, and of other document. At the requested conference, petitioner undertook to comply with respondent's request for the production of the required documents. Petitioner commenced to secure Region 3 Air Anti-Pollution Permit. Although among the permits previously secured prior to the operation of petitioner's plant was a temporary permit to operate air pollution installation, issued by the then National Pollution Control Commission, and is now at a stage where the Environmental Management Bureau is trying to determine the correct kind of anti-pollution device to be installed as part of petitioner's request for the renewal of its permit. Petitioner's attention having been called to its lack of mayor's permit, it sent its representatives to the office of the mayor to secure the same, but were not entertained. On April 6, 1989, without previous and reasonable notice upon petitioner, respondent ordered the municipality's station commander to padlock the premises of petitioner's plant, thus effectively causing the stoppage of its operation. Petitioner instituted an action for certiorari, prohibition, mandamus with preliminary injunction against private respondent. The judge found that petitioner is entitled to the issuance of a writ of preliminary injunction upon posting of a bond worth P50,000. During the MR, the provincial prosecutor presented his evidence prepared by Meivik Gina, due to the manufacturing process and nature of raw materials used. The fumes coming from the factory may contain particulate matters which are hazardous to the health of the people. As such, the company should cease operating until such a time that the proper air pollution device is installed and operational. The lower court then set aside the order which granted a writ of preliminary mandatory injunction and dissolved the writ issued. Issue 1. The writ of preliminary injunction should be granted. Held no ratio. The matter of issuance of a writ of preliminary injunction is addressed to the sound judicial discretion of the trial court, and its action shall not be disturbed on appeal unless it is demonstrated that it acted without jurisdiction or in excess of jurisdiction or otherwise, in grave abuse of its discretion. By the same token, the court that issued such a preliminary relief may recall or dissolve the writ as the circumstances may warrant. The following circumstances militate against the maintenance of the writ of preliminary injunction sought by petitioner. 1. No mayor's permit had been secured. While it is true that the matter of determining whether there is a pollution of the environment that requires control if not prohibition of the operation of a business is addressed to the National Pollution Control Commission of the Ministry of Human Settlements, now the Environmental Management Bureau, it must be recognized that the mayor of a town has as much responsibility to protect its inhabitants from pollution, and by virtue of his police power, he may deny the application for a permit to operate a business or otherwise close the same unless appropriate measures are taken to control and or avoid injury to the health of the residents of the community from the emissions in the operation of the business. 2. The acting mayor called the attention of petitioner to the pollution emitted by the fumes of its plant, whose offensive odor not only pollute the air in the locality but also affect the health of the residents in the area, so that petitioner was ordered to stop its operation until further orders, and it was required to bring the following: building permit, mayor's permit, and Region 3 DENR anti-pollution permit. 3. This action of the acting mayor was in response to the complaint of the residents of Barangay Giang, Sta Maria, Bulacan, directed to the provincial governor through channels. The NBI, finding that some of the signatures in the 4-page petition were written by one person, appears to be true in some instances. But on the whole, the many signatures appear to be written by different persons. The certification of the barrio captain of said barrio that he has not received any complaint on the matter must be because the complaint was sent directly to the governor through the acting mayor. 4. The closure order of the acting mayor was issued only after an investigation was made by Meivik Gina, who in her report observed that the fumes emitted by the plant goes directly to the surrounding houses and that no proper air pollution device has been installed. 5. Petitioner failed to produce a building permit from the municipality of Sta Maria, but instead presented a building permit issued by an official of Makati on March 6, 1987. 6. While petitioner was able to present a temporary permit to operate by the then National Pollution Control Commission on December 15, 1987, the permit was good only up to May 25, 1988. Petitioner had not exerted any effort to extend or validate its permit, much less to install any device to control the pollution and prevent any hazard to the health of the residents of the community. All these factors justify the dissolution of the writ of preliminary injunction by the trial court, and the appellate court correctly upheld the action of the lower court. Petitioner takes note of the plea of petitioner focusing on its huge investment in this dollar-earning industry. It must be stressed, however, that concomitant with the need to promote investment and contribute to the growth of the economy is the equally essential imperative of protecting the health, nay the very lives of the people, from the deleterious effect of the pollution of the environment. Laguna Lake Development Authority VCA. Facts: RA 4850 was enacted creating the Laguna Lake Development Authority. This agency was supposed to accelerate the development and balanced growth of the Laguna Lake area and the surrounding provinces, cities, and towns, in the Act. Within the context of the national and regional plans and policies for social and economic development. PD 813 amended certain sections RA 4850 because of the concern for the rapid expansion of metropolitan Manila, the suburbs, and the lakeshore towns of Laguna de Bay, combined with current and prospective uses of the lake for municipal industrial water supply, irrigation, fisheries, and the like. To effectively perform the role of the authority under RA 4850, the Chief Executive issued EO 927, further defined and enlarged the functions and powers of the authority, and named and enumerated the towns, cities and provinces encompassed by the term Laguna de Bay region. Also, pertinent to the issues in this case are the following provisions of EO 927, which include in particular the sharing of fees. Sector 2. XXX The authority shall have exclusive jurisdiction to issue permit for the use of all surface water for any projects or activities in or affecting the said region, including navigation, construction, and operation of fish pens, fish enclosures, fish corrals, and the like. SEC 3. Collection of fees. The authority is hereby empowered to collect fees for the use of the lake water and its tributaries for all beneficial purposes, including but not limited to fisheries, recreation, municipal, industrial, agricultural, navigation, irrigation, and waste disposal purpose, provided that the rates of the fees to be collected, and the sharing with other government agencies and political subdivisions, if necessary, shall be subject to the approval of the President of the Philippines upon recommendation of the authority's board, except fish pen fee, which will be shared in the following manner. 20% of the fee shall go to the lakeshore local governments, 5% shall go to the Project Development Fund, which shall be administered by a council, and the remaining 75% shall constitute the share of LLDA. However, after the implementation within the 3-year period of the Laguna Lake Fishery Zoning and Management Plan, the sharing will be modified as follows: 35% of the fish pen fee goes to the lakeshore local governments, 5% goes to the Project Development Fund, and the remaining 60% shall be retained by LLDA, provided, however, that the share of LLDA shall form part of its corporate funds and shall not be remitted to the National Treasury as an exception to the provisions of Presidential Decree No. 1234. Then came Republic Act No. 7160. The municipalities in the Laguna Lake region interpreted the provisions of this law to mean that the newly passed law gave municipal governments the exclusive jurisdiction to issue fishing privileges within their municipal waters. Because RA 7160 provides. Sector 149. Fishery rentals, fees and charges. Municipalities shall have the exclusive authority to grant fishery privileges in the municipal waters and impose rental fees or charges therefore in accordance with the provisions of this section. Municipal governments thereupon assumed the authority to issue fishing privileges and fish pen permits. Big fish pen operators took advantage of the occasion to establish fish pens and fish cages to the consternation of the authority. Unregulated fish pens and fish cages occupied almost the entire lake water surface area, increasing the occupation drastically from 7,000 ha in 1990 to almost 21,000 ha in 1995. The mayor's permit to construct fish pens and fish cages were all undertaken in violation of the policies adopted by the authority on fish pen zoning and the Laguna Lake carrying capacity. In view of the foregoing circumstances, the authority served notice to the general public that 1. All fish pens, fish cages and other aquaculture structures in the Laguna de Bay region, which were not registered or to which no application for registration and/or permit has been filed with Laguna Lake Development Authority as of March 31, 1993 are hereby declared outrightly as illegal. 2. All fish pens, fish cages and other aquaculture structures so declared as illegal shall be subject to demolition, which shall be undertaken by the Presidential Task Force for Illegal Fish Pen and Illegal Fishing. 3. Owners of fish pens, fish cages and other aquaculture structures declared as illegal shall, without prejudice to demolition of their structures, be criminally charged in accordance with Section 39A of Republic Act 4850 as amended by PD 813 for violation of the same laws. Violations of these laws carries a penalty of imprisonment of not exceeding 3 years or a fine not exceeding 5,000 pesos or both at the discretion of the court. All operators of fish pens, fish cages and other aquaculture structures declared as illegal in accordance with the foregoing notice shall have 1 month on or before October 27, 1993 to show cause before the LLDA why their said fish pens, fish cages and other aquaculture structures should not be demolished/dismantled. 1 month thereafter, the authority sent notices to the concerned owners of the illegally constructed fish pens, fish cages and other aquaculture structures advising them to dismantle their respective structures within 10 days from receipt thereof, otherwise, demolition shall be effected. The fish pen owners filed injunction cases against the LLDA. The LLDA filed motions to dismiss the cases against it on jurisdictional grounds. The motions to dismiss were denied. Meanwhile, TRO/writs of preliminary mandatory injunction were issued enjoining the LLDA from demolishing the fish pens and similar structures in question. Hence, the present petition for certiorari, prohibition, and injunction. The CA dismissed the LLDA's consolidated petitions. It ruled that LLDA is not among those quasi-judicial agencies of government appealable only to the Court of Appeals. The LLDA Charter does vest LLDA with quasi-judicial functions insofar as fish pens are concerned. The provisions of the LLDA Charter insofar as fishing privileges in Laguna de Bay are concerned had been repealed by the Local Government Code of 1991, in view of the aforesaid repeal. The power to grant permits devolved to respective local government units concerned. Issue which agency of the government, the LLDA or the towns and municipalities comprising the region, should exercise jurisdiction over the Laguna Lake and its environs insofar as the issuance of permits for fishery privileges is concerned. Held LLDA Ratio, Section 4 of RA 4850, the provisions of PD 813, and Section 2 of EO 927. Specifically provide that the LLDA shall have exclusive jurisdiction to issue permits for the use or all surface water for any projects or activities in or affecting the said region, including navigation, construction, and operation of fish pens, fish enclosures, fish corrals and the like. On the other hand, RA 7160 has granted to the municipalities the exclusive authority to grant fishery privileges in municipal waters. The Sangguniang Bayan may grant fishery privileges to erect fish corrals, oyster, mussels or other aquatic beds or bangus fry area within a definite zone of the municipal waters. The provisions of RA 7160 do not necessarily repeal the laws creating the LLDA and granting the latter water rights authority over Laguna de Bay and the Lake region. The Local Government Code of 1991 does not contain any express provision which categorically expressly repeal the charter of the authority. It has to be conceded that there was no intent on the part of the legislature to repeal Republic Act No. 4850 and its amendments. The repeal of laws should be made clear and expressed. It has to be conceded that the charter of the LLDA constitutes a special law. RA 7160 is a general law. It is basic in statutory construction that the enactment of a later legislation which is a general law cannot be construed to have repealed a special law. It is a well-settled rule in this jurisdiction that a special statute, provided for a particular case or class of cases, is not repealed by a subsequent statute, general in its terms, provisions, and application. Unless the intent to repeal or alter is manifest, although the terms of the general law are broad enough to include the cases embraced in the special law. Where there is a conflict between a general law and a special statute, the special statute should prevail since it evinces the legislative intent more clearly than the general statute. The special law is to be taken as an exception to the general law in the absence of special circumstances forcing a contrary conclusion. This is because implied repeals are not favored and as much as possible, given to all enactments of the legislature. A special law cannot be repealed, amended, or altered by a subsequent general law by mere implication. Considering the reasons behind the establishment of the authority, which are environmental protection, navigational safety, and sustainable development, there is every indication that the legislative intent is for the authority to proceed with its mission. We are on all fours with the manifestation of LLDA that Laguna de Bay, like any other single body of water, has its own unique natural ecosystem. The 900 km lake surface water, the 8 major river tributaries and several other smaller rivers that drain into the lake, the 2,920 square kilometers basin or watershed transcending the boundaries of Laguna and Rizal provinces, constitute one integrated delicate natural ecosystem that needs to be protected with uniform set of policies, if we are to be serious in our aims of attaining sustainable development. This is an inexhaustible natural resource, a very limited one which requires judicious management and optimal utilization to ensure renewability and preserve its ecological integrity and balance. Managing the lake resources would mean the implementation of a national policy geared towards the protection, conservation, balanced growth and sustainable development of the region with due regard to the intergenerational use of its resources by the inhabitants in this part of the earth. The authors of Republic Act 4850 have foreseen this need when they passed this LLDA law, the special law designed to govern the management of our Laguna de Bay lake resources. Laguna de Bay therefore cannot be subjected to fragmented concepts of management policies where lakeshore local government units exercise exclusive dominion over specific portions of the lake water. The implementation of a cohesive and integrated lake water resource management policy, therefore, is necessary to conserve, protect, and sustainably develop Laguna de Bay. The power of the LGUs to issue fishing privileges was clearly granted for revenue purposes. This is evident from the fact that Section 149 of the new Local Government Code empowering local governments to issue fishing permits is embodied in Chapter 2, Book 2, of Republic Act No. 7160 under the heading, Specific Provisions on the Taxing and Other Revenue-Raising Power of LGUs. On the other hand, the power of the authority to grant permits for fish pens, fish cages and other aquaculture structures is for the purpose of effectively regulating and monitoring activities in the Laguna de Bay region and for lake quality control and management. 6. It does partake of the nature of police power, which is the most pervasive, the least limitable and the most demanding of all state powers, including the power of taxation. Accordingly, the charter of the authority which embodies a valid exercise of police power should prevail over the Local Government Code of 1991 on matters affecting Laguna de Bay. There should be no quarrel over permit fees for fish pens, fish cages and other aquaculture structures in the Laguna de Bay area. Section 3 of Executive Order No. 927 provides for the proper sharing of fees collected. In respect to the question as to whether the authority is a quasi-judicial agency or not, it is our holding that, considering the provisions of Section 4 of Republic Act No. 4850 and Section 4 of Executive Order No. 927, Series of 1983, and the ruling of this court in Laguna Lake Development Authority vs. Court of Appeals. There is no question that the authority has express powers as a regulatory a quasi-judicial body in respect to pollution cases, with authority to issue a cease-and-desist order and on matters affecting the construction of illegal fish pens, fish cages and other aquaculture structures in Laguna de Bay. The authority's pretense, however, that it is co-equal to the regional trial courts such that all actions against it may only be instituted before the Court of Appeals cannot be sustained. On actions necessitating the resolution of legal questions affecting the powers of the authority as provided for in its charter, the regional trial courts have jurisdiction. In view of the foregoing, this court holds that Section 149 of RA 7160, otherwise known as the Local Government Code of 1991, has not repealed the provisions of the Charter of the LLDA, Republic Act No. 4850, as amended. Thus, the authority has the exclusive jurisdiction to issue permits for the enjoyment of fishery privileges in Laguna de Bay to the exclusion of municipalities situated therein, and the authority to exercise such powers as are by its charter vested on it. 8.5 Power of Eminent Domain. Mota EETLV Court of Appeals. Facts: the Sangguniang Bayan of the Municipality of Bunawan in Agasan del Sur passed Resolution No. 43/89, authorizing the municipal mayor to initiate the petition for expropriation of a 1-hectare portion of Lot No. 6138 PLS4 along the National Highway owned by Percival Mota E for the site of Bunawan Farmers Center and other government sports facilities. The resolution was approved by Mayor Anuncio Bustillo and was transmitted to the Sangguniang Panlalawigan for its approval. The Sangguniang Panlalawigan disapproved said resolution and returned it with the comment that expropriation is unnecessary, considering that there are still available lots in Bunawan for the establishment of the government center. The municipality filed a petition for eminent domain against Percival Mota E before the RDC. The municipality then filed a motion to take or enter upon the possession of the land upon deposit with the municipal treasurer of the required amount. The RDC granted the motion. It ruled that the Sangguniang Panlalawigan's failure to declare the resolution invalid leaves it effective. It added that the duty of the Sangguniang Panlalawigan is merely to review the ordinances and resolutions passed by the Sangguniang Bayan under Section 208 of BPBLG 337, Old Local Government Code, and that the exercise of eminent domain is not one of the acts enumerated in Section 19 requiring the approval of the Sangguniang Panlalawigan. Petitioners elevated the case in a petition for certiorari before the CA. The CA held that the public purpose for the expropriation is clear from Resolution No. 43/89, and that since the Sangguniang Panlalawigan of Agasan del Sur did not declare Resolution No. 43/89 invalid, expropriation of petitioners' property could proceed. Meanwhile, the municipality had erected 3 buildings on the subject property: the Association of Barangay Councils Hall, the Municipal Motor Pool, both wooden structures, and the Bunawan Municipal Gymnasium, which is made of concrete. In the instant petition for review, petitioner seeks the reversal of the decision and resolution of the CA and a declaration that Resolution No. 43/89 of the Municipality of Bunawan is null and void. Issue 1. A municipality may expropriate private property by virtue of a municipal resolution which was disapproved by the Sangguniang Panlalawigan. Held yes ratio, eminent domain, the power which the municipality of Bunawan exercised in the instant case, is a fundamental state power that is inseparable from sovereignty. It is government's right to appropriate, in the nature of a compulsory sale to the state, private property for public use or purpose. Inherently possessed by the national legislature, the power of eminent domain may be validly delegated to local governments, other public entities and public utilities. For the taking of private property by the government to be valid, the taking must be for public use and there must be just compensation. The municipality's power to exercise the right of eminent domain is not disputed as it is expressly provided for BP 337, the local government code in force at the time expropriation proceedings were initiated. What petitioners question is the lack of authority of the municipality to exercise this right since the Sangguniang Panlalawigan disapproved Resolution No. 43-89. The Sangguniang Panlalawigan's disapproval of Resolution No. 43-89 is an infirm action which does not render said resolution null and void. The law, Section 153 of BPBLG 337, grants the Sangguniang Panlalawigan the power to declare a municipal resolution invalid on the sole ground that it is beyond the power of the Sangguniang Bayan or the mayor to issue. Velasco v. Blas, the only ground upon which a provincial board may declare any municipal resolution, ordinance or order invalid is when such resolution, ordinance, or order is beyond the powers conferred upon the council or president making the same. Absolutely no other ground is recognized by the law. A strictly legal question is before the provincial board in its consideration of a municipal resolution, ordinance, or order. The provincial disapproval of any resolution, ordinance, or order must be premised specifically upon the fact that such resolution, ordinance, or order is outside the scope of the legal powers conferred by law. If a provincial board passes these limits, it usurps the legislative function of the municipal council or president. Such has been the consistent course of executive authority. Thus, the Sangguniang Panlalawigan was without the authority to disapprove Municipal Resolution No. 43-89 for the municipality of Butuan clearly has the power to exercise the right of eminent domain and its Sangguniang Bayan the capacity to promulgate said resolution, pursuant to the earlier quoted Section 9 of BPBLG 337. Perforce, it follows that Resolution No. 43-89 is valid and binding and could be used as lawful authority to petition for the condemnation of petitioner's property. As regards the accusation of political oppression, it is alleged that Motai incurred the ire of then-Mayor Bustillo when he refused to support the latter's candidacy for mayor in previous elections. Petitioners claim that then-incumbent Mayor Bustillo used the expropriation to retaliate by expropriating their land even if there were other properties belonging to the municipality and available for the purpose. Specifically, they allege that the municipality owns a vacant 7-hectare property adjacent to petitioner's land, evidenced by a sketch plan. The limitations on the power of eminent domain are that the use must be public, compensation must be made and due process of law must be observed. The Supreme Court, taking cognizance of such issues as the adequacy of compensation, necessity of the taking and the public use character or the purpose of the taking, has ruled that the necessity of exercising eminent domain must be genuine and of a public character. Government may not capriciously choose what private property should be taken. Prov. Of Cameron's Survey Court of Appeals. Facts: the Sangguniang Panlalawigan of Cameron's Sur passed Resolution No. 129, Series of 1988, authorizing the provincial governor to purchase or expropriate property contiguous to the provincial capital site. In order to establish a pilot farm for non-food and non-traditional agricultural crops and a housing project for provincial government employees. Pursuant to the resolution, the province through Governor Luis R. Villafuerte, filed 2 cases for expropriation against Ernesto N. San Joaquin and Efren N. San Joaquin. The San Joaquins moved to dismiss the complaints on the ground of inadequacy of the price offered for their property. In an order, the trial court denied the motion to dismiss and authorized the province to take possession of the property upon the deposit of P5,714.00. The trial court issued a writ of possession. The San Joaquins filed a motion for relief from the order and a motion to admit an amended motion to dismiss. Both motions were denied. In their petition before the Court of Appeals, the San Joaquins asked that Resolution No. 129, Series of 1988 be declared null and void, that the complaints for expropriation be dismissed, and that the order dated December 6, 1989 denying the motion to dismiss and allowing the province to take possession of the property subject of the expropriation in the order dated February 26, 1990, denying the motion to admit the amended motion to dismiss, be set aside. They also asked that an order be issued to restrain the trial court from enforcing the writ of possession, and thereafter to issue a writ of injunction. The province claimed that it has the authority to initiate the expropriation proceedings under Sections 4 and 7 of Local Government Code and that the expropriations are for a public purpose. The Solicitor General stated that under Section 9 of the Local Government Code, there was no need for the approval by the Office of the President of the exercise by the Sangguniang Panlalawigan of the right of eminent domain. However, the Solicitor General expressed the view that the province of Cameron Sur must first secure the approval of the Department of Agrarian Reform of the plan to expropriate the lands of petitioners for use as a housing project. The CA set aside the order of the court and ordered the trial court to suspend the expropriation proceedings until the province shall have submitted the requisite approval of the DAR. Issue 1. The expropriation was proper ratio. The CA did not rule on the validity of the questioned resolution, neither did it dismiss the complaints. However, when the CA ordered the suspension of the proceedings until the province shall have obtained the authority of the DAR to change the classification of the lands sought to be expropriated from agricultural to non-agricultural use, it assumed that the resolution is valid and that the expropriation is for a public purpose or public use. Public purpose. Modernly, there has been a shift from the literal to a broader interpretation of public purpose or public use for which the power of eminent domain may be exercised. The old concept was that the condemned property must actually be used by the general public before the taking thereof could satisfy the constitutional requirement of public use. Under the new concept, public use means public advantage, convenience, or benefit, which tends to contribute to the general welfare and the prosperity of the whole community, like a resort complex for tourists or housing project. The expropriation of the property authorized by the questioned resolution is for a public purpose. The establishment of a pilot development center would inure to the direct benefit and advantage of the people of the province of Cameron Sur. Once operational, the center would make available to the community invaluable information and technology on agriculture, fishery, and the cottage industry. Ultimately, the livelihood of the farmers, fishermen, and craftsmen would be enhanced. The housing project also satisfies the public purpose requirement of the Constitution. As held in Sumulong v. Guerrero, housing is a basic human need. Shortage in housing is a matter of state concern since it directly and significantly affects public health, safety, the environment, and in some the general welfare. Eminent Domain vs. Carl. It is the submission of the province of Cameron Sur that its exercise of the power of eminent domain cannot be restricted by the provisions of the Carl, particularly Section 65. Which requires the approval of the DAR before a parcel of land can be reclassified from an agricultural to a non-agricultural land. The CA, following the recommendation of the Solicitor General, held that the province of Cameron Sur must comply with the provision of Section 65 of the CARC and must first secure the approval of the Department of Agrarian Reform of the plan to expropriate the lands of the San Joaquins. In heirs of Juancho Ardana v. Reyes, while the court said that there was no need under the facts of this petition to rule on whether the public purpose is superior or inferior to another purpose or engage in a balancing of competing public interest, it upheld the expropriation after noting that petitioners had failed to overcome the showing that the taking of 8,970 SQM formed part of the resort complex. A fair and reasonable reading of the decision is that this court viewed the power of expropriation as superior to the power to distribute lands under the Land Reform Program. The Solicitor General denigrated the power to expropriate by the province of Cameron Sur by stressing the fact that LGUs exercise such power only by delegation. It is true that local government units have no inherent power of eminent domain and can exercise it only when expressly authorized by the legislature. It is also true that in delegating the power to expropriate, the legislature may retain certain control or impose certain restraints on the exercise thereof by the local governments. While such delegated power may be a limited authority, it is complete within its limits. Moreover, the limitations on the exercise of the delegated power must be clearly expressed, either in the law conferring the power or in other legislations. Section 9 of BPBLG 337 does not intimate in the least that local government units must first secure the approval of the Department of Land Reform for the conversion of lands from agricultural to non-agricultural use, before they can institute the necessary expropriation proceedings. Likewise, there is no provision in the Comprehensive Agrarian Reform Law which expressly subjects the expropriation of agricultural lands by local government units to the control of the Department of Agrarian Reform. The closest provision of law that the CA could cite to justify the intervention of the DAR in expropriation matters is Section 65 of the CARL. The opening, adverbial phrase of the provision sends signals that it applies to lands previously placed under the Agrarian Reform Program, as it speaks of the lapse of 5 years from its award. The rules on conversion of agricultural lands found in Section 4 and 5 of Executive Order No. 129A, Series of 1987, cannot be the source of the authority of the DAR to determine the suitability of a parcel of agricultural land for the purpose to which it would be devoted by the expropriating authority. While those rules vest on the Department of Agrarian Reform the exclusive authority to approve or disapprove conversions of agricultural lands for residential, commercial, or industrial uses, such authority is limited to the applications for reclassification submitted by the landowners or tenant beneficiaries. Statutes conferring the power of eminent domain to political subdivisions cannot be broadened or constricted by implication. To sustain the Court of Appeals would mean that the LGUs can no longer expropriate agricultural lands needed for the construction of roads, bridges, schools, hospitals, etc., without first applying for conversion of the use of the lands with the DAR, because all of these projects would naturally involve a change in the land use. In effect, it would then be the DAR to scrutinize whether the expropriation is for a public purpose or public use. Ordinarily, it is the legislative branch of the local government unit that shall determine whether the use of the property sought to be expropriated shall be public, the same being an expression of legislative policy. The courts defer to such legislative determination and will intervene only when a particular undertaking has no real or substantial relation to the public use. There is also an ancient rule that restrictive statutes, no matter how broad their terms are, do not embrace the sovereign unless the sovereign is specially mentioned as subject thereto. The Republic of the Philippines, as sovereign, or its political subdivisions, as holders of delegated sovereign powers, cannot be bound by provisions of law couched in general term. The fears of private respondents that they will be paid on the basis of the valuation declared in the tax declarations of their property, are unfounded. This court has declared as unconstitutional the presidential decrees fixing the just compensation in expropriation cases to be the value given to the condemned property either by the owners or the assessor, whichever was lower. As held in Municipality of Talasa E.V. Ramirez, the rules for determining just compensation are those laid down in Rule 67 of the Rules of Court, which allow private respondents to submit evidence on what they consider shall be the just compensation for their property. Barangay San Roque v. Heirs of Pastor. Fax petitioner filed before the MTC of Talasa, Cebu a complaint to expropriate a property of the respondents. In an order, the MTC dismissed the complaint on the ground of lack of jurisdiction. It reasoned that eminent domain is an exercise of the power to take private property for public use, after payment of just compensation. In an action for eminent domain, therefore, the principal cause of action is the exercise of such power or right. The fact that the action also involves real property is merely incidental. An action for eminent domain is therefore within the exclusive original jurisdiction of the regional trial court and not with this court. On appeal, the RDC dismissed the complaint, holding that an action for eminent domain affected title to real property, hence, the value of the property to be expropriated would determine whether the case should be filed before the MTC or the RDC. The RDC concluded that the action should have been filed before the MTC since the value of the subject property was less than P20,000. Aggrieved, petitioner appealed directly to this court, raising a pure question of law. Respondents contend that the complaint for eminent domain affects the title to or possession of real property. Thus, they argue that the case should have been brought before the MTC, pursuant to BP 129 as amended by Section 3 of RA 7691. This law provides that MTCS shall have exclusive original jurisdiction over all civil actions that involve title to or possession of real property, the assessed value of which does not exceed 20,000 pesos or, in civil actions in Metro Manila, 50,000 pesos exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs. Issue 1. An expropriation suit is one incapable of pecuniary estimation and is therefore within the jurisdiction of the RDC. Held yes. Ratio A review of the jurisprudence of this court indicates that in determining whether an action is one the subject matter of which is not capable of pecuniary estimation. This court has adopted the criterion of first ascertaining the nature of the principal action or remedy sought. If it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation, and whether jurisdiction is in the municipal courts or in the courts of first instance would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, or where the money claim is purely incidental to, or a consequence of, the principal relief sought. Like in suits to have the defendant perform his part of the contract and in actions for support, or for annulment of a judgment or to foreclose a mortgage. This court has considered such actions as cases where the subject of the litigation may not be estimated in terms of money, and are cognizable exclusively by courts of first instance. The rationale of the rule is plainly that the second-class cases, besides the determination of damages, demand an inquiry into other factors which the law has deemed to be more within the competence of courts of first instance, which were the lowest courts of record at the time that the first organic laws of the judiciary were enacted allocating jurisdiction. In the present case, an expropriation suit does not involve the recovery of a sum of money. Rather, it deals with the exercise by the government of its authority and right to take private property for public use. In National Power Corporation v. Joksun, the court ruled that expropriation proceedings have two phases. The first is concerned with the determination of the authority of the plaintiff to exercise the power of eminent domain and the propriety of its exercise in the context of the facts involved in the suit. It ends with an order, if not of dismissal of the action, of condemnation declaring that the plaintiff has a lawful right to take the property sought to be condemned, for the public use or purpose described in the complaint. Upon the payment of just compensation to be determined as of the date of the filing of the complaint, an order of dismissal, if this be ordained, would be a final one, of course, since it finally disposes of the action and leaves nothing more to be done by the court on the merits. So, too, would an order of condemnation be a final one, for thereafter, as the rules expressly state, in the proceedings before the trial court, no objection to the exercise of the right of condemnation shall be filed or heard. The second phase of the eminent domain action is concerned with the determination by the court of the just compensation for the property sought to be taken. This is done by the court with the assistance of not more than 3 commissioners. The order fixing the just compensation on the basis of the evidence before, and findings of, the commissioners would be final, too. It would finally dispose of the second stage of the suit, and leave nothing more to be done by the court regarding the issue. It should be stressed that the primary consideration in an expropriation suit is whether the government or any of its instrumentalities has complied with the requisites for the taking of private property. Hence, the courts determine the authority of the government entity, the necessity of the expropriation, and the observance of due process. In the main, the subject of an expropriation suit is the government's exercise of eminent domain, a matter that is incapable of pecuniary estimation. True, the value of the property to be expropriated is estimated in monetary terms, for the court is duty-bound to determine the just compensation for it. This, however, is merely incidental to the expropriation suit. Indeed, that amount is determined only after the court is satisfied with the propriety of the expropriation. Verily, the court held in Republic of the Philippines v. Zurbano that condemnation proceedings are within the jurisdiction of courts of first instance, the forerunners of the regional trial courts. The said case was decided during the effectivity of the Judiciary Act of 1948 which, like BP 129 in respect to RTCs, provided that courts of first instance had original jurisdiction over all civil actions in which the subject of the litigation is not capable of pecuniary estimation. The 1997 amendments to the Rules of Court were not intended to change these jurisprudential precedents. We are not persuaded by respondents' argument that the present action involves the title to or possession of a parcel of land. They cite the observation of retired Justice Jose Y. Faria, an eminent authority in remedial law, that condemnation or expropriation proceedings are examples of real actions that affect the title to or possession of a parcel of land. Their reliance is misplaced. Justice Faria sought merely to distinguish between real and personal actions. His discussion on this point pertained to the nature of actions, not to the jurisdiction of courts. In fact, in his pre-bar lectures, he emphasizes that jurisdiction over eminent domain cases is still within the RTCs under the 1997 rules. To emphasize, the question in the present suit is whether the government may expropriate private property under the given set of circumstances. The government does not dispute respondents' title to or possession of the same. Indeed, it is not a question of who has a better title or right, for the government does not even claim that it has a title to the property. It merely asserts its inherent sovereign power to appropriate and control individual property for the public benefit, as the public necessity, convenience, or welfare may demand. Mun. Of Paranaki v. VM Realty Corp. Facts pursuant to Sangguniang Bayan Resolution No. 9395, Series of 1993. The municipality of Paranaki filed a complaint for expropriation against VM Realty Corporation, over 2 parcels of land. Allegedly, the complaint was filed for the purpose of alleviating the living conditions of the underprivileged by providing homes for the homeless through a socialized housing project. Petitioner, pursuant to its Sangguniang Bayan Resolution No. 577, Series of 1991, previously made an offer to enter into a negotiated sale of the property with private respondent, which the latter did not accept. The RDC authorized petition to take possession of the subject property upon its deposit with the clerk of court of an amount equivalent to 15% of its fair market value. Private respondent filed an answer alleging that the complaint failed to state a cause of action because it was filed pursuant to a resolution and not to an ordinance as required by RA 7160, and the cause of action, if any, was barred by a prior judgment or residential judicata. On private respondent's motion, its answer was treated as a motion to dismiss. The trial court dismissed the complaint. Issue 1. The resolution is different from the ordinance held yes ratio. Petitioner contends that a resolution approved by the Municipal Council for the purpose of initiating an expropriation case substantially complies with the requirements of the law because the terms ordinance and resolution are synonymous for the purpose of bestowing authority the local government unit through its chief executive to initiate the expropriation proceedings in court in the exercise of the power of eminent domain. Petitioner seeks to bolster this contention by citing Article 36, Rule 6 of the of the Local Government Code, which provides, if the LGU fails to acquire a private property for public use, purpose, or welfare through purchase, the LGU may expropriate said property through a resolution of the Sangguniang authorizing its chief executive to initiate expropriation proceedings. The court disagrees. The power of eminent domain is lodged in the legislative branch of government, which may delegate the exercise thereof to LGUs, other public entities and public utilities. An LGU may therefore exercise the power to expropriate private property only when authorized by Congress and subject to the latter's control and restraints imposed through the law conferring the power or in other legislations. In this case, Section 19 of RA 7160, which delegates to LGUs the power of eminent domain, also lays down the parameters for its exercise. Thus, the following essential requisites must concur before an LGU can exercise the power of eminent domain. 1. An ordinance is enacted by the local legislative council authorizing the local chief executive, in behalf of the LGU, to exercise the power of eminent domain or pursue expropriation proceedings over a particular private property. 2. The power of eminent domain is exercised for public use, purpose, or welfare, or for the benefit of the poor and the landless. 3. There is payment of just compensation, as required under Section 9, Article 3 of the Constitution, and other pertinent laws. 4. A valid and definite offer has been previously made to the owner of the property sought to be expropriated, but said offer was not accepted. In the case at bar, the local chief executive sought to exercise the power of eminent domain pursuant to a resolution of the municipal council. Thus, there was no compliance with the first requisite that the mayor be authorized through an ordinance. Petitioner cites Cameron's Sur vs. CA to show that a resolution may suffice to support the exercise of eminent domain by an LGU. This case, however, is not in point because the applicable law at that time was BP 337/30, the previous local government code, which had provided that a mere resolution would enable an LGU to exercise eminent domain. In contrast, RA 7160 explicitly required an ordinance for this purpose. We are not convinced by petitioners' insistence that the terms resolution and ordinance are synonymous. A municipal ordinance is different from a resolution. An ordinance is a law, but a resolution is merely a declaration of the sentiment or opinion of a lawmaking body on a specific matter. An ordinance possesses a general and permanent character, but a resolution is temporary in nature. Additionally, the two are enacted differently. A third reading is necessary for an ordinance, but not for a resolution, unless decided otherwise by a majority of all the Sangunian members. If Congress intended to allow LGUs to exercise eminent domain through a mere resolution, it would have simply adopted the language of the previous local government code. But Congress did not. In a clear divergence from the previous local government code, Section 19 of RA 7160 categorically requires that the local chief executive act pursuant to an ordinance. Indeed, legislative intent is determined principally from the language of a statute. Where the language of a statute is clear and unambiguous, the law is applied according to its express terms, and interpretation would be resorted to only where a literal interpretation would be either impossible or absurd or would lead to an injustice. 34 In the instant case, there is no reason to depart from this rule, since the law requiring an ordinance is not at all impossible, absurd, or unjust. Moreover, the power of eminent domain necessarily involves a derogation of a fundamental or private right of the people. 35 Accordingly, the manifest change in the legislative language, from resolution under the BP 337 to ordinance, under RA 7160, demands a strict construction. No species of property is held by individuals with greater tenacity, and is guarded by the Constitution and laws more sedulously, than the right to the freehold of inhabitants. When the legislature interferes with that right and, for greater public purposes, appropriates the land of an individual without his consent, the plain meaning of the law should not be enlarged by doubtful interpretation. Petitioner relies on Article 36, Rule 6 of the Implementing Rules, which requires only a resolution to authorize an LGU to exercise eminent domain. This is clearly misplaced, because Section 19 of RA 7160, the law itself, surely prevails over said rule which merely seeks to implement it. It is axiomatic that the clear letter of the law is controlling and cannot be amended by a mere administrative rule issued for its implementation. Besides, what the discrepancy seems to indicate is a mere oversight in the wording of the implementing rules, since Article 32, Rule 6 thereof, also requires that, in exercising the power of eminent domain, the chief executive of the LGU must act pursuant to an ordinance. Issue 1. The complaint states a cause of action held no ratio. In the first place, petitioner merely alleged the existence of such an ordinance, but it did not present any certified true copy thereof. In the second place, petitioner did not raise this point before this court. In fact, it was mentioned by private respondent, and only in passing. In any event, this allegation does not cure the inherent defect of petitioner's complaint for expropriation filed on September 23, 1993. The fact that there is no cause of action is evident from the face of the complaint for expropriation, which was based on a mere resolution. The absence of an ordinance authorizing the same is equivalent to lack of cause of action. Consequently, the Court of Appeals committed no reversible error in affirming the trial court's decision which dismissed the expropriation suit. Issue 1. The action is barred by residential juridicata held no ratio. All the requisites for the application of residential judicata are present in this case. There is a previous final judgment on the merits in a prior expropriation case involving identical interests, subject matter, and cause of action, which has been rendered by a court having jurisdiction over it. Be that as it may, the court holds that the principle of residential judicata, which finds application in generally all cases and proceedings, cannot bar the right of the state or its agent to expropriate private property. The very nature of eminent domain, as an inherent power of the state, dictates that the right to exercise the power be absolute and unfettered even by a prior judgment or residential judicata. The scope of eminent domain is plenary and, like police power, can reach every form of property which the state might need for public use. All separate interests of individuals in property are held of the government under this tacit agreement or implied reservation. Notwithstanding the grant to individuals, the eminent domain, the highest and most exact idea of property, remains in the government, or in the aggregate body of the people in their sovereign capacity. And they have the right to resume the possession of the property whenever the public interest requires it. Thus, the state or its authorized agent cannot be forever barred from exercising said right by reason alone of previous non-compliance with any legal requirement. While the principle of residential judicata does not denigrate the right of the state to exercise eminent domain, it does apply to specific issues decided in a previous case. For example, a final judgment dismissing an expropriation suit on the ground that there was no prior offer precludes another suit raising the same issue. It cannot, however, bar the state or its agent from thereafter complying with this requirement, as prescribed by law, and subsequently exercising its power of eminent domain over the same property. By the same token, our ruling that petitioner cannot exercise its delegated power of eminent domain through a mere resolution will not bar it from reinstituting similar proceedings, once the said legal requirement end. For that matter, all others are properly complied with. Parenthetically and by parity of reasoning, the same is also true of the principle of law of the case. In Republic v. Sticknecht, the court ruled that the power of the state or its agent to exercise eminent domain is not diminished by the mere fact that a prior final judgment over the property to be expropriated has become the law of the case as to the parties. The state or its authorized agent may still subsequently exercise its right to expropriate the same property, once all legal requirements are complied with. To rule otherwise will not only improperly diminish the power of eminent domain, but also clearly defeat social justice. City of Cebu v. Ca. Facts: Merlita Cardino is the owner of a parcel of land in Sitio Sto. Nino, Alaska Mambaling. The City of Cebu filed a complaint for eminent domain against Cardino with the RDC seeking to expropriate the said parcel of land. The complaint was initiated pursuant to Resolution No. 404 and Ordinance No. 1418, dated February 17, 1992. Of the Sangguniang Panlungsod of Cebu City authorizing the city mayor to expropriate the said parcel of land for the purpose of providing a socialized housing project for the landless and low-income city residents. Cardino filed a motion to dismiss on the ground of lack of cause of action as there has been negotiations for the purchase of the property without resorting to expropriation, but said negotiations failed. Also, there was no compliance with the conditions to the exercise of the power of eminent domain. The RDC dismissed the complaint. The CA affirmed the of the RDC. According to the CA, an allegation of repeated negotiations made with the private respondent for the purchase of her property by the petitioner, cannot by any stretch of imagination be equated or likened to the clear and specific requirement that the petitioner should have previously made a valid and definite offer to purchase. It further added that the term negotiation, which necessarily implies uncertainty, it consisting of acts the purpose of which is to arrive at a conclusion, may not be perceived to mean the valid and definite offer contemplated by law. Issue 1. Expropriation may be granted ratio. An offshoot of the foregoing is the instant petition for review on certiorari, which has essentially become a battle of semantics being waged before this court. While petitioner reiterates that paragraph 7 of the complaint sufficiently states compliance with the requirement of a valid and definite offer, private respondent insists that the term negotiations is too broad to be equated with the said requirement. Elaborating, private respondent posited that by definition, negotiations run the whole range of acts preparatory to concluding an agreement, from the preliminary correspondence, the fixing of the terms of the agreement, the price, the mode of payment, obligations of the parties may conceive as necessary to their agreement. Thus, negotiations by itself may pertain to any of the foregoing and does not automatically mean the making of a valid and definite offer. At the outset, it must be said that without necessarily delving into the parties' semantical arguments, this court finds that the complaint does in fact state a cause of action. What may perhaps be conceded is only the relative ambiguity of the allegations in paragraph 7 of the complaint. However, as we have previously held, a complaint should not be dismissed upon a mere ambiguity. Indefiniteness or uncertainty of the cause of action stated therein, for these are not grounds for a motion to dismiss but rather for a bill of particulars. In other words, a complaint should not be dismissed for insufficiency unless it appears clearly from the face of the complaint that the plaintiff is not entitled to any relief under any state of facts which could be proved within the facts alleged therein. The error of both the RDC and Respondent Court of Appeals in holding that the complaint failed to state a cause of action stems from their inflexible application of the rule that when the motion to dismiss is based on the ground that the complaint states no cause of action, no evidence may be allowed and the issue should only be determined in the light of the allegations of the complaint. However, this rule is not without exceptions. In the case of Tan v. Director of Forestry, this court departed from the aforementioned rule and held that, although the evidence of the parties were on the question of granting or denying the petitioner appellant's application for a writ of preliminary injunction, the trial court correctly applied said evidence in the resolution of the motion to dismiss. Likewise, in Mark Opper Mining Corporation v. Garcia, we sanctioned the act of the trial court in considering, in addition to the complaint, other pleadings submitted by the parties in deciding whether or not the complaint should be dismissed for lack of cause of action. This court deemed such course of action but logical where the trial court had the opportunity to examine the merits of the complaint, the answer with counterclaim, the petitioner's answer to the counterclaim and its answer to the request for admission. The same liberality should be applied in the instant case. Furthermore, even on the face of the complaint alone, there is extant a cause of action. All documents attached to a complaint, the due execution and genuineness of which are not detained under oath by the defendant, must be considered as part of the complaint without need of introducing evidence thereon. Additionally, the general rule is that a motion to dismiss hypothetically admits the truth of the facts alleged in the complaint. Thus, Ordinance No. 1418 is not only incorporated into the complaint for eminent domain filed by petitioner, but is also deemed admitted by private respondent. A perusal of the copy of said ordinance which has been annexed to the complaint shows that the fact of petitioners having made a previous valid and definite offer to private respondent is categorically stated therein. Thus, the second whereas clause of the said ordinance provides as follows, whereas the city government has made a valid and definite offer to purchase subject lot for the public use aforementioned but the registered owner Mrs. Merlita Cardino has rejected such offer. The foregoing should now put to rest the long-drawn argument over the alleged failure of the complaint to state a cause of action. There is no longer any room for doubt that as alleged in the complaint, and as admitted by private respondent, the petitioner had in fact complied with the condition precedent of a valid and definite offer set forth in Sector 19 of RA 7160. The rules of procedure are not to be applied in a very rigid, technical sense. Rules of procedure are used only to help secure substantial justice. If a technical and rigid enforcement of the rules is made, their aim would be defeated. Where the rules are merely secondary in importance or made to override the ends of justice, the technical rules had been misapplied to the prejudice of the substantial right of a party, said rigid application cannot be countenanced. The doctrine finds compelling application in the case at bench. For as correctly averred by petitioner, nothing else was accomplished by the dismissal of the complaint for eminent domain but a considerable delay in the proceedings. The dismissal of the complaint did not bar petitioner from filing another eminent domain case and from correcting its alleged error by the mere expedient of changing paragraph 7 thereof. Indeed, precious time has been wasted while the salutary objectives of Ordinance No. 1418 of the City of Cebu have been put on hold by a quarrel over technical matters. Francia v. Munn of Macoian. Facts: on February 6, 2003, the respondent filed a complaint for expropriation against petitioners. Respondent needed petitioners 16,256 SQM. Idle property at the junction of the North Expressway, Malhakani-Bacamalig Main Road Artery and the MacArthur Highway. It planned to use it to establish a common public terminal for all types of public utility vehicles with a weighing scale for heavy trucks. In their answer, petitioners denied that the property sought to be expropriated was raw land. It was in fact developed and there were plans for further development. For this reason, respondents' offer price of P2,333,500 was too low. After trial, the RDC ruled that the expropriation was for a public purpose as the terminal would improve the flow of traffic during rush hours. Moreover, the property is the best site for the proposed terminal because of its accessibility. Aggrieved, petitioners filed a petition for certiorari in the CA. They claimed that the trial court issued the orders without conducting a hearing to determine the existence of a public purpose. The partially granted the petition. Finding that petitioners were deprived of an opportunity to controvert respondents' allegations, the appellate court nullified the order of expropriation except with regard to the writ of possession. According to the CA, a hearing was not necessary because once the expropriator deposited the required amount, the issuance of a writ of possession became ministerial. Issue 1. The CA erred in upholding the RDC's orders that, in expropriation cases, prior determination of the existence of a public purpose was not necessary for the issuance of a writ of possession. Held no ratio. Section 19 of Republic Act 7160 provides. Section 19. Eminent domain. A local government unit may, through its chief executive and acting pursuant to an ordinance, exercise the power of eminent domain for public use or purpose or welfare for the benefit of the poor and the landless. Upon payment of just compensation, pursuant to the provisions of the Constitution and pertinent laws, provided, however, that the power of eminent domain may not be exercised unless a valid and definite offer has been previously made to the owner, and that such offer was not accepted, provided, further, that the local government unit may immediately take possession of the property upon the filing of the expropriation proceedings and upon making a deposit with the proper court of at least 15% of the fair market value of the property, based on the current tax declaration of the property to be expropriated, provided, finally, that the amount to be paid for the expropriated property shall be determined by the proper court, based on the fair market value at the time of the taking of the property. Before a local government unit may enter into the possession of the property sought to be expropriated, it must file a complaint for expropriation sufficient in form and substance in the proper court and deposit with the said court at least 15% of the property's fair market value based on its current tax declaration. The law does not make the determination of a public purpose a condition precedent to the issuance of a writ of possession. Heirs of Ardanavi Reyes. Facts: the Philippine Tourism Authority filed 4 complaints with the CFI of Cebu City for the expropriation of 282 ha of rolling land situated Indiana Barangays Malabog and Babag, Cebu City for the development into integrated resort complexes of selected and well-defined geographic areas with potential tourism value. The PDA will construct a sports complex, clubhouse, golf course, playground, and picnic area on said land. An electric power grid will also be established by NPC as well as deep well and drainage system. Complementary support facilities will also be created. The defendants alleged that the taking is allegedly not impressed with public use under the Constitution. Also, assuming that PDA has such power, the intended use cannot be paramount to the determination of the land as a land reform area, that limiting the amount of compensation by legislative fiat is constitutionally repugnant, and that since the land is under the land reform program, it is the Court of Agrarian Relations and not the Court of First Instance that has jurisdiction over the expropriation cases. The Philippine Tourism Authority, having deposited with the PNB an amount equivalent to 10% of the value of the properties pursuant to PD 1533. The lower court issued separate orders authorizing PDA to take immediate possession of the premises and directing the issuance of writs of possession. Issue 1. The public use requirement has been complied with. Held yes ratio. There are 3 provisions of the Constitution which directly provide for the exercise of the power of eminent domain. Sector 2. Article 4 states that private property shall not be taken for public use without just compensation. Section 6, Article 14 allows the state, in the interest of national welfare or defense and upon payment of just compensation, to transfer to public ownership, utilities, and other private enterprises to be operated by the government. Section 13, Article 14 states that the Batasang Pambansa may authorize upon payment of just compensation the expropriation of private lands to be subdivided into small lots and conveyed at cost to deserving citizens. While not directly mentioning the expropriation of private properties upon payment of just compensation, the provisions on social justice and agrarian reforms which allow the exercise of police power together with the power of eminent domain in the implementation of constitutional objectives are even more far-reaching insofar as taxing of private property is concerned. We cite all the above provisions on the power to expropriate because of the petitioner's insistence on a restrictive view of the eminent domain provision. The thrust of all constitutional provisions on expropriation is in the opposite direction. As early as 1919, this court in Visay in Refining Co v Samus categorized the restrictive view as wholly erroneous and based on a misconception of fundamentals. The petitioners look for the word tourism in the Constitution. Understandably, the search would be in vain. To freeze specific programs like tourism into express constitutional provisions would make the Constitution more prolix than a bulky code and require of the framers a prescience beyond Delphic proportions. In said case, this court emphasized that the power of eminent domain is inseparable from sovereignty, being essential to the existence of the state and inherent in government even in its most primitive forms. The only purpose of the provision in the Bill of Rights is to provide some form of restraint on the sovereign power. It is not a grant of authority. The petitioners ask us to adopt a strict construction and declare that public use means literally use by the public and that public use is not synonymous with public interest, public benefit, or public welfare, and much less public convenience. The petitioners face two major obstacles. First, their contention, which is rather sweeping in its call for a retreat from the public welfare orientation, is unduly restrictive and outmoded. Second, no less than the lawmaker has made a policy determination that the power of eminent domain may be exercised in the promotion and development of Philippine tourism. The restrictive view of public use may be appropriate for a nation which circumscribes the scope of government activities and public concerns and which possesses big and correctly located public lands that obviate the need to take private property for public purposes. Neither circumstance applies to the Philippines. We have never been a laissez-faire state, and the necessities which impel the exertion of sovereign power are all too often found in areas of scarce public land or limited government resources. There can be no doubt that expropriation for such traditional purposes as the construction of roads, bridges, ports, waterworks, schools, electric and telecommunications systems, hydroelectric power plants, markets and slaughterhouses, parks, hospitals, government office buildings, and flood control systems is valid. However, the concept of public use is not limited to traditional purposes. Here as elsewhere, the idea that public use is strictly limited to clear cases of use by the public has been discarded. In the Philippines, Chief Justice Enrique M. Fernando has aptly summarized the statutory and judicial trend as follows. The taking to be valid must be for public use. There was a time when it was felt that a literal meaning should be attached to such a requirement. Whatever project is undertaken must be for the public to enjoy, as in the case of streets or parks. Otherwise, expropriation is not allowable. It is not anymore. As long as the purpose of the taking is public, then the power of eminent domain comes into play. As just noted, the Constitution in at least two cases, to remove any doubt, determines what is public use. One is the expropriation of lands to be subdivided into small lots for resale at cost to individuals. The other is in the transfer, through the exercise of this power, of utilities and other private enterprise to the government. It is accurate to state then that at present whatever may be beneficially employed for the general welfare satisfies the requirement of public use. The petitioner's contention that the promotion of tourism is not public use because private concessionaires would be allowed to maintain various facilities such as restaurants, hotels, stores, etc. inside the tourist complex is impressed with even less merit. Private bus firms, taxicab fleets, roadside restaurants, and other private businesses using public streets and highways do not diminish in the least bit the public character of expropriations for roads and streets. The lease of store spaces in underpasses of streets built on expropriated land does not make the taking for a private purpose. Airports and piers catering exclusively to private airlines and shipping companies are still for public use. The expropriation of private land for slum clearance and urban development is for a public purpose even if the developed area is later sold to private homeowners, commercial firms, entertainment and service companies, and other private concerns. The petitioners have also failed to overcome the deference that is appropriately accorded to formulations of national policy expressed in legislation. The rule in Berman v. Parker of deference to legislative policy even if such policy might mean taking from one private person and conferring on another private person applies as well as in the Philippines. An examination of the language in the 1919 cases of City of Manila v. Chinese Community of Manila and Visayan Refining COV. Camus, earlier cited, shows that from the very start of constitutional government in our country judicial deference to legislative policy has been clear and manifest in eminent domain proceedings. The expressions of national policy are found in the revised Charter of the Philippine Tourism Authority, PD 564. According to them, assuming that PDA has the right to expropriate, the properties subject of expropriation may not be taken for the purposes intended since they are within the coverage of Operation Land Transfer under the Land Reform Program. That the Agrarian Reform Program occupies a higher level in the order of priorities than other state policies like those relating to the health and physical well-being of the people. And that property already taken for public use may not be taken for another public use. The petitioners, however, have failed to show that the area being developed is indeed a land reform area and that the affected persons have emancipation patents and certificates of land transfer. The records show that the area being developed into a tourism complex consists of more than 808 hectares, almost all of which is not affected by the land reform program. The portion being expropriated is 282 hectares of hilly and unproductive land where even subsistence farming of crops other than rice and corn can hardly survive. And of the 282 disputed hectares, only 8,970 square meters, less than 1 hectare, is affected by Operation Land Transfer. Of the 40 defendants, only 2 have emancipation patents for the less than 1 hectare of land affected. The non-impairment clause has never been a barrier to the exercise of police power and likewise eminent domain. As stated in Manigault v. Springs, parties by entering into contracts may not stop the legislature from enacting laws intended for the public good. The applicable doctrine is expressed in Ars v. Ginato, which involved the expropriation of land for a public plaza. The issue of prematurity is also raised by the petitioners. They claim that since the necessity for the taking has not been previously established, the issuance of the orders authorizing the PDA to take immediate possession of the premises, as well as the corresponding writs of possession, was premature. Under Presidential Decree No. 42, as amended by Presidential Decree No. 1533, the government, its agency or instrumentality, as plaintiff in an expropriation proceedings is authorized to take immediate possession, control, and disposition of the property and the improvements, with power of demolition. Notwithstanding the pendency of the issues before the court, upon deposit with the Philippine National Bank of an amount equivalent to 10% of the value of the property expropriated, the issue of immediate possession has been settled in Ars v. Ginato. In answer to the issue, condemnation or expropriation proceedings is in the nature of one that is quasi in rem. wherein the fact that the owner of the property is made a party is not essentially indispensable insofar at least as it concerns the immediate taking of possession of the property and the preliminary determination of its value, including the amount to be deposited. Makasior, it appearing that the petitioners are not tenants of the parcels of land in question and therefore do not fall within the purview of the Land Reform Code, the petition should be dismissed on that score alone. There is no need to decide whether the power of the PDA to expropriate the land in question predicated on the police power of the state shall take precedence over the social justice guarantee in favor of tenants and the landless. The welfare of the landless and small landowners should prevail over the right of the PDA to expropriate the lands just to develop tourism industry, which benefit the wealthy only. Such a position would increase the disenchanted citizens and drive them to dissidence. The government is instituted primarily for the welfare of the governed, and there are more poor people in this country than the rich. The tourism industry is not essential to the existence of the government, but the citizens are, and their right to live in dignity should take precedence over the development of the tourism industry. Philstream International Inc. VCA. Facts: petitioner is the registered owner of the properties subject of this dispute, consisting of adjacent parcels of land situated in Antonio Rivera Street, Tonda 2, Manila. Petitioner filed an ejectment suit before the MTC against the occupants of the parcels of land on the grounds of termination of the lease contract and non-payment of rentals. Judgment was rendered by the MTC ordering private respondents to vacate the premises and pay back rentals to petitioner. The RDC and CA affirmed. However, it appeared that during the pendency of the ejectment proceedings, private respondents, a complaint for annulment of deed of exchange against petitioner which was filed before the RDC. The City of Manila then approved Ordinance No. 7813, authorizing Mayor Lim to initiate the acquisition by negotiation, expropriation, purchase, or other legal means certain parcels of land which formed part of the properties of petitioner then occupied by private respondents. The city approved Ordinance No. 7855 declaring the expropriation of certain parcels of land situated along Antonio Rivera and Fernando Magurero Streets in Tonda, Manila, which were owned by Mr. Enrique Quijano Gutierrez, petitioner's predecessor in interest. The said properties were to be sold and distributed to qualified tenants of the area pursuant to the Land Use Development Program of the City of Manila. The City of Manila filed a complaint for eminent domain. The trial court issued a writ of possession in favor of the city which ordered the transfer of possession over the disputed premises to the City of Manila. Petitioner filed a motion to dismiss, but the court denied th motion. Concerning the first case, the trial court issued an order commanding the demolition of the structure erected on the disputed premises. To avert the demolition, private respondents filed before the RDC of Manila, Branch 14, a petition for certiorari and prohibition with prayer for the issuance of a temporary restraining order and preliminary injunction. The TRO was granted, which was later lifted. The court dismissed the case on the ground of forum shopping. On appeal, the CA found merit in private respondents' allegations in support of their application of the issuance of the writ and granted the same. The issue raised in GR number 125218 is purely procedural and technical matter. Petitioner takes exception to the resolutions of the CA which ordered the dismissal of its petition for certiorari for non-compliance with seconds 2 of Rule 6 of the revised internal rules of the Court of Appeals by failing to attach to its petition other pertinent documents and papers, and for attaching copies of pleadings which are blurred and unreadable. Petitioner argues that respondent appellate court seriously erred in giving more premium to form rather than the substance. We agree with the petitioner. A strict adherence to the technical and procedural rules in this case would defeat rather than meet the ends of justice, as it would result in the violation of the substantial rights of petitioner. At stake in the appeal filed by petitioner before the CA is the exercise of their property rights over the disputed premises which have been expropriated and have in fact been ordered condemned in favor of the City of Manila. In effect, The dismissal of their appeal in the expropriation proceedings based on the aforementioned grounds is tantamount to a deprivation of property without due process of law, as it would automatically validate the expropriation proceedings based on the aforementioned grounds is tantamount to a deprivation of property without due process of law, as it would automatically validate the expropriation proceedings which the petitioner is still disputing. It must be emphasized that where substantial rights are affected, as in this case, the stringent application of procedural rules may be relaxed if only to meet the ends of substantial justice. With regard to the other petition, GR number 128077. Petitioner Philstream objects to the issuance by Respondent CA of the restraining order and the preliminary injunction enjoining the execution of the writ of demolition issued in the ejectment suit as an incident to private respondents pending. Petition assailing the dismissal by the RDC of Manila, Branch 33, of the consolidated petitions for certiorari filed by private respondents in the City of Manila on the ground of forum shopping. The propriety of the issuance of the restraining order and the writ of preliminary injunction is but a mere instant to the actual controversy, which is rooted in the assertion of the conflicting rights of the parties in this case over the disputed premises. In order to determine whether private respondents are entitled to the injunctive reliefs granted by Respondent CA, we deemed it proper to extract the source of discord. Petitioner anchors its claim by virtue of its ownership over the properties and the existence of a final and executory judgment against private respondents ordering the latter's ejectment from the premises. Private respondents' claim, on the other hand, hinges on an alleged supervening event which has rendered the enforcement of petitioner's rights moot, that is, the expropriation proceedings undertaken by the City of Manila over the disputed premises for the benefit of herein private respondents. For its part, the City is merely exercising its power of eminent domain within its jurisdiction by expropriating petitioners' properties for public use. There is no dispute as to the existence of a final and executory judgment in favor of petitioner ordering the ejectment of private respondents from the properties subject of this dispute. The judgment in the ejectment suit became final after private respondents failed to interpose any appeal from the adverse decision of CA. Petitioner has every right to assert the execution of this decision, as it had already become final and executory. However, it must also be conceded that the City of Manila has an undeniable right to exercise its power of eminent domain within its jurisdiction. The right to expropriate private property for public use is expressly granted to it under Section 19 of the 1991 Local Government Code. More specifically, the City of Manila has the power to expropriate private property in the pursuit of its urban land reform and housing program as explicitly laid out in the revised Charter of the City of Manila. In fact, the City of Manila's right to exercise these prerogatives, notwithstanding the existence of a final and executory judgment over the property to be expropriated, has been upheld by this court in the case of Philippine-Colombian Association vs. Panis. Corollary to the expanded notion of public use, expropriation is not anymore confined to vast tracts of land and landed estate. It is therefore of no moment that the land sought to be expropriated in this case is less than the half a hectare only. Through the years, the public use requirement in eminent domain has evolved into a flexible concept, influenced by changing conditions. Public use now includes the broader notion of indirect public benefit or advantage, including a particular, urban land reform and housing. We take judicial notice of the fact that urban land reform has become a paramount task in view of the acute shortage of decent housing in urban areas. Nevertheless, despite the existence of a serious dilemma, local government units are not given an unbridled authority when exercising their power of eminent domain in pursuit of solutions to these problems. The basic rules still have to be followed, which are as follows. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Private property shall not be taken for public use without just compensation. Thus, the exercise by local government units of the power of eminent domain is not without limitations. Where on-site development is found more practicable and advantageous to the beneficiaries, the priorities mentioned in this section shall not apply. The local government units shall give budgetary priority to on-site development of government lands. Very clear from the provisions are the limitations with respect to the order of priority in acquiring private lands and in resorting to expropriation proceedings as means to acquire the same. Private lands rank last in the order of priority for purposes of socialized housing. In the same vein, expropriation proceedings are to be resorted to only when the other modes of acquisition have been exhausted. Compliance with these conditions must be deemed mandatory because these are the only safeguards in securing the right of owners of private property to due process when their property is expropriated for public use. Proceeding from the parameters laid out in the above disquisitions, we now pose the crucial question: did the City of Manila comply with the above-mentioned conditions when it expropriated petitioners' properties? We have carefully scrutinized the records of this case and found nothing that would indicate the respondent City of Manila complied with Sections 9 and Sector 10 of RA 7279. Petitioners' properties were expropriated and ordered condemned in favor of the City of Manila sans any showing that resort to the acquisition of other lands listed under Sector 9 of RA 7279 have proved futile. Evidently, there was a violation of petitioner Philstream's right to due process which must accordingly be rectified. Indeed, it must be emphasized that the state has a paramount interest in exercising its power of eminent domain for the general good, considering that the right of the state to expropriate private property as long as it is for public use always takes precedence over the interest of private property owners. However, we must not lose sight of the fact that the individual rights affected by the exercise of such right are also entitled to protection. Bearing in mind that the exercise of this superior right cannot override the guarantee of due process extended by the law to owners of the property to be expropriated. In this regard, vigilance over compliance with the due process requirements is in order. Hagonoy Market Vendors Association v. Mun of Hagonoy. Facts: on October 1, 1996, the Sangguniang Bayan of Hagonoy, Bulacan, enacted an ordinance, Code Usan BLG 28, which increased the stall rentals of the market vendors in Hagonoy. Article 3 provided that it shall take effect upon approval. The subject ordinance was posted from November 4 to 25, 1996. In the last week of November, 1997, the petitioner's members were personally given copies of the approved ordinance and were informed that it shall be enforced in January 1998. On December 8, 1997, the petitioner's president filed an appeal with the Secretary of Justice assailing the constitutionality of the tax ordinance. Petitioner claimed it was unaware of the posting of the ordinance. Respondent opposed the appeal. It contended that the ordinance took effect on October 6, 1996 and that the ordinance, as approved, was posted as required by law. Hence, it was pointed out that petitioner's appeal, made over a year later, was already time-barred. The Secretary of Justice dismissed the appeal on the ground that it was filed out of time, i.e., beyond 30 days from the effectivity of the ordinance on October 1, 1996, as prescribed under Section 187 of the 1991 Local Government Code. Issue 1. The CA erred in dismissing the appeal. Held yes ratio. We find that the Court of Appeals erred in dismissing petitioner's appeal on the ground that it was formally deficient. It is clear from the records that the petitioner exerted due diligence to get the copies of its appealed resolutions certified by the Department of Justice, but failed to do so on account of Typhoon Laling. Under the circumstances, Respondent Appellate Court should have tempered its strict application of procedural rules in view of the fortuitous event, considering that litigation is not a game of technicalities. Issue 1. The petitioner should be dismissed. Held yes ratio. The petition should be dismissed as the appeal of the petitioner with the Secretary of Justice is already time-barred. The applicable law is Section 187 of the 1991 Local Government Code. The law requires that an appeal of a tax ordinance or revenue measure should be made to the Secretary of Justice within 30 days from effectivity of the ordinance and even during its pendency. The effectivity of the assailed ordinance shall not be suspended. In the case at bar, Municipal Ordinance No. 28 took effect in October 1996. Petitioner filed its appeal only in December 1997, more than a year after the effectivity of the ordinance in 1996. Clearly, the Secretary of Justice correctly dismissed it for being time-barred. At this point, it is apropos to state that the time frame fixed by law for parties to avail of their legal remedies before competent courts is not a mere technicality that can be easily brushed aside. The periods stated in Section 187 of the Local Government Code are mandatory. Ordinance No. 28 is a revenue measure adopted by the municipality of Haguenau to fix and collect public market stall rentals. Being its lifeblood, collection of revenues by the government is of paramount importance. The funds for the operation of its agencies and provision of basic services to its inhabitants are largely derived from its revenues and collections. Thus, it is essential that the validity of revenue measures is not left uncertain for a considerable length of time. Hence, the law provided a time limit for an aggrieved party to assail the legality of revenue measures and tax ordinances. In a last-ditch effort to justify its failure to file a timely appeal with the Secretary of Justice, the petitioner contends that its period to appeal should be counted not from the time the ordinance took effect in 1996 but from the time its members were personally given copies of the approved ordinance in November 1997. It insists that it was unaware of the approval and effectivity of the subject ordinance in 1996 on two grounds. First, no public hearing was conducted prior to the passage of the ordinance and, second, the approved ordinance was not posted. We do not agree. Petitioner's bold assertion that there was no public hearing conducted prior to the passage of Code Usen BLG 28 is belied by its own evidence. In petitioner's two communications with the Secretary of Justice, it enumerated the various objections raised by its members before the passage of the ordinance in several meetings called by the Sanguinian for the purpose. These show beyond doubt that petitioner was aware of the proposed increase and in fact participated in the public hearings therefore. The respondent municipality likewise submitted the minutes and report of the public hearings conducted by the Sangguniang Bayan's Committee on Appropriations and Market on February 6, July 15, and August 19, all in 1996. For the proposed increase in the stall rentals, petitioner cannot gripe that there was practically no public hearing conducted as its objections to the proposed measure were not considered by the Sangguniang Bayan. To be sure, public hearings are conducted by legislative bodies to allow interested parties to ventilate their views on a proposed law or ordinance. These views, however, are not binding on the legislative body and it is not compelled by law to adopt the same. Sanggunian members are elected by the people to make laws that will promote the general interest of their constituents. They are mandated to use their discretion and best judgment in serving the people. Parties who participate in public hearings to give their opinions on a proposed ordinance should not expect that their views would be patronized by their lawmakers. On the issue of publication or posting, the records is bereft of any evidence to prove petitioner's negative allegation that the subject ordinance was not posted as required by law. In contrast, the respondent Sangguniang Bayan of the municipality of Haguenau, Bulacan, presented evidence which clearly shows that the procedure for the enactment of the assailed ordinance was complied with. Municipal Ordinance No. 28 was enacted by the Sangguniang Bayan of Haguenau on October 1, 1996. Then Acting Municipal Mayor Maria Garcia Santos approved the ordinance on October 7, 1996. After its approval, copies of the ordinance were given to the municipal treasurer on the same day. On November 9, 1996, the ordinance was approved by the Sangguniang Panlalawigan. The ordinance was posted during the period From November 4 to 25, 1996 in 3 public places, viz. In front of the municipal building, at the bulletin board of the Sta Anna Parish Church and on the front door of the office of the market master in the public market. Posting was validly made in lieu of publication as there was no newspaper of local circulation in the municipality of Hagonoy. This fact was known to and admitted by petitioner. Thus, petitioner's ambiguous and unsupported claim that it was only sometime in November 1997 that the Provincial Board approved Municipal Ordinance No. 28 and so the posting could not have been made in November 1996 was sufficiently disproved by the positive evidence of respondent municipality. Given the foregoing circumstances, petitioner cannot validly claim lack of knowledge of the approved ordinance. The filing of its appeal a year after the effectivity of the subject ordinance is fatal to its cause. Finally, even on the substantive points raised, the petition must fail. Section 6c. 04 of the 1993 Municipal Revenue Code and Section 191 of the Local Government Code limiting the percentage of increase that can be imposed apply to tax rates, not rentals. Neither can it be said that the rates were not uniformly imposed or that the public markets included in the ordinance were unreasonably determined or classified. To be sure, the ordinance covered the 3 concrete public markets, the 2-story Bagong Palenque, the burnt but reconstructed Lumang Palenque and the more recent Lumang Palenque with wet market. However, the Palenqueng Bagong Municipia or Gabaldon was excluded from the increase in rentals as it is only a makeshift, dilapidated place, with no doors or protection for security. Intended for transient peddlers who used to sell their goods along the sidewalk. Republic of the Philippines v. Court of Appeals. Facts: petitioner instituted expropriation proceedings covering a total of 544,980 square meters of contiguous land situated along MacArthur Highway, Malolos, Bulacan. To be utilized for the continued broadcast operation and use of radio transmitter facilities for the Voice of the Philippines project. Petitioner took over the premises after the previous lessee, the Voice of America, had ceased its operations thereat. Petitioner made a deposit of P517,558.80, the sum provisionally fixed as being the reasonable value of the property. On February 26, 1979, or more than 9 years after the institution of the expropriation proceedings. The trial court issued this order condemning the property and ordering the plaintiff to pay the defendants the just compensation for the property. The bone of contention is the 76,589 square meter property previously owned by Luis Santos, predecessor in interest of respondents, which forms part of the expropriated area. It appears that the national government failed to pay to respondents the compensation pursuant to the foregoing decision, such that a little over 5 years later, or on May 9, 1984, respondents filed a manifestation with a motion seeking payment for the expropriated property. In the meantime, President Estrada issued Proclamation No. 22, transferring 20 hectares of the expropriated property to the Bulacan State University for the expansion of its facilities and another 5 hectares to be used exclusively for the propagation of the Philippine Carabao. The remaining portion was retained by the PIA. This fact notwithstanding, and despite the 1984 court order, the Santos heirs remained unpaid. And no action was taken on their case until September 16, 1999 when petitioner filed its manifestation and motion to permit the deposit in court of the amount of P4,664,000 by way of just compensation for the expropriated property of the late Luis Santos subject to such final computation as might be approved by the court. This time, the Santos heirs, opposing the manifestation and motion, submitted a counter-motion to adjust the compensation from P6.00 per square meter previously fixed in the 1979 decision to its current zonal valuation pegged at P5,000 per square meter or Indiana the alternative, to cause the return to them of the expropriated property. On March 1, 2000, the Bulacan RDC ruled in favor of respondents and issued the assailed order, vacating its decision of February 26, 1979 and declaring it to be unenforceable on the ground of prescription. The CA denied the appeal. The right of eminent domain is usually understood to be an ultimate right of the sovereign power to appropriate any property within its territorial sovereignty for a public purpose. Fundamental to the independent existence of a state, it requires no recognition by the Constitution, whose provisions are taken as being merely confirmatory of its presence and as being regulatory, at most. In the due exercise of the power in the hands of the legislature, the power is inherent, its scope matching that of taxation, even that of police power itself, in many respects. It reaches to every form of property the state needs for public use and, as an old case so puts it, all separate interests of individuals in property are held under a tacit agreement or implied reservation vesting upon the sovereign the right to resume the possession of the property whenever the public interest so requires it. The ubiquitous character of eminent domain is manifest in the nature of the expropriation proceedings. Expropriation proceedings are not adversarial in the conventional sense, for the condemning authority is not required to assert any conflicting interest in the property. Thus, by filing the action, the condemner in effect merely serves notice that it is taking title and possession of the property, and the defendant asserts title or interest in the property, not to prove a right to possession, but to prove a right to compensation for the taking. Obviously, however, the power is not without its limits. First, the taking must be for public use, and second, that just compensation must be given to the private owner of the property. These twin proscriptions have their origin in the recognition of the necessity for achieving balance between the state interests, on the one hand, and private rights, upon the other hand. By effectively restraining the former and affording protection to the latter. In determining public use, two approaches are utilized. The first is public employment or the actual use by the public, and the second is public advantage or benefit. It is also useful to view the matter as being subject to constant growth, which is to say that as society advances, its demands upon the individual so increases, and each demand is a new use to which the resources of the individual may be devoted. The expropriated property has been shown to be for the continued utilization by the PIA, a significant portion thereof being ceded for the expansion of the facilities of the Bulacan State University and for the propagation of the Philippine Carabao, themselves in line with the requirements of public purpose. Respondents question the public nature of the utilization by petitioner of the condemned property, pointing out that its present use differs from the purpose originally contemplated in the 1969 expropriation proceedings. The argument is of no moment. The property has assumed a public character upon its expropriation. Surely, petitioner, as the condemner and as the owner of the property, is well within its rights to alter and decide the use of that property, the only limitation being that it be for public use, which, decidedly, it is. In insisting on the return of the expropriated property, respondents would exhort on the pronouncement in Provincial Government of Sorsogon vs. VDA de Villarroya, where the unpaid landowners were allowed the alternative remedy of recovery of the property there in question. It might be borne in mind that the case involved the municipal government of Sorsogon, to which the power of eminent domain is not inherent, but merely delegated and of limited application. The grant of the power of eminent domain to local governments under RA 7160 cannot be understood as being the pervasive and all-encompassing power vested in the legislative branch of government. For local governments to be able to wield the power, it must, by enabling law, be delegated to it by the national legislature, but even then, this delegated power of eminent domain is not, strictly speaking, a power of eminent, but only of inferior domain, or only as broad or confined as the real authority would want it to be. Thus, in Valdehusa vs. Republic where the private landowners had remained unpaid 10 years after the termination of the expropriation proceedings, this court ruled, the points in dispute are whether such payment can still be made and, if so, in what amount. Said lots have been the subject of expropriation proceedings. By final and executory judgment in said proceedings, they were condemned for public use, as part of an airport, and ordered sold to the government. It follows that both by virtue of the judgment, long final, in the expropriation suit, as well as the annotations upon their title certificates, plaintiffs are not entitled to recover possession of their expropriated lots which are still devoted to the public use for which they were expropriated, but only to demand the fair market value of the same. The judgment rendered by the Bullock and RDC in 1979 on the expropriation proceedings provides not only for the payment of just compensation to herein respondents but likewise adjudges the property condemned in favor of petitioner over which parties, as well as their privies, are bound. Petitioner has occupied, utilized and, for all intents and purposes, exercised dominion over the property pursuant to the judgment. The exercise of such rights vested to it as the condemnee indeed has amounted to at least a partial compliance or satisfaction of the 1979 judgment, thereby preempting any claim of bar by prescription on grounds of non-execution. In arguing for the return of their property on the basis of non-payment, respondents ignore the fact that the right of the expropriatory authority is far from that of an unpaid seller in ordinary sales, to which the remedy of rescission might perhaps apply. An in rem proceeding, condemnation acts upon the property. After condemnation, the paramount title is in the public under a new and independent title, thus, by giving notice to all claimants to a disputed title. Condemnation proceedings provide a judicial process for securing better title against all the world than may be obtained by voluntary conveyance. Respondents, in arguing laches against petitioner, did not take into account that the same argument could likewise apply against them. Respondents first instituted proceedings for payment against petitioner on May 9, 1984, or 5 years after the 1979 judgment had become final. The unusually long delay in bringing the action to compel payment against herein petitioner would militate against them. Consistently with the rule that one should take good care of his own concern, respondents should have commenced the proper action upon the finality of the judgment which, indeed, resulted in a permanent deprivation of their ownership and possession of the property. The constitutional limitation of just compensation is considered to be the sum equivalent to the market value of the property, broadly described to be the price fixed by the seller in open market in the usual and ordinary course of legal action and competition, or the fair value of the property as between one who receives, and one who desires to sell it fixed at the time of the actual taking by the government. Thus, if property is taken for public use before compensation is deposited with the court having jurisdiction over the case, the final compensation must include interests on its just value to be computed from the time the property is taken to the time when compensation is actually paid or deposited with the court. In fine, between the taking of the property and the actual payment, legal interests accrue in order to place the owner in a position as good as the position he was in before the taking occurred. The Bullock and Trial Court, in its 1979 decision, was correct in imposing interests on the zonal value of the property to be computed from the time petitioner instituted condemnation proceedings and took the property in September 1969. This allowance of interest on the amount found to be the value of the property as of the time of the taking computed, being an effective forbearance at 12% per annum, should help eliminate the issue of the constant fluctuation and inflation of the value of the currency over time. Article 1250 of the Civil Code, providing that, in case of extraordinary inflation or deflation, the value of the currency at the time of the establishment of the obligation shall be the basis for the payment when no agreement to the contrary is stipulated, has strict application only to contractual obligations. In other words, a contractual agreement is needed for the effects of extraordinary inflation to be taken into account to alter the value of the currency. All given, the trial court of Bulacan in issuing its order, dated March 1, 2000, vacating its decision of February 26, 1979 has acted beyond its lawful cognizance, the only authority left to it being to order its execution. Verily, private respondents, although not entitled to the return of the expropriated property, deserve to be paid promptly on the yet unpaid award of just compensation already fixed by final judgment of the Bulacan RDC on February 26, 1979 at P6.00 per square meter, with legal interest thereon at 12% per annum computed from the date of taking of the property, i.e., September 19, 1969, until the due amount shall have been fully paid. 8.6 Reclassification of lands. Fordic v. Corona. Facts. Concerns the MR of the Court's resolution dated November 17, 1998 and motion to refer the case to the Court en banc. In previous case, the Court voted 2-2 on the separate motions for reconsideration, as a result of which the decision was affirmed. The Court noted in a resolution dated January 27, 1999 that the movants have no legal personality to seek redress before the Court as their motion to intervene was already denied and that the motion to refer the case to the Court en banc is akin to a second MR which is prohibited. In this motion, both respondents and interveners prayed that the case be referred to the case en banc inasmuch as their earlier MR was resolved by a vote of 2-2, the required number to carry a decision under the Constitution was not met. Issue 1. Failure to meet the 3 votes justifies the referral of the case to the Court en banc. Held no ratio. A careful reading of the constitutional provision reveals the intention of the framers to draw a distinction between cases, on the one hand, and matters, on the other hand, such that cases are decided while matters, which include motions, are resolved. Otherwise put, the word decided must refer to cases, while the word resolved must refer to matters, applying the rule of redendo singula singulis. With this interpretation, it is clear that only cases are referred to the Court en banc for decision whenever the required number of votes is not obtained. Conversely, the rule does not apply where, as in this case, the required 3 votes is not obtained in the resolution of a Mr. Hence. The second sentence of the provision speaks only of case and not matter. The reason is simple. Article 8, Section 4 pertains to the disposition of cases by a division. If there is a tie in the voting, there is no decision. The only way to dispose of the case then is to refer it to the Court en banc. On the other hand, if a case has already been decided by the division and the losing party files a MR, the failure of the division to resolve the motion because of a tie in the voting does not leave the case undecided. There is still the decision which must stand in view of the failure of the members of the division to muster the necessary vote for its reconsideration. Quite plainly, if the voting results in a tie, the motion for reconsideration is lost. The assailed decision is not reconsidered and must therefore be deemed affirmed. Such was the ruling of this Court in the resolution of November 17, 1998. Issue 1. The referral to the Court en banc is justified on the ground that the issues are of first impression. Held no ratio. The issues presented before us by the movants are matters of no extraordinary import to merit the attention of the Court en banc. The issue of whether or not the power of the local government units to reclassify lands is subject to the approval of the DAR is no longer novel, this having been decided by this Court in the case of Province of Cameron Sur, ETLVS. Court of Appeals, wherein we held that local government units need not obtain the approval of the DAR to convert or reclassify lands from agricultural to non-agricultural use. Moreover, the decision sought to be reconsidered was arrived at by a unanimous vote of all 5 members of the Second Division of this Court. Stated otherwise, This second division is of the opinion that the matters raised by movants are nothing new and do not deserve the consideration of the court en banc. Thus, the participation of the full court in the resolution of movants' motions for reconsideration would be inappropriate. Issue 1. The referral to the court en banc partakes of the nature of a second MR. Held yes ratio, the contention, therefore, that our resolution of November 17, 1998 did not dispose of the earlier MR of the decision dated April 24, 1998 is flawed. Consequently, the present MR necessarily partakes of the nature of a second motion for reconsideration which, according to the clear and unambiguous language of Rule 56, Section 4, in relation to Rule 52, Section 2, of the 1997 Rules of Civil Procedure, is prohibited. True, there are exceptional cases when this court may entertain a second motion for reconsideration, such as where there are extraordinarily persuasive reasons. Even then, we have ruled that such second MRs must be filed with express leave of court first obtained. In this case, not only did movants fail to ask for prior leave of court, but more importantly, they have been unable to show that there are exceptional reasons for us to give due course to their second motions for reconsideration. Stripped of the arguments for referral of this incident to the court en banc, the motions subject of this resolution are nothing more but rehashes of the motions for reconsideration which have been denied in the resolution of November 17, 1998. To be sure, the allegations contained therein have already been raised before and passed upon by this court in the said resolution. Issue 1. The win-win resolution was valid held no ratio. This refers to the resolution by authority of the President modifying the decision dated March 29, 1996 of the OP through Executive Secretary Ruben Torres. NQSRMDC's application for conversion is approved only with respect to 44 hectares as recommended by the DA. The remaining 100 hectares found to be suitable for agriculture shall be distributed to qualified farmer beneficiaries in accordance with RA 6657. The resolution is void and of no legal effect considering that the March 29, 1996 decision of the Office of the President had already become final and executory even prior to the filing of the MR which became the basis of the said win-win resolution. While it may be true that on its face the nullification of the win-win resolution was grounded on a procedural rule pertaining to the reglementary period to appeal or move for reconsideration, the underlying consideration therefore was the protection of the substantive rights of petitioners. Just as a losing party has the right to file an appeal within the prescribed period, the winning party also has the correlative right to enjoy the finality of the resolution of his/her case. In other words, the finality of the March 29, 1996 OP decision accordingly vested a pertinent rights to the land in dispute on petitioners as well as on the people of Bukidnon and other parts of the country who stand to be benefited by the development of the property. Before finally disposing of these pending matters, we feel it necessary to rule once and for all on the legal standing of interveners in this case. In their present motions, interveners insist that they are real parties in interest inasmuch as they have already been issued certificates of land ownership award, or CLOAs. And that while they are seasonal farm workers at the plantation, they have been identified by the DAR as qualified beneficiaries of the property. These arguments are, however, nothing new as in fact they have already been raised in interveners' earlier motion for reconsideration of our April 24, 1998 decision. Again as expressed in the opinion of Mr. Justice Martinez, interveners, who are admittedly not regular but seasonal farm workers, have no legal or actual and substantive interest over the subject land inasmuch as they have no right to own the land. Rather, their right is limited only to a just share of the fruits of the land. Moreover, the win-win resolution itself states that the qualified beneficiaries have yet to be carefully and meticulously determined by the Department of Agrarian Reform. Absent any definitive finding of the DAR, interveners cannot as yet be deemed vested with sufficient interest in the controversy as to be qualified to intervene in this case. Likewise, the issuance of the CLOAs to them does not grant them the requisite standing in view of the nullity of the win-win resolution. No legal rights can emanate from a resolution that is null and void. Mello by mandate of the Constitution, cases heard by a division when the required majority of at least 3 votes in the division is not obtained are to be heard and decided by the court en banc. The deliberations of the 1986 Constitutional Commission disclose that if the case is not decided in a division by a majority vote, it goes to the court en banc and not to a larger division. In a situation where a division of 5 has only 4 members, the 5th member having inhibited himself or is otherwise not in a position to participate, or has retired, a minimum of 3 votes would still be required before there can be any valid decision or resolution by that division. There may, then, be instances when a deadlock may occur, i.e., the votes tied at 2-2. It is my humble view that under the clear and unequivocal provisions of the 1986 Constitution, if the required majority is not reached in a division, the case should automatically go to court en banc. I submit that the requirement of 3 votes equally applies to motions for reconsideration because the provision contemplates cases or matters heard by a division. And a motion for reconsideration cannot be divorced from the decision in a case that it seeks to be reconsidered. Consequently, if the required minimum majority of 3 votes is not met, the matter of the motion for reconsideration has to be heard by the court en banc, as mandated by the Constitution. To say that the motion is lost in the division on a 2-2 vote, is to construe something which cannot be sustained by a reading of the Constitution. To argue that a motion for reconsideration is not a case but only a matter which does not concern a case, so that, even though the vote thereon in the division is 2-2, the matter or issue is not required to elevated to the court en banc, is to engage in a lot of unfounded hair-splitting. Roxas N. Co., Inc. v. Court of Appeals. Facts: this case involves 3 haciendas in Nasugbu, Batangas owned by petitioner and the validity of the acquisition of these haciendas by the government under RA 6657. Petitioner is a domestic corporation and is the registered owner of 3 haciendas, namely, Haciendas Palico, Banalad and Calaway, all located in the municipality of Nasugbu, Batangas. President Aquino signed in on July 1987, Proclamation 131 instituting a CARP and EO 229 providing the mechanism to implement the program. Pursuant to this, Congress passed RA 6657, the CARL. Before the effectivity of the law, petitioner filed with DAR a voluntary offer to sell Hacienda Calaway pursuant to the provisions of EO 229. Haciendas Palico and Banalad were later placed under compulsory acquisition by DAR in accordance with the CARL. Hacienda Palico. DAR, through Municipal Agrarian Reform Officer of Nasugbu, Batangas, sent a notice entitled Invitation to Parties to Petitioner to discuss the results of the DAR investigation of Hacienda Palico, which was scheduled for compulsory acquisition this year under the CARP. Summary investigation reports were submitted by the MARO, representatives of the Barangay Agrarian Reform Committee, Land Bank, and the Provincial Agrarian Reform Officer recommending that 270 Ha and 75 3 ha of the property be placed under compulsory acquisition at a compensation of P8,109,739.00 and P2,188,195.47, respectively. DAR through Secretary Miriam Santiago sent a notice of acquisition to petitioner. Petitioner was informed that 1,023.999 ha of its land in Hacienda Palico were subject to immediate acquisition and distribution by the government under the CARL, and the government was offering compensation of P3.4 million for 333,0800 hectares. Almost 2 years later, the DAR regional director sent to the LBP land valuation manager 3 separate memoranda entitled Request to Open Trust Account. Each memoranda requested that a trust account representing the valuation of 3 portions of Hacienda Palico be opened in favor of the petitioner in view of the latter's rejection of its offered value. Meanwhile, petitioner applied with the DAR for conversion of Haciendas Palico and Banalad from agricultural to non-agricultural lands under the provisions of the CARL. Despite petitioner's application for conversion, DAR proceeded with the acquisition of the 2 haciendas. The LBP trust accounts as compensation for Hacienda Palico were replaced by respondent DAR with cash and LBP bonds. On October 22, 1993, from the mother title of TCT number 985 of the Hacienda, DAR registered Certificate of Land Ownership Award number 6654. On October 30, 1993, CLOAs were distributed to farmer beneficiaries. Hacienda Banalad. DAR through the Maro of Nasugbu Batangas sent a notice of acquisition to petitioner. Later, the Maro sent an invitation to parties again to Pimentel inviting the latter to attend a conference to discuss the results of the Maro's investigation over Hacienda Banalad. The reports were discussed. The conference. Present in the conference were representatives of the prospective farmer beneficiaries, the BARC, the LBP and Jamie Pimentel on behalf of the landowner. After the meeting, it was recommended that 737.2590 ha under tax declaration NOS 0236 and 0237 be likewise placed under compulsory acquisition for distribution. DAR, through the Department Secretary, sent to petitioner 2 separate notices of acquisition over Hacienda Banalad. These notices were sent on the same day as the notice of acquisition over Hacienda Palico. Unlike the notice over Hacienda Palico, however, the notices over Hacienda Banalad were addressed to Roxas YCIA Limited in Makati. The DAR regional director sent to the LBP land valuation manager a request to open trust account in petitioner's name as compensation for 234.6493 hectares of Hacienda Banalad. A second request to open trust account was sent on November 18, 1991 over 723.4130 hectares of said hacienda. On May 4, 1993, petitioner applied for conversion of both Haciendas Palico and Banalad. Hacienda Kalawa. Hacienda Kalawa was voluntarily offered for sale to the government on May 6, 1988 before the effectivity of the CARL. DAR, through the Regional Director for Region 4, sent to petitioner 2 separate resolutions accepting petitioner's voluntary offer to sell Hacienda Kalawa, particularly TCT NOS T44664 and T44663. Nevertheless, on August 6, 1992, petitioner, through its president, Eduardo J. Roxas, sent a letter to the Secretary of DAR withdrawing its VOS of Hacienda Kalawa. The Sangguniang Bayan of Nasugbu, Batangas allegedly authorized the reclassification of Hacienda Kalawa from agricultural to non-agricultural. As a result, petitioner informed DAR that it was applying for conversion of Hacienda Kalawa from agricultural to other uses. DAR Secretary informed petitioner that a reclassification of the land would not exempt it from agrarian reform. The Secretary also denied petitioners' withdrawal of the VAS on the ground that withdrawal could only be based on specific grounds such as unsuitability of the soil for agriculture, or if the slope of the land is over 18 degrees and that the land is undeveloped. Despite the denial of the VAS withdrawal of Hacienda Calaway, on May 11, 1993, petitioner filed its application for conversion of both haciendas Palico and Banalad. On August 24, 1993, petitioner instituted case No. N001796-46 with the Darab praying for the cancellation of the CLOAs issued by DAR in the name of several persons. Petitioner alleged that the municipality of Nasugbu, where the haciendas are located, had been declared a tourist zone, that the land is not suitable for agricultural production, and that the Sangguniang Bayan of Nasugbu had reclassified the land to non-agricultural. Darab submitted the case to the Office of the Secretary of Agrarian Reform for determination. The CA filed a petition before the CA questioning the expropriation of its properties under the CARL. Meanwhile, the petition for conversion of the 3 haciendas was denied by the Maro. The CA then dismissed the petition. Issue 1. The court can take cognizance of this petition despite petitioner's failure to exhaust administrative remedies held yes. Ratio, petitioner rightly sought immediate redress in the courts. There was a violation of its rights, and to require it to exhaust administrative remedies before the DAR itself was not a plain, speedy, and adequate remedy. DAR issued CLOAs to farmer beneficiaries over portions of petitioner's land without just compensation to petitioner. A CLOA is evidence of ownership of land by a beneficiary under RA 6657. Before this may be awarded to a farmer beneficiary, the land must first be acquired by the state from the landowner and ownership transferred to the former. The transfer of possession and ownership of the land to the government are conditioned upon the receipt by the landowner of the payment or deposit by the DAR of the compensation with an accessible bank. Until then, title remains with the landowner. There was no receipt by petitioner of any compensation for any of the lands acquired by the government. The kind of compensation to be paid the landowner is also specific. The law provides that the deposit must be made only in cash or LBP bonds. DAR's opening of trust account deposits in petitioner's name with the land bank does not constitute payment under the law. Trust account deposits are not cash or LBP bonds. The replacement of the trust account with cash or LBP bonds did not ipso facto cure the lack of compensation, for essentially, the determination of this compensation was marred by lack of due process. In fact, in the entire acquisition proceedings, respondent DAR disregarded the basic requirements of administrative due process. Under these circumstances, the issuance of the CLOAs to farmer beneficiaries necessitated immediate judicial action on the part of the petitioner. Issue 1. The acquisition proceedings over the 3 haciendas were valid and in accordance with law. Held no ratio, mode of acquisition of land under RA 6657. 2 modes of acquisition of private land, compulsory and voluntary. In the compulsory acquisition of private lands, the land holding, the landowners, and the farmer beneficiaries must first be identified. After identification, the DAR shall send a notice of acquisition to the landowner, by personal delivery or registered mail, and post it in a conspicuous place in the municipal building and barangay hall of the place where the property is located. Within 30 days from receipt of the notice of acquisition, the landowner, his administrator, or representative shall inform the DAR of his acceptance or rejection of the offer. If the landowner accepts, he executes and delivers a deed of transfer in favor of the government and surrenders the certificate of title. Within 30 days from the execution of the deed of transfer, the LBP pays the owner the purchase price. If the landowner rejects the DAR's offer or fails to make a reply, the DAR conducts summary administrative proceedings to determine just compensation for the land. The landowner, the LBP representative and other interested parties may submit evidence on just compensation within 15 days from notice. Within 30 days from submission, the DAR shall decide the case and inform the owner of its decision and the amount of just compensation. Upon receipt by the owner of the corresponding payment, or, in case of rejection or lack of response from the latter, the DAR shall deposit the compensation in cash or in LBP bonds with an accessible bank. The DAR shall immediately take possession of the land and cause the issuance of a transfer certificate of title in the name of the Republic of the Philippines. The land shall then be redistributed to the farmer beneficiaries. Any party may question the decision of the DAR in the regular courts for final determination of just compensation. For a valid implementation of the CAR program, 2 notices are required: the notice of coverage and letter of invitation to a preliminary conference sent to the landowner, the representatives of the BARC, LBP, farmer beneficiaries and other interested parties pursuant to DARA. O number 12, series of 1989, and the notice of acquisition sent to the landowner under Section 16 of the CARL. The importance of the first notice, i.e., the notice of coverage and the letter of invitation to the conference, and its actual conduct cannot be understated. They are steps designed to comply with the requirements of administrative due process. The implementation of the CARL is an exercise of the state's police power and the power of eminent domain. To the extent that the CARL prescribes retention limits to the landowners, there is an exercise of police power for the regulation of private property in accordance with the Constitution. But where, to carry out such regulation, the owners are deprived of lands they own in excess of the maximum area allowed, there is also a taking under the power of eminent domain. The taking contemplated is not a mere limitation of the use of the land. What is required is the surrender of the title to and physical possession of the said excess and all beneficial rights accruing to the owner in favor of the farmer beneficiary. The Bill of Rights provides that no person shall be deprived of life, liberty, or property without due process of law. The CARL was not intended to take away property without due process of law. The exercise of the power of eminent domain requires that due process be observed in the taking of private property. The notice requirements under the CARL are not confined to the notice of acquisition set forth in Section 16 of the law. They also include the notice of coverage first laid down in DARAO number 12, series of 1989 and subsequently amended in DARAO number 9, series of 1990 and DARAO number 1, series of 1993. This notice of coverage does not merely notify the landowner that his property shall be placed under CARP and that he is entitled to exercise his retention right, it also notifies him, pursuant to DARAO number 9, series of 1990, that a public hearing shall be conducted where he and representatives of the concerned sectors of society may attend to discuss the results of the field investigation, the land valuation and other pertinent matters. Under DARAO Number 1, series of 1993, the notice of coverage also informs the landowner that a field investigation of his land holding shall be conducted where he and the other representatives may be present. Compulsory acquisition of Hacienda Palico and Banalad. In the case at bar, DAR claims that it, through Maro Leopoldo C. Lejano, sent a letter of invitation entitled Invitation to Parties dated September 29, 1989 to petitioner, through Jamie Pimentel, the administrator of Hacienda Palico. The invitation was received on the same day it was sent as indicated by a signature and the date received at the bottom left corner of said invitation. With regard to Hacienda Banalad, DAR claims that Pimentel, administrator also of Hacienda Banalad, was notified and sent an invitation to the conference. Pimentel actually attended the conference on September 21, 1989 and signed the minutes of the meeting on behalf of petitioner. The minutes was also signed by the representatives of the BARC, the LBP, and farmer beneficiaries. No letter of invitation was sent or conference meeting held with respect to Hacienda Calaway because it was subject to a voluntary offer to sell to DAR. When DAR, through the Maro, sent to the various parties the notice of coverage and invitation to the conference, DARAO number 12, series of 1989 was already in effect more than a month earlier. The operating procedure in DAR Administrative Order number 12 does not specify how notices or letters of invitation shall be sent to the landowner, the representatives of the BARC, the LBP, the farmer beneficiaries and other interested parties. The procedure in the sending of these notices is important to comply with the requisites of due process, especially when the owner, as in this case, is a juridical entity. Petitioner is a domestic corporation, and therefore, has a personality separate and distinct from its shareholders, officers, and employees. Jamie Pimentel is not the president, manager, secretary, cashier, or director of Petitioner Corporation. Is he, as administrator of the two haciendas, considered an agent of the corporation? The purpose of all rules for service of process on a corporation is to make it reasonably certain that the corporation will receive prompt and proper notice in an action against it. Service must be made on a representative so integrated with the corporation as to make it a priori supposable that he will realize his responsibilities and know what he should do with any legal papers served on him, and bring home to the corporation notice of the filing of the action. Petitioner's evidence does not show the official duties of Pimentel as administrator of petitioner's haciendas. The evidence does not indicate whether Pimentel's duties is so integrated with the corporation that he would immediately realize his responsibilities and know what he should do with any legal papers served on him. At the time the notices were sent and the preliminary conference conducted, petitioner's principal place of business was listed in DAR's records as Soriano Building, Plaza Cervantes, Manila, and 7th FLR Cacho Gonzalez Building, 101, Aguirre St. Makati, Metro Manila. Pimentel did not hold office at the principal place of business of petitioner. Neither did he exercise his functions in Plaza Cervantes, Manila, nor in Cacho Gonzalez Building, Makati, Metro Manila. He performed his official functions and actually resided in the haciendas in Nasugbu, Batangas, a place over 200 kilometers away from Metro Manila. Curiously, DAR had information of the address of petitioner's principal place of business. The notices of acquisition over haciendas Palico and Banalad were addressed to petitioner at its offices in Manila and Makati. These notices were sent barely 3 to 4 months after Pimentel was notified of the preliminary conference. Why DAR chose to notify Pimentel instead of the officers of the corporation was not explained by the said respondent. Nevertheless, assuming that Pimentel was an agent of Petitioner Corporation, and the notices and letters of invitation were validly served on petitioner through him, there is no showing that Pimentel himself was duly authorized to attend the conference meeting with the MARO, BARC, and LBP representatives and farmer beneficiaries for purposes of compulsory acquisition of petitioner's land holdings. Even DAR's evidence does not indicate this authority. On the contrary, petitioner claims that it had no knowledge of the letter invitation, hence could not have given Pimentel the authority to bind it to whatever matters were discussed or agreed upon by the parties at the preliminary conference or public hearing. Notably, 1 year after Pimentel was informed of the preliminary conference, DARAO No. 9, series of 1990 was issued, and this required that the notice of coverage must be sent to the landowner concerned or his duly authorized representative. Assuming further that petitioner was duly notified of the CARP coverage of its haciendas, the areas found actually subject to CARP were not properly identified before they were taken over by DAR. The acquisition of the land holdings did not cover the entire expanse of the two haciendas, but only portions thereof. Hacienda Palico has an area of 1,024 hectares and only 688.7576 hectares were targeted for acquisition. Hacienda Banalad has an area of 1,050 hectares but only 964.0688 hectares were subject to CARP. The haciendas are not entirely agricultural lands. In fact, the various tax declarations over the haciendas describe the land holdings as sugarland, and forest, sugarland, pasture land, horticulture, and woodland. Upon receipt of this notice, therefore, Petitioner Corporation had no idea which portions of its estate were subject to compulsory acquisition, which portions it could rightfully retain, whether these retained portions were compact or contiguous, and which portions were excluded from CARP coverage. Even Respondent DAR's evidence does not show that petitioner, through its duly authorized representative, was notified of any ocular inspection and investigation that was to be conducted by Respondent DAR. Neither is there proof that petitioner was given the opportunity to at least choose and identify its retention area in those portions to be acquired compulsorily. The right of retention and how this right is exercised, is guaranteed in Section 6 of the Carl Voluntary Acquisition of Hacienda Callaway. First of all, the same EO 229, like Section 16 of the Carl, requires that the landowner, and beneficiaries of the land subject to agrarian reform be identified before the notice of acquisition should be issued. Hacienda Callaway was voluntarily offered for sale in 1989. The hacienda has a total area of 867.4571 hectares and is covered by 4 titles. In 2 separate resolutions both dated January 12, 1989, DAR, through the regional director, formally accepted the VOS over 2 of these 4 titles. The land covered by the 2 titles has an area of 855.5257 hectares, but only 8,544 hectares thereof fell within the coverage of RA. 6,657. Petitioner claims it does not know where these portions are located. DAR, on the other hand, avers that surveys on the land covered by the 4 titles were conducted in 1989, and that petitioner, as landowner, was not denied participation therein. The results of the survey and the land valuation summary report, however, do not indicate whether notices to attend the same were actually sent to and received by petitioner or its duly authorized representative. To reiterate, EO 229 does not lay down the operating procedure, much less the notice requirements, before the VOS is accepted by DAR. Notice to the landowner, however, cannot be dispensed with. It is part of administrative due process and is an essential requisite to enable the landowner himself to exercise, at the very least, his right of retention guaranteed under the Carl. Issue: assuming the haciendas may be reclassified from agricultural to non-agricultural, 1. This court has the power to rule on this issue. Held no ratio, it is petitioner's claim that the 3 haciendas are not subject to agrarian reform because they have been declared for tourism, not agricultural purposes. In 1975, then-President Marcos issued Proclamation No. 1520 declaring the municipality of Nasugbu, Batangas a tourist zone. Lands in Nasugbu, including the subject haciendas, were allegedly reclassified as non-agricultural 13 years before the effectivity of RA 6657. In 1993, the regional director for Region 4 of the DA certified that the haciendas are not feasible and sound for agricultural development. On March 20, 1992, pursuant to Proclamation No. 1520, the Sangguniang Bayan of Nasugbu, Batangas adopted Resolution No. 19 reclassifying certain areas of Nasugbu as non-agricultural. This resolution approved Municipal Ordinance No. 19, Series of 1992, the revised zoning ordinance of Nasugbu, which zoning ordinance was based on a land use plan for planning areas for new development allegedly prepared by the University of the Philippines. Resolution No. 19 of the Sangguniang Bayan was approved by the Sangguniang Panlalawigan of Batangas on March 8, 1993. Petitioner claims that Proclamation No. 1520 was also upheld by DAR in 1991 when it approved conversion of 1827. hectares in Nasugbu into a tourist area known as the Bacalao Resort Complex, and 13.52 hectares in Barangay Calaway as within the potential tourist belt. Petitioner presents evidence before us that these areas are adjacent to the haciendas subject of this petition, hence, the haciendas should likewise be converted. Petitioner urges this court to take cognizance of the conversion proceedings and rule accordingly. We do not agree. DAR's failure to observe due process in the acquisition of petitioner's land holdings does not ipso facto give this court the power to adjudicate over petitioner's application for conversion of its haciendas from agricultural to non-agricultural. The agency charged with the mandate of approving or disapproving applications for conversion is the DAR. At the time petitioner filed its application for conversion, the rules of procedure governing the processing and approval of applications for land use conversion was the DARAO No. 2, series of 1990. Under this AO, the application for conversion is filed with the MARO where the property is located. The MARO reviews the application and its supporting documents and conducts field investigation and ocular inspection of the property. The findings of the MARO are subject to review and evaluation by the Provincial Agrarian Reform Officer. The PARO may conduct further field investigation and submit a supplemental report together with his recommendation to the Regional Agrarian Reform Officer who shall review the same. For lands less than 5 hectares, the RARO shall approve or disapprove applications for conversion. For lands exceeding 5 hectares, the RARO shall evaluate the PARO report and forward the records in his report to the Undersecretary for Legal Affairs. Applications over areas exceeding 50 hectares are approved or disapproved by the Secretary of Agrarian Reform. Indeed, the doctrine of primary jurisdiction does not warrant a court to arrogate unto itself authority to resolve a controversy the jurisdiction over which is initially lodged with an administrative body of special competence. DAR is in a better position to resolve petitioner's application for conversion, being primarily the agency possessing the necessary expertise on the matter. The power to determine whether haciendas Palico, Banalad, and Calaway are non-agricultural, hence, exempt from the coverage of the CARL lies with the DAR, not with this court. Finally, we stress that the failure of DAR to comply with the requisites of due process in the acquisition proceedings does not give this court the power to nullify the CLOAs already issued to the farmer beneficiaries. To assume the power is to short-circuit the administrative process, which has yet to run its regular course. DAR must be given the chance to correct its procedural lapses in the acquisition proceedings. In Hacienda Palico alone, CLOAs were issued to 177 farmer beneficiaries in 1993. Since then until the present, these farmers have been cultivating their lands. It goes against the basic precepts of justice, fairness, and equity to deprive these people, through no fault of their own, of the land they till. Anyhow, the farmer beneficiaries hold the property in trust for the rightful owner of the land. 8.7 Closure and opening of roads. Cabrera v. CA. Facts: the Provincial Board of Catanduanes adopted Resolution No. 158. Pursuant thereto, deeds of exchange were executed under which the province conveyed to Remedios R. Bagadiang, Ferdeswindu F. Alcala, Elena S. Latour, Baldomero Tolentino, Eulogia T. Alejandro, Angeles S. Vargas, and Juan S. Reyes portions of the closed road in exchange for their own respective properties, on which was subsequently laid a new concrete road leading to the Capitol building. Learning about Resolution 158, the petitioner filed a complaint with the CFI of Catanduanes for restoration of public road and/or abatement of nuisance, annulment of resolutions and documents with damages. He alleged that the land fronting his house was a public road owned by the province in its governmental capacity and therefore beyond the commerce of man. He contended that Resolution No. 158 and the deeds of exchange were invalid, as so too was the closure of the road. The judge sustained the authority of the provincial board to enact said resolution. The CA affirmed and found that the road was not a public road but just a trail. Also, pursuant to RA 5185, municipal authorities, subject to the approval of the Provincial Board, can close thoroughfares pursuant to Sector 2246 of the Revised Administrative Code. Petitioner insists that Sections 2246 is not applicable because Resolution number 158 is not an order for the closure of the road in question but an authority to barter or exchange it with private properties. He maintains that the public road was owned by the province in its governmental capacity and, without a prior order of closure, could not be the subject of a barter. Control over public roads, he insists, is with Congress and not with the Provincial Board. Issue 1. The Provincial Board can validly enact said resolution. Held yes ratio. Resolution 158 clearly says that it is hereby resolved to close the old road. The closure is as plain as day except that the petitioner, with the blindness of those who will not see, refuses to acknowledge it. The court has little patience with such puerile arguments. They border dangerously on a trifling with the administration of justice and can only prejudice the pleader's cause. The authority of the Provincial Board to close that road and use or convey it for other purposes is derived from the following provisions of Republic Act No. 5185 in relation to Section 2246 of the Revised Administrative Code. It sustained the subsequent sale of the land as being in accordance not only with the Charter but also with Article 422 of the Civil Code, which provides property of public dominion, when no longer intended for public use or for public service, shall form part of the patrimonial property of the state. In the case of Favis v. City of Baguio, the power of the City Council of Baguio City to close city streets and withdraw them from public use was also assailed. This court said 5. So it is, that appellant may not challenge the City Council's act of withdrawing a strip of Lapu-Lapu Street at its dead end from public use and converting the remainder thereof into an alley. These are acts well within the ambit of the power to close a city street. The City Council, it would seem to us, is the authority competent to determine whether or not a certain property is still necessary for public use. Such power to vacate a street or alley is discretionary. And the discretion will not ordinarily be controlled or interfered with by the courts, absent a plain case of abuse or fraud or collusion. Faithfulness to the public trust will be presumed. So the fact that some private interests may be served incidentally will not invalidate the vacation ordinance. While it is true that the cases dealt with city councils and not the Provincial Board, there is no reason for not applying the doctrine announced therein to the Provincial Board in connection with the closure of provincial roads. The Provincial Board has, after all, the duty of maintaining such roads for the comfort and convenience of the inhabitants of the province. Moreover, this authority is inferable from the grant by the national legislature of the funds to the province for the construction of provincial roads. The lower court found the petitioner's allegation of injury and prejudice to be without basis because he had easy access anyway to the national road. For in fact the vehicles used by the court and the parties during the ocular inspection easily passed and used it, reaching beyond plaintiff's house. However, the CA ruled that he was prejudiced by the closure of the road which formerly fronted his house. He and his family were undoubtedly inconvenienced by the loss of access to their place of residence for which we believe they should be compensated. On this issue, the governing principle was laid down in Favis thus. The general rule is that one whose property does not abut on the closed section of a street has no right to compensation for the closing or vacation of the street, if he still has reasonable access to the general system of streets. The circumstances in some cases may be such as to give a right to damages to a property owner, even though his property does not abut on the closed section. But to warrant recovery in any such case the property owner must show that the situation is such that he has sustained special damages differing in kind, and not merely in degree, from those sustained by the public generally. Petitioner is not entitled to damages because the injury he has incurred, such as it is the price he and others like him must pay for the welfare of the entire community. This is not a case where his property has been expropriated and he is entitled to just compensation. The construction of the new road was undertaken under the General Welfare Clause. As the trial judge acutely observed, whatever inconvenience the petitioner has suffered pales in significance compared to the greater convenience the new road, which is wide and concrete, straight to the Veterans Fountain and down to the pier, has been giving to the public, plus the fact that the new road adds beauty and color not only to the town of Viereck but also to the whole province of Caden-Duanes. For the enjoyment of those benefits, every individual in the province, including the petitioner, must be prepared to give his share. MMDA v Bel Air Village Association Inc. Facts: MMDA is a government agency tasked with the delivery of basic services in Metro Manila. Bel Air Village Association, Inc. is a non-stock, non-profit corporation whose members are homeowners in Bel Air Village, a private subdivision in Makati City. BAVA is the registered owner of Neptune Street, a road inside Bel Air Village. On December 30, 1995, respondent received from petitioner, through its chairman, a notice dated December 22, 1995 requesting respondent to open Neptune Street to public vehicular traffic starting January 2, 1996. BAVA was apprised that the perimeter wall separating the subdivision from the adjacent Calayan Avenue would be demolished. On January 2, 1996, BAVA instituted against petitioner before the RTC a civil case for injunction. Respondent prayed for the issuance of a TRO and preliminary injunction enjoining the opening of Neptune Street and prohibiting the demolition of the perimeter wall. The trial court issued a temporary restraining order the following day. After due hearing, the trial court denied the issuance of preliminary injunction. On appeal, the CA rendered a decision on the merits of the case finding that the MMDA has no authority to order the opening of Neptune Street, a private subdivision road, and cause the demolition of its perimeter walls. It held that the authority is lodged in the City Council of Makati by ordinance. Issue 1. The MMDA has authority to open Neptune Road to the public. Held no ratio, MMDA claims that it has the authority to open Neptune Street to public traffic because it is an agent of the state endowed with police power in the delivery of basic services in Metro Manila. One of these basic services is traffic management, which involves the regulation of the use of thoroughfares to ensure the safety, convenience, and welfare of the general public. It is alleged that the police power of MMDA was affirmed by this court in the consolidated cases of Sangalang v. IAC. From the premise that it has police power, it is now urged that there is no need for the city of Makati to enact an ordinance opening Neptune Street to the public. Police power is an inherent attribute of sovereignty. It has been defined as the power vested by the Constitution in the legislature to make, ordain, and establish all manner of wholesome and reasonable laws, statutes and ordinances, either with penalties or without. Not repugnant to the Constitution, as they shall judge to be for the good and welfare of the Commonwealth, and for the subjects of the same. The power is plenary and its scope is vast and pervasive, reaching and justifying measures for public health, public safety, public morals, and the general welfare. It bears stressing that police power is lodged primarily in the national legislature. It cannot be exercised by any group or body of individuals not possessing legislative power. The national legislature, however, may delegate this power to the President and administrative boards as well as the lawmaking bodies of municipal corporations or local government units. Once delegated, the agents can exercise only such legislative powers as are conferred on them by the national lawmaking body. Metropolitan or Metro Manila is a body composed of several local government units, i.e. 12 cities and 5 municipalities, namely, the cities of Caloocan, Manila, Mandaluyong, Makati, Pasay, Pasig, Quezon, Muntinlupa, Las Piñas, Marikina, Paranaque, and Valenzuela, and the municipalities of Malabon, Navotas. Pateros, San Juan, and Taguig. With the passage of RA 7924 in 1995, Metropolitan Manila was declared as a Special Development and Administrative Region, and the administration of metro-wide basic services affecting the region placed under a development authority referred to as the MMDA. The implementation of the MMDA's plans, programs, and projects is undertaken by the local government units, national government agencies, accredited people's organizations, non-governmental organizations, and the private sector, as well as by the MMDA itself. For this purpose, the MMDA has the power to enter into contracts, memoranda of agreement and other cooperative arrangements with these bodies for the delivery of the required services within Metro Manila. Clearly, the scope of the MMDA's function is limited to the delivery of the 7 basic services. One of these is transport and traffic management, which includes the formulation and monitoring of policies, standards, and projects to rationalize the existing transport operations, infrastructure requirements, the use of thoroughfares, and promotion of the safe movement of persons and goods. It also covers the mass transport system and the institution of a system of road regulation, the administration of all traffic enforcement operations, traffic engineering services, and traffic education programs, including the institution of a single ticketing system in Metro Manila for traffic violations. Under this service, the MMDA is expressly authorized to set the policies concerning traffic and coordinate and regulate the implementation of all traffic management programs. In addition, the MMDA may install and administer a single ticketing system, fix, impose and collect fines and penalties for all traffic violations. It will be noted that the powers of the MMDA are limited to the following acts: formulation, coordination, regulation, implementation, preparation, management, monitoring, setting of policies, installation of a system and administration. There is no syllable in RA number 7924 that grants the MMDA police power, let alone legislative power. Even the Metro Manila Council has not been delegated any legislative power. Unlike the legislative bodies of the local government units, there is no provision in RA number 7924 that empowers the MMDA or its council to enact ordinances, approve resolutions, and appropriate funds for the general welfare of the inhabitants of Metro Manila. The MMDA is, as termed in the charter itself, a development authority. It is an agency created for the purpose of laying down policies and coordinating with the various national government agencies, people's organizations, non-governmental organizations and the private sector for the efficient and expeditious delivery of basic services in the vast metropolitan area. All its functions are administrative in nature, and these are actually summed up in the charter itself. Petitioner cannot seek refuge in the cases of Sangalang v. Intermediate Appellate Court, where we upheld a zoning ordinance issued by the Metro Manila Commission, the predecessor of the MMDA, as an exercise of police power. The first Sangalang decision was on the merits of the petition, while the second decision denied reconsideration of the first case and in addition discussed the case of Yabat v. Court of Appeals. Contrary to petitioner's claim, the two Sangalang cases do not apply to the case at bar. Firstly, both involved zoning ordinances passed by the Municipal Council of Makati and the MMC. In the instant case, the basis for the proposed opening of Neptune Street is contained in the notice of December 22, 1995 sent by petitioner to respondent Bava, through its president. The notice does not cite any ordinance or law, either by the Sangguniang Panlungsod of Makati City or by the MMDA, as the legal basis for the proposed opening of Neptune Street. Petitioner MMDA simply relied on its authority under its charter to rationalize the use of roads and/or thoroughfares for the safe and convenient movement of persons. Rationalizing the use of roads and thoroughfares is one of the acts that fall within the scope of transport and traffic management. By no stretch of the imagination, however, can this be interpreted as an express or implied grant of ordinance-making power, much less police power. Ms. Juris. Secondly, the MMDA is not the same entity as the MMC in Sangalang. Although the MMC is the forerunner of the present MMDA, an examination of Presidential Decree No. 824, the Charter of the MMC, shows that the latter possessed greater powers which were not bestowed on the present MMDA. J. Lex in 1990, President Aquino issued Executive Order, E.O. No. 392 and constituted the Metropolitan Manila Authority. The powers and functions of the MMC were devolved to the MMA. It ought to be stressed, however, that not all powers and functions of the MMC were passed to the MMA. The MMA's power was limited to the delivery of basic urban services requiring coordination in Metropolitan Manila. The MMA's governing body, the Metropolitan Manila Council, although composed of the mayors of the component cities and municipalities, was merely given the power of formulation of policies on the delivery of basic services requiring coordination and consolidation, and promulgation of resolutions and other issuances. Approval of a code of basic services and the exercise of its rule-making power. Under the 1987 Constitution, the local government units became primarily responsible for the governance of their respective political subdivisions. The MMA's jurisdiction was limited to addressing common problems involving basic services that transcended local boundaries. It did not have legislative power. Its power was merely to provide the local government units technical assistance in the preparation of local development plans. Any semblance of legislative power it had was confined to a review. Legislation proposed by the local legislative assemblies to ensure consistency among local governments and with the comprehensive development plan of Metro Manila, and to advise the local governments accordingly. When RA No. 7924 took effect, Metropolitan Manila became a Special Development and Administrative Region and the MMDA a Special Development Authority whose functions were without prejudice to the autonomy of the affected local government units. The character of the MMDA was clearly defined in the legislative debates enacting its charter. It is thus beyond doubt that the MMDA is not a local government unit or a public corporation endowed with legislative power. It is not even a special metropolitan political subdivision as contemplated in Section 11, Article X of the Constitution. The creation of a special metropolitan political subdivision requires the approval by a majority of the votes cast in a plebiscite in the political units directly affected. RA No. 7924 was not submitted to the inhabitants of Metro Manila in a plebiscite. The chairman of the MMDA is not an official elected by the people, but appointed by the president with the rank and privileges of a cabinet member. In fact, part of his function is to perform such other duties as may be assigned to him by the president, whereas in local government units, the president merely exercises supervisory authority. This emphasizes the administrative character of the MMDA. Clearly then, the MMC under PD No. 824 is not the same entity as the MMDA under RA No. 7924. Unlike the MMC, the MMDA has no power to enact ordinances for the welfare of the community. It is the local government units, acting through their respective legislative councils, that possess legislative power and police power. In the case at bar, the Sangguniang Panlungsod of Makati City did not pass any ordinance or resolution ordering the opening of Neptune Street, hence its proposed opening by petitioner MMDA is illegal and the Respondent Court of Appeals did not err in so ruling. We desist from ruling on the other issues as they are unnecessary. So we stress that this decision does not make light of the MMDA's noble efforts to solve the chaotic traffic condition in Metro Manila. Every day, traffic jams and traffic bottlenecks plague the metropolis. Even our once sprawling boulevards and avenues are now crammed with cars while city streets are clogged with motorists and pedestrians. Traffic has become a social malaise affecting our people's productivity and the efficient delivery of goods and services in the country. The MMDA was created to put some order in the metropolitan transportation system, but unfortunately the powers granted by its charter are limited. Its good intentions cannot justify the opening for public use of a private street in a private subdivision without any legal warrant. The promotion of the general welfare is not antithetical to the preservation of the rule of law. Sangalang v. IAC. MMDA claims that it has the authority to open Neptune Street to public traffic because it is an agent of the state endowed with police power in the delivery of basic services in Metro Manila. One of these basic services is traffic management, which involves the regulation of the use of thoroughfares to ensure the safety, convenience, and welfare of the general public. It is alleged that the police power of MMDA was affirmed by this court in the consolidated cases of Sangalang v. IAC. From the premise that it has police power, it is now urged that there is no need for the city of Makati to enact an ordinance opening Neptune Street to the public. Macasiano v. Diokno. Facts: on June 13, 1990, the municipality of Paranaque passed Ordinance 86, S. 1990, which authorized the closure of J. Gabriel, G. Cruz, Bayanahan, Lt. Garcia Extension and Opana streets located at Baclaran, Paranaque, Metro Manila, and the establishment of a flea market thereon. The said ordinance was approved by the Municipal Council pursuant to MCC Ordinance 2, S. 1979, authorizing and regulating the use of certain city and/or municipal streets, roads, and open spaces within metropolitan Manila as sites for flea market and/or vending areas, under certain terms and conditions. On July 20, 1990, the Metropolitan Manila Authority approved Ordinance 86, S. 1990 of the Municipal Council subject to conditions. On June 20, 1990, the Municipal Council issued a resolution authorizing the Paranaque Mayor to enter into contract with any service cooperative for the establishment, operation, maintenance, and management of flea markets and/or vending areas. On August 8, 1990, the municipality and Palanyag, a service cooperative, entered into an agreement whereby the latter shall operate, maintain and manage the flea market with the obligation to remit dues to the treasury of the municipal government of Paranaque. Consequently, market stalls were put up by Palanyag on the said streets. On September 13, 1990, Brig. Gen. Macasiano, PNP Superintendent of the Metropolitan Traffic Command, ordered the destruction and confiscation of stalls along G. Cruz and J. Gabriel St. in Baclaran. These stalls were later returned to Palanyag. On October 16, 1990, Macasiano wrote a letter to Palanyag giving the latter 10 days to discontinue the flea market, otherwise, the market stalls shall be dismantled. On October 23, 1990, the municipality and Palanyag filed with the trial court a joint petition for prohibition and mandamus with damages and prayer for preliminary injunction. On December 17, 1990, the trial court issued an order upholding the validity of Ordinance 86/S 1990 of the Municipality of Paranaque and enjoining Macasiano from enforcing his letter order against Palanyag. Hence, a petition for certiorari under Rule 65 was filed by Macasiano through the OSG. The Supreme Court granted the petition, and reversed and set aside the December 17, 1990 decision of the RDC which granted the writ of preliminary injunction enjoining the PNP Superintendent. Metropolitan Traffic Command from enforcing the demolition of market stalls along J. Gabriel, G.G. Cruz, Bayanahan, L.T. Garcia Extension and Opena Streets. Ratio. Property of provinces, cities, and municipalities, property for public use. The property of provinces, cities, and municipalities is divided into property for public use and patrimonial property. As to property for public use, Article 424 of Civil Code provides that property for public use, in the provinces, cities, and municipalities, consists of the provincial roads, city streets, the squares, fountains, public waters, promenades, and public works for public service paid for by said provinces, cities, or municipalities. All other property possessed by any of them is patrimonial and shall be governed by this code, without prejudice to the provisions of special laws. In the present case, thus, J. Gabriel G.G. Cruz, Bayanahan, L.T. Garcia Extension and Opena Streets are local roads used for public service and are therefore considered public properties of the municipality. Properties for public service deemed public and under absolute control of Congress. Properties of the local government which are devoted to public service are deemed public and are under the absolute control of Congress. Local governments have no authority to regulate use of public properties unless authority is vested upon by Congress, e.g. closure of roads. Local governments have no authority whatsoever to control or regulate the use of public properties unless specific authority is vested upon them by Congress. One such example of this authority given by Congress to the local governments is the power to close roads as provided in Section 10, Chapter 2 of the Local Government Code, which states a local government unit may likewise, through its head acting pursuant to a resolution of its Sangguniang and in accordance with existing law and the provisions of this code, close any barangay, municipal, city or provincial road, street, alley, park, or square. No such way or place or any part thereof shall be closed without indemnifying any person prejudiced thereby. A property thus withdrawn from public use may be used or conveyed for any purpose for which other real property belonging to the local unit concerned might be lawfully used or conveyed. Legal provision should be read and interpreted in accordance with basic principles already established by law. LGU has no power to lease a road available to public and ordinarily used for vehicular traffic. The legal provision which gives authority to local government units to close roads and other similar public places should be read and interpreted in accordance with basic principles already established by law. These basic principles have the effect of limiting such authority of the province, city, or municipality to close a public street or thoroughfare. Article 424 NCC lays down the basic principle that properties of public dominion devoted to public use and made available to the public in general are outside the commerce of man and cannot be disposed of or leased by the local government unit to private persons. Aside from the requirement of due process which should be complied with before closing a road, street, or park, the closure should be for the sole purpose of withdrawing the road or other public property from public use when circumstances show that such property is no longer intended or necessary for public use or public service. When it is already withdrawn from public use, the property then becomes patrimonial property of the local government unit. It is only then that the LGU can use or convey them for any purpose for which other real property belonging to the local unit concerned might be lawfully used or conveyed. However, those roads and streets which are available to the public in general and ordinarily used for vehicular traffic are still considered public property devoted to public use. In such case, the LGU has no power to use it for another purpose or to dispose of or lease it to private persons. Related case, Cebu Oxygen v. Bercils. In Cebu Oxygen v. Bercils, the City Council of Cebu, through a resolution, declared the terminal road of Emborces Street, Mabalo, Cebu City as an abandoned road, the same not being included in the city development plan. Thereafter, the City Council passed another resolution authorizing the sale of the said abandoned road through public bidding. The court held that the city of Cebu is empowered to close a city street and to vacate or withdraw the same from public use. Such withdrawn portion becomes patrimonial property which can be the object of an ordinary contract-related case, Dacanae via sistio. In Dacanae via sistio, the disputed areas from which the market stalls are sought to be evicted are public streets. A public street is property for public use, hence outside the commerce of man, arts. 424, Civil Code. Being outside the commerce of man, it may not be the subject of lease or other contract. Villanueva, et.al. v. Castaneda and Macalino, 15 SCRA 142. Citing the Municipality of Cavite v. Rojas, 30 SCRA 602, Espiritu v. Municipal Council of Paso Rubio, 102 Philosophy 869, and Wiat v. de la Fuente, 48 OG 4860. The right of the public to use the city streets may not be bargained away through contract. The interests of a few should not prevail over the good of the greater number in the community whose health, peace, safety, good order, and general welfare, the respondent city officials are under legal obligation to protect. The leases or licenses granted by the city government to stall holders are null and void for being contrary to law. The executive order issued by the acting mayor authorizing the use of Heroes del 96th Street as a vending area for stall holders contravenes the general law that reserves city streets and roads for public use. The executive order may not infringe upon the vested right of the public to use city streets for the purpose they were intended to serve, i.e., as arteries of travel for vehicles and pedestrians. In gratia argumenti, ordinance cannot be validly implemented as municipality has not complied with conditions imposed by the MMA for the approval of the ordinance. Even assuming, in gratia argumenti, that the municipality has the authority to pass the disputed ordinance, the same cannot be validly implemented because it cannot be considered approved by the Metropolitan Manila Authority due to non-compliance by the municipality of the conditions imposed by the former for the approval of the ordinance. The allegations of the municipality that the closed streets were not used for vehicular traffic and that the majority of the residents do not oppose the establishment of a flea market on said streets are unsupported by any evidence that will show that the first condition has been met. Likewise, the designation by the municipality of a time schedule during which the flea market shall operate is absent. Baclaran area congested. Establishment of flea market on municipality streets does not help solve problem of congestion. It is of public notice that the streets along Baclaran area are congested with people, houses and traffic brought about by the proliferation of vendors occupying the streets. To license and allow the establishment of a flea market along J. Gabriel, G. Cruz, by Anahan, Lt. Garcia extension and open a streets in Baclaran would not help in solving the problem of congestion but rather leads to inconvenience to children as the normal transportation flow is disrupted. To pollution and deterioration of health of residents due to the garbage left by the vendors on the streets. Further, ambulances and fire engines are not able to use the roads for a more direct access to the fire area and thus lose valuable time that should have been spent in saving properties and lives. And further, the ambulances and people rushing patients to St. Rita Hospital located along G. Cruz Street are delayed as they are unable to pass through said street due to the stalls and vendors. Powers of local government unit not absolute. The powers of a local government unit are not absolute. They are subject to limitations laid down by the Constitution and the laws such as our Civil Code. Moreover, the exercise of such powers should be subservient to paramount considerations of health and well-being of the members of the community. Every local government unit has the sworn obligation to enact measures that will enhance the public health, safety, and convenience, maintain peace and order, and promote the general prosperity of the inhabitants of the local units. Based on this objective, the local government should refrain from acting towards that which might prejudice or adversely affect the general welfare. General public has legal right to demand the restoration of city streets to their specific public purpose. As in the Dacanae case, the general public have a legal right to demand the demolition of the illegally constructed stalls in public roads and streets, and the officials of municipality have the corresponding duty arising from public office to clear the city streets and restore them to their specific public purpose. Applicability of the Daconet case: contracts by local government governed by the original terms and conditions, and the law in force at time the rights were vested. As in the Daconet case, both cases involve an ordinance which is void and illegal for lack of basis and authority in laws applicable during its time. However, BP 337 has already been repealed by RA 7160, which took effect on January 1, 1992. Section 5 of the new code provides that rights and obligations existing on the date of effectivity of the new code and arising out of contracts or any other source of prestation involving a local government unit shall be governed by the original terms and conditions of the said contracts or the law in force at the time such rights were vested. Syllabus Part 3, Elective Officials, Vacancies, Citizen, Disciplinary Actions. Qualifications: Abella v. Cumlick 201 SCRA 253 Facts. Initially, Silvestre de la Cruz filed a petition with the Cumlick to disqualify petitioner Larrazabal from running as governor of Leyte on the ground that she misrepresented her residence in her certificate of candidacy as Cananga, Leyte. It was alleged that she was in fact a resident of Ormoc City like her husband, who was earlier disqualified from running for the same office. The Cumlick granted the petition. However, when the commission granted the decision, Larrazabal was already proclaimed the governor. Hence, when she was disqualified, Abella, who gathered the second highest votes in the said area, sought to take his oath as governor of Cananga, Leyte. The petitioner, however, avers that the Cumlick decision is erroneous when it relied on the provisions of the Family Code to rule that the petitioner lacks the required residence to qualify her to run for the position of governor of Leyte. She opines that under the election law, the matter of determination of the residence is more on the principle of intention, the animus revertendi, rather than anything else. In this regard she states that her subsequent physical transfer of residence to Ormoc City thereafter, did not necessarily erase or remove her Cananga residence. For as long as she had the animus revertendi evidenced by her continuous and regular acts of returning there in the course of the years, although she had physically resided at Ormoc City. Issue: whether or not the candidate who got the second highest vote may be proclaimed as governor when the candidate for such position was disqualified. Held, the Supreme Court held that while it is true that SPC No. 88-546 was originally a petition to deny due course to the certificate of candidacy of Larrazabal and was filed before Larrazabal could be proclaimed, the fact remains that the local elections of February 1, 1988 in the province of Leyte proceeded with Larrazabal considered as a bona fide candidate. The voters of the province voted for her in the sincere belief that she was a qualified candidate for the position of governor. Her votes were counted and she obtained the highest number of votes. The net effect is that the petitioner lost in the election. He was repudiated by the electorate. As regards the principle of animus revertendi, Fapin v. Quirino M. Absence from one's residence or origin domicile to pursue studies, engage in business, or practice his avocation, is not sufficient to constitute abandonment or loss of such residence. The determination of a person's legal residence or domicile largely depends upon intention, which may be inferred from his acts, activities, and utterances. The party who claims that a person has abandoned or left his residence or origin must show and prove preponderantly such abandonment or loss. In the instant case, there is no evidence to prove that the petitioner temporarily left her residence in Cananga, Leyte in 1975 to pursue any calling, profession, or business. What is clear is that she established her residence in Ormoc City with her husband and considers herself a resident therein. The intention of animus revertendi not to abandon her residence in Cananga, Leyte therefore, is nor present. The fact that she occasionally visits Kananga, Leyte through the years does not signify an intention to continue her residence therein. It is common among us Filipinos to often visit places where we formerly resided, specially so when we have left friends and relatives, although for intents and purposes we have already transferred our residence to other places. Whether or not the petitioner is a registered voter of Kananga, Leyte, the petitioner insists that she is such a registered voter based on the following antecedents. 1. She cancelled her registration in Ormoc City on November 25, 1987. And 2. She then transferred her registration to Kananga, Leyte on November 25, 1987 by registering thereat. And 3. She later voted on election day in Kananga, Leyte. We find the version pressed by respondent unworthy of belief. The story is marked by so many bizarre circumstances not consistent with the ordinary course of events or the natural behavior of persons. Among these are the application for cancellation of registration by respondent Adelina Y. Larrazabal happened to be misplaced by a clerk in the election registrar's office for Ormoc City, so it was not sent to the Board of Election Inspectors in a sealed envelope. The inadvertent misplacement was discovered only on January 9, 1988. The voter's affidavit was delivered by itself without any endorsement or covering letter from the election registrar or anybody else. The election clerk delivered the application for cancellation only towards the last hour of the revision day. Allegedly at 4:30 p.m., January 9, 1988, all the members of the BAE had already signed the minutes indicating that no revision of the voters' list was made as of 5:00 p.m. The poll clerk and the third member prepared another minutes stating that the election clerk had delivered the application for cancellation at 4:30 p.m. Without any reference to the minutes they had previously signed, Emeterio Larrazabal, who was supposed to have registered in Precinct 17, Mahawan, Kananga, was supposed to have filled up an application for cancellation of his registration in Precinct number 15, Ormoc City at Precinct 17 concurrent with his registration. His application for cancellation was never submitted in evidence. The serial number of the voters' affidavits of the spouses Larrazabal in Precinct number 17 are far removed from the serial numbers of the other new registrants in November 28, 1987 in the same precinct. The most telling evidence is the list of voters, that the chairman and the poll clerk had written in Part 2 of the same, closed by the signatures of both officials, showing that there were only 9 additional registered voters in Precinct 17. Petitioner was not there. It was only on February 15, 1988, or 2 weeks after the election day, that the same registrar certified for the first time that there were 2 voters' lists, the first without the names of the Larrazabals and the second, which appeared only after February 1, submitted by the chairman of the board for Precinct 17, which contained the spouses Larrazabal's names. Failing in her contention that she is a resident and registered voter of Kananga, Leyte, the petitioner poses an alternative position that her being a registered voter in Ormoc City was no impediment to her candidacy for the position of governor of the province of Leyte. Section 12, Article X of the Constitution provides. Relating therefore, Section 89 of R.A. 179 to Section 12, Article X of the Constitution, one comes up with the following conclusion, that Ormoc City when organized was not yet a highly urban city but is, nevertheless, considered independent of the province of Leyte, to which it is geographically attached because its charter prohibits its voters from voting for the provincial elective officials. The question now is whether or not the prohibition against the city's registered voters electing the provincial officials necessarily mean a prohibition of the registered voters to be elected as provincial officials. The argument is untenable. Section 12, Article X of the Constitution is explicit in that aside from highly urbanized cities, component cities whose charters prohibit their voters from voting for provincial elective officials are independent of the province. In the same provision, it provides for other component cities within a province whose charters do not provide a similar prohibition. Necessarily. Component cities like Ormoc City whose charters prohibit their voters from voting for provincial elective officials are treated like highly urbanized cities which are outside the supervisory power of the province to which they are geographically attached. This independence from the province carries with it the prohibition or mandate directed to their registered voters not to vote and be voted for the provincial elective offices. The resolution in GR number 80716 entitled Peralta v. The Commission on Elections, et.al. dated December 10, 1987 applies to this case. While the cited case involves Olongapo City which is classified as a highly urbanized city, the same principle is applicable. Moreover, Section 89 of Republic Act 179, independent of the constitutional provision, prohibits registered voters of Ormoc City from voting and being voted for elective offices in the province of Leyte. We agree with the Cumlac and Bank that the phrase shall not be qualified and entitled to vote in the election of the provincial governor and the members of the provincial board of the province of Leyte connotes two prohibitions: 1. From running for, and the second, from voting for any provincial elective official. The petitioner takes exception to this interpretation. She opines that such interpretation is wrong English since nowhere in the provision is there any reference to a prohibition against running for provincial elective office. She states that if the prohibition to run was indeed intended, the provision should have been phrased shall not be qualified to run in the election for provincial governor. A comma should have been used after the word qualified and after the word vote to clearly indicate that the phrase in the election of the provincial governor is modified separately and distinctly by the words not qualified and the words not entitled to vote. The court finds the petitioner's interpretation fallacious. In the case of Mapa v. Arroyo, the conjunction and between the phrase shall not be qualified and entitled to vote refer to two prohibitions as ruled by the Cumlac in relation to the demonstrative phrase in the election of the provincial governor and the members of the provincial board of the province of Leyte. Finally, the petitioner contends that the February 14, 1991 decision of the Cumlac's Second Division is null and void on the ground that on that date, the term of Commissioner Andres Flores, one of the signatories of the majority opinion, had already expired on February 2, 1991. Commissioner Flores was appointed for a 3-year term from February 15, 1988 to February 15, 1991. In these 3 years he exercised his duties and functions as commissioner, granting in the absence of a statute expressly stating when the terms of the Cumlac chairman and members commence and expire, that his term expired on February 2, 1991 to enable a faithful compliance with the constitutional provision that the terms of office in the Cumlac are on a staggered basis commencing and ending at fixed intervals. His continuance in office until February 15, 1991 has a color of validity. Therefore, all his official acts from February 3, 1991 to February 15, 1991, are considered valid. Issue: 1. Abella can assume position of governor by virtue of Section 6 RA 6646. Ratio: Abella claims that the Frivaldo and Labo cases were misapplied by the Cumlac. According to him, these cases are fundamentally different from SPC No. 88 to 546 in that the Frivaldo and Labo cases were petitions for a quo warranto filed under Section 253 of the Omnibus Code. contesting the eligibility of the respondents after they had been proclaimed duly elected to the office from which they were sought to be unseated, while SPC No. 88-546, which was filed before proclamation under Section 78 of the Omnibus Election Code, sought to deny due course to Larazabal's certificate of candidacy for material misrepresentations and was seasonably filed on election day. He, therefore, avers that since under Section 6 of Republic Act 6646 it is provided therein that, any candidate who has been declared by final judgment to be disqualified shall not be voted for, and the votes cast for him shall not be counted. The votes cast in favor of Larazabal who obtained the highest number of votes are not considered counted, making her a non-candidate. He who obtained the second highest number of votes should be installed as regular governor of Leyte in accordance with the court's ruling in Gr. No. 88,004. While it is true that SPC No. 88-546 was originally a petition to deny due course to the certificate of candidacy of Larazabal and was filed before Larazabal could be proclaimed, the fact remains that the local elections of February 1, 1988 in the province of Leyte proceeded with Larazabal considered as a bona fide candidate. The voters of the province voted for her in the sincere belief that she was a qualified candidate for the position of governor. Her votes were counted and she obtained the highest number of votes. The net effect is that the petitioner lost in the election. He was repudiated by the electorate. In the Frivaldo and Labo cases, this is precisely the reason why the candidates who obtained the second highest number of votes were not allowed to assume the positions vacated by Frivaldo, the governorship of Sorsogon, and Labo, the position of mayor in Baguio City. The nature of the proceedings, therefore, is not that compelling. What matters is that in the event a candidate for an elected position who is voted for and who obtains the highest number of votes is disqualified for not possessing the eligibility requirements at the time of the election as provided by law, the candidate who obtains the second highest number of votes for the same position cannot assume the vacated position. It should be stressed that in Gr. No. 88,004, the court set aside the dismissal of SPC No. 88-546, and directed the Cumlic to conduct hearings to determine whether or not Larazabal was qualified to be a candidate for the position of governor in the province of Leyte. This is the import of the decision in Gr. No. 88,004. Thus, the court ruled in the case of Labo, Jr. v. Commission on Elections. Finally, there is the question of whether or not the private respondent, who filed the quo warranto petition, can replace the petitioner as mayor. He cannot. The simple reason is that as he obtained only the second highest number of votes in the election, he was obviously not the choice of the people of Baguio City. The latest ruling of the court on this issue is Santos v. Commission on Elections, decided in 1985. In that case, the candidate who placed second was proclaimed elected after the votes for his winning rival, who was disqualified as a turncoat and considered a non-candidate, were all disregarded as stray. In effect, the second placer won by default. That decision was supported by 8 members of the court then, with 3 dissenting and another 2 reserving their vote. One was on official leave. It would be extremely repugnant to the basic concept of the constitutionally guaranteed right to suffrage if a candidate who has not acquired the majority or plurality of votes is proclaimed a winner and imposed as the representative of a constituency, the majority of which have positively declared through their ballots that they do not choose him. Sound policy dictates that public elective offices are filled by those who have received the highest number of votes cast in the election for that office. And it is a fundamental idea in all republican forms of government that no one can be declared elected and no measure can be declared carried unless he or it receives a majority or plurality of the legal votes cast in the election. The fact that the candidate who obtained the highest number of votes is later declared to be disqualified or not eligible for the office to which he was elected does not necessarily entitle the candidate who obtained the second highest number of votes to be declared the winner of the elective office. The votes cast for a dead, disqualified, or non-eligible person may not be valid to vote the winner into office or maintain him there. However, the absence of a statute which clearly asserts a contrary politics and legislative policy on the matter, if the votes were cast in the sincere belief that the candidate was alive, qualified, or eligible, they should not be treated as stray, void or meaningless. In sum, the court does not find any reason to reverse and set aside the questioned decision and resolution of the Cumlic. The Cumlic has not acted without or in excess of jurisdiction or in grave abuse of discretion. Labo v. Cumlic. Facts: Ramon Labo, Jr. married an Australian citizen in the Philippines. He was granted Australian citizenship in 1976. In 1980, the marriage was declared void for being bigamous. Labo returned to the Philippines in 1980, using an Australian passport, and obtained an alien certificate of registration. He later applied for a change in status from immigrant to returning Filipino citizen. However, the Commission on Immigration and Deportation denied his application for the cancellation of his ACR since he has not applied for reacquisition of his Filipino citizenship. According to the records of the Australian Embassy, Labo was still an Australian citizen as of April 12, 1984. Although no direct evidence was presented to prove that he took an oath of allegiance as a naturalised Australian citizen. The laws of Australia at the time required any person over the age of 16 years who is granted Australian citizenship to take an oath of allegiance. The wording/text of this oath includes a renunciation of all other allegiance. Labo ran and won as mayor of Baguio City in the local elections held on January 18, 1988. The second placer, Luis Lardizabal, filed a petition for quo warranto, alleging that Labo is disqualified from holding public office on the grounds of alienage, and asking that the latter's proclamation as mayor be annulled. Issues: The original issue raised before the Supreme Court concerned only the Cumlic's jurisdiction over Lardizabal's petition. Labo contended that the petition for quo warranto was not filed on time, hence the Cumlic lacks the jurisdiction to conduct an inquiry regarding his citizenship. However, the SC decided to rule on the merits of the case, given that the issue is also of considerable importance, and in the interest of the speedy administration of justice. Does the Cumlic have the jurisdiction to inquire into Labo's citizenship? Is Ramon Labo, Jr. a Filipino citizen? Is he qualified to hold public office in the Philippines? If Labo is not eligible to serve as mayor, can Lardizabal, as the runner-up in the elections, replace him? Held/ratio. Yes. Contrary to Labo's claim, the petition for quo warranto was filed on time. Lardizabal did not immediately pay the filing fee because the Cumlic had at first considered the petition as a pre-proclamation proceeding, which does not require the payment of such a fee. When the Cumlic reclassified the petition, Lardizabal immediately paid the filing fee, thus, he still complied with the prescribed 10-day period. Furthermore, the court held that such technicalities should not hinder judicial decisions on significant issues, such as the one being decided in this case. Labo is not a Filipino citizen. He had lost his Philippine citizenship by all three modes specified in the Constitution: naturalization in a foreign country, express renunciation of citizenship, and subscribing to an oath of allegiance to support the Constitution or laws of a foreign country. He has not reacquired Philippine citizenship by any of the three methods prescribed in the Constitution: direct act of Congress, naturalization, and repatriation. Contrary to Labo's claim, his naturalization in Australia did not confer him with dual citizenship. The Constitution explicitly states that dual citizenship is inimical to national interest. The contention that his marriage to an Australian national did not automatically divest him of Filipino citizenship is irrelevant. There was no claim that Labo had automatically ceased to be a Filipino because of that marriage. Also, his Filipino citizenship has not been automatically restored upon the annulment of his Australian citizenship, when his marriage was declared void on the grounds of bigamy. The Commission on Immigration and Deportation held in 1988 that Labo was not a Filipino citizen. The earlier contrary decision by the COMELEC in 1982 is totally baseless, and is even alleged to have been politically motivated. The latter can be reversed because the doctrine of residential judicata does not apply to questions of citizenship. Labo is not eligible to hold public office in the Philippines. He was not even a qualified voter when he was elected. Despite getting the second highest number of votes, Lard Isabel cannot assume the position of mayor because he has not been duly elected by the people of Baguio City. Labo's disqualification alone does not entitle him to take office. Instead, the elected vice mayor shall replace Labo. Separate concurring opinion. Although no decision has been rendered by the COMELEC and elevated to the SC for review, it is undeniable that a foreigner cannot be allowed to hold public office in the Philippines. It is regrettable, however, that Labo should be disqualified on the basis of his citizenship because he has already achieved a lot while serving as mayor during the pendency of the case. Frivaldo v. COMELEC. Facts: Petitioner Juan G. Frivaldo was proclaimed governor-elect and assumed office in due time. The League of Municipalities filed with the COMELEC a petition for annulment of Frivaldo's election and proclamation on the ground that he was not a Filipino citizen, having been naturalized in the United States. Frivaldo admitted the allegation but pleaded the special and affirmative defenses that his naturalization was merely forced upon himself as a means of survival against the unrelenting prosecution by the martial law dictator's agent abroad. Issue: whether or not Frivaldo was a citizen of the Philippines at the time of his election. Held no. Section 117 of the Omnibus Election Code provides that a qualified voter must be, among other qualifications, a citizen of the Philippines, this being an indispensable requirement for suffrage under Article V, Section 1, of the Constitution. Even if he did lose his naturalized American citizenship, such forfeiture did not and could not have the effect of automatically restoring his citizenship in the Philippines that he had earlier renounced. Qualifications for public office are continuing requirements and must be possessed not only at the time of appointment or election or assumption of office but during the officer's entire tenure. Frivaldo declared not a citizen of the Philippines and therefore disqualified from serving as a governor of the province of Sorsogon. In the certificate of candidacy he filed, Frivaldo described himself as a natural-born citizen of the Philippines, omitting mention of any subsequent loss of such status. The evidence shows, however, that he was naturalized as a citizen of the United States in 1983 per the following certification from the United States District Court, Northern District of California. As duly authenticated by Vice Consul Amado P. Cortez of the Philippine Consulate General in San Francisco, California, USA. This evidence is not denied by the petitioner. In fact, he expressly admitted it in his answer. Nevertheless, as earlier noted, he claims it was forced on him as a measure of protection from the persecution of the Marcos government through his agents in the United States. The court sees no reason not to believe that the petitioner was one of the enemies of the Marcos dictatorship. Even so, it cannot agree that as a consequence thereof he was coerced into embracing American citizenship. His feeble suggestion that his naturalization was not the result of his own free and voluntary choice is totally unacceptable and must be rejected outright. There were many other Filipinos in the United States similarly situated as Frivaldo, and some of them subject to greater risk than he, who did not find it necessary nor do they claim to have been coerced to abandon their cherished status as Filipinos. They did not take the oath of allegiance to the United States, unlike the petitioner who solemnly declared on oath, that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state or sovereignty of whom or which I have heretofore been a subject or citizen, meaning in his case the Republic of the Philippines. The martyred Ninoy Aquino heads the impressive list of those Filipinos in exile who, unlike the petitioner, held fast to their Philippine citizenship despite the perils of their resistance to the Marcos regime. The Nate Bohm case cited by the petitioner invoked the international law principle of effective nationality, which is clearly not applicable to the case at bar. That case is not relevant to the petition before us because it dealt with a conflict between the nationality laws of two states as decided by a third state. No third state is involved in the case at bar. In fact, even the United States is not actively claiming Frivaldo as its national. The sole question presented to us is whether or not Frivaldo is a citizen of the Philippines under our own laws, regardless of other nationality laws. We can decide this question alone as sovereign of our own territory, conformably to Section 1 of the said convention, providing that it is for each state to determine under its law who are its nationals. It is also worth noting that Nate Bohm was invoking his naturalization in Liechtenstein, whereas in the present case Frivaldo is rejecting his naturalization in the United States. If he really wanted to disavow his American citizenship and reacquire Philippine citizenship, the petitioner should have done so in accordance with the laws of our country. Under CA number 63 as amended by CA number 473 and PD number 725, Philippine citizenship may be reacquired by direct act of Congress, by naturalization, or by repatriation. It does not appear that Frivaldo has taken these categorical acts. He contends that by simply filing his certificate of candidacy he had, without more, already effectively recovered Philippine citizenship. But that is hardly the formal declaration the law envisions. Surely, Philippine citizenship previously disowned is not that cheaply recovered. If the special committee had not yet been convened, what that meant simply was that the petitioner had to wait until this was done, or seek naturalization by legislative or judicial proceedings. Gutierrez Jr., concurring, I concur in the pragmatic approach taken by the court. I agree that when the higher interests of the state are involved, the public good should supersede any procedural infinities which may affect a petition filed with the Commission on Elections. I fail to see how the court could allow a person who by his own admissions is indubitably an alien to continue holding the office of governor of any province. It is an established rule of long standing that the period fixed by law for the filing of a protest, whether quo warranto or election contest, is mandatory and jurisdictional. As a rule, the quo warranto petition seeking to annul the petitioner's election and proclamation should have been filed with 10 days after the proclamation of election results. The purpose of the law in not allowing the filing of protests beyond the period fixed by law is to have a certain and definite time within which petitions against the results of an election should be filed and to provide summary proceedings for the settlement of such disputes. The rules of court allow the Republic of the Philippines to file quo warranto proceedings against any public officer who performs an act which works a forfeiture of his office. However, where the Solicitor General or the President feel that there are no good reasons to commence quo warranto proceedings, the court should allow a person like Estuyi or his league to bring the action. I must emphasize, however, that my concurrence is limited to a clear case of an alien holding an elective public office, and perhaps in a clear case of disloyalty to the Republic of the Philippines. Where the disqualification is based on age, residence, or any of the many grounds for ineligibility, I believe that the 10-day period should be applied strictly. The pragmatic approach is also shown by the fact that the court found it inexpedient to wait for the final decision of Cumlic. This step is most unusual, but considering the total lack of any serious grounds for the petitioner's claim of having regained his Philippine citizenship, I am constrained to concur in the procedure pro hac vice. Mercado v. Manzano. Facts: this is a petition for certiorari seeking to set aside the resolution of the Cumlic and Bank and to declare Manzano disqualified to hold the office of Vice Mayor of Makati City. Important details on Edu Manzano, born September 4, 1955 in San Francisco, California, USA to Filipino parents. On the May 11, 1998 elections for Vice Mayoralty of Makati City, 3 candidates competed for the post: Eduardo B. Manzano, Ernesto S. Mercado, and Gabriel V. Daza. 3. Manzano won the elections, but his proclamation was suspended due to a pending petition for disqualification filed by a certain Ernesto Mamaril alleging that Manzano was an American citizen. On May 7, 1998, the Second Division of the Cumlic cancelled the certificate of candidacy of Manzano on the grounds of his dual citizenship, which disqualifies him according to Sector 40 of the Local Government Code. Manzano filed a motion for reconsideration. Mercado sought to intervene in the case for disqualification. Manzano opposed the motion to intervene. The motion was unresolved. But on August 31, 1998, the Cumlic en Banc reversed the Second Division's ruling on the cancellation of the certificate of candidacy and directing the proclamation of Manzano as winner, saying, Manzano, being born in the USA, obtained U.S. citizenship by operation of the U.S. Constitution and laws under principle of jus soli. Yet, by being born to Filipino parents, Manzano natural-born Filipino citizen, by operation of the 1935 Philippine Constitution and laws under principle jus sanguinis. Although he is registered as an alien with the Philippine Bureau of Immigration and holds an American passport, he has not lost his Filipino citizenship since he has not renounced it and has not taken an oath of allegiance to the USA. Manzano, after the age of majority, registered himself as a voter and voted in the 1992, 1995, and 1998 Philippine elections, which effectively renounced his U.S. citizenship under American law. Under Philippine law, he no longer had U.S. citizenship. Private respondent Manzano was then proclaimed as vice mayor of Makati City. Issues. 1. Petitioner Mercado has personality to bring this suit considering that he was not an original party in the case for disqualification filed by Ernesto Mamaril, nor was his motion for leave to intervene granted. Yes. 1. Respondent Manzano is a dual citizen, and if so, 1. He is disqualified from being a candidate for vice mayor in Makati City. No. Reasons. Manzano argues that Mercado has neither legal interest in the matter of litigation nor an interest to protect because he is a defeated candidate for the vice mayoralty post of Makati City, cannot be proclaimed as the vice mayor of Makati City. Even if the private respondent be ultimately disqualified by final and executory judgment. This assumes that at the time intervention was sought, there had already been a proclamation of the election results for the vice mayoralty elections, when in fact, there has not been such a proclamation. Certainly, the petitioner had, and still has, an interest in ousting private respondent from the race when he sought to intervene. The rule in Labo v. Cumlic only applies when the election of the respondent is contested, and the question is won, the second placer may be declared winner. If Mamaril was competent to bring action, so was Mercado, being a rival candidate. Petitioner has right to intervene even if he filed the motion on May 20, 1998, when it was shown that the private respondent had the most votes. Electoral Reforms Law of 1987 provides that intervention may be allowed in proceedings for disqualification even after election if there has been no final judgment rendered. Failure of Cumlic en Banc to resolve petitioner's motion for intervention was tantamount to denial of the motion, justifying this petition for certiorari. Invoking the maxim dura lex sed lex, petitioner contends that through sections 40 of the Local Government Code, Congress has commanded in explicit terms the ineligibility of persons possessing dual allegiance to hold elective office. Dual citizenship is different from dual allegiance. Dual citizenship is involuntary, it arises out of circumstances of birth or marriage, where a person is recognized to be a national by two or more states. Dual allegiance is a result of a person's volition, it is a situation wherein a person simultaneously owes, by some positive act, loyalty to two or more states. Dual citizenship is an issue because a person who has this raises a question of which state's law must apply to him/her, therefore posting a threat to a country's sovereignty. In seconds 5 Article 4 of the Constitution on Citizenship, the concern was not with dual citizenship per se, but with naturalized citizens who maintain allegiance to their countries of origin even after naturalization. Hence, dual citizenship in the aforementioned disqualification clause must mean dual allegiance. Therefore, persons with mere dual citizenship do not fall under this disqualification. It should suffice that upon filing of certificates for candidacy, such persons with dual citizenships have elected their Philippine citizenship to terminate their dual citizenship. In private respondent's certificate of candidacy, he made these statements under oath on March 27, 1998, "I am a Filipino citizen natural born. I am not a permanent resident of, or immigrant to, a foreign country. I am eligible for the office I seek to be elected. I will support and defend the Constitution of the Philippines and will maintain true faith and allegiance thereto." The filing of such certificate of candidacy sufficed to renounce his American citizenship, effectively removing any disqualification he might have as a dual citizen. In Frivaldo v. Cumlick, it was held that by laws of the United States, Frivaldo lost his American citizenship when he took his oath of allegiance to the Philippine government when he ran for governor in 1988, in 1992, and in 1995. Every certificate of candidacy contains an oath of allegiance to the Philippine government. Therefore, petitioner Mercado's contention that the oath of allegiance contained in private respondent's certificate of candidacy is insufficient to constitute his renunciation of his American citizenship. Also, equally without merit is his contention that, to be effective, such renunciation should have been made upon reaching the age of majority, since no law requires the election of Philippine citizenship to be made upon majority age. Plus, the fact that Manzano admitted that he was registered as an American citizen with the Philippine Bureau of Immigration and Deportation and that he holds an American passport which he used for his last travel to the U.S. dated April 22, 1997 should not be such a big deal. At the time of said travel, the use of an American passport was simply an assertion of his American nationality before the termination of his American citizenship. Admitting that he was a registered alien does not mean that he is not still a Filipino. Manzano's oath of allegiance, together with the fact he has spent his life here, received his education here, and practiced his profession here, and has taken part in past Philippine elections, leaves no doubt of his election of Philippine citizenship. Wherefore, petition for certiorari, dismissed. Ineligibility refers to lack of qualifications prescribed. Kokia v. Cumlick. Nature, petition for certiorari to set aside the resolution, dated July 19, 2001, of the 2nd Division of the Cumlick, ordering the cancellation of the certificate of candidacy of petitioner Teodoro M. Kokia for the position of Mayor of Oras, Eastern Samar in the May 14, 2001 elections and the order, dated January 30, 2002, of the Cumlick and Bank denying petitioner's motion for reconsideration. Special civil action in the SC certiorari. Facts: February 17, 1938, Kokia was born of Filipino parents in Oras, Eastern Samar. He grew up and resided there until 1965, when he joined the U.S. Navy. He was subsequently naturalized as a U.S. citizen. 1970 to 1973, petitioner thrice visited the Philippines while on leave from the U.S. Navy. Otherwise, even after his retirement from the U.S. Navy in 1985, he remained in the U.S. October 15, 1998, petitioner came to the Philippines and took out a residence certificate, although he continued making several trips to the U.S., the last of which took place on July 6, 2000 and lasted until August 5, 2000. Subsequently, petitioner applied for repatriation under R.A. Number 81715 to the Special Committee on Naturalization, which was approved November 7, 2000, November 10, 2000, oath-taking as Filipino citizen, issued Certificate of Repatriation No. 000737 and Bureau of Immigration Identification Certificate No. 115123 3 days after November 21, 2000, applied for registration as a voter of Batangas, Oras, Eastern Samar. Approved by Election Registration Board on January 12, 2001. February 27, 2001, filed Certificate of Candidacy stating therein that he had been a resident of Oras, Eastern Samar for 2 years. March 5, 2001, Neil M. Alvarez respondent. Incumbent mayor of Oras and re-electionist sought cancellation of petitioner's certificate of candidacy on the ground that the latter had made a material misrepresentation in his certificate of candidacy by stating that he had been a resident of Oras for 2 years when in truth he had resided therein for only about 6 months since November 10, 2000, when he took his oath as a citizen of the Philippines. Cumlic unable to render judgment on the case before the elections on May 14, 2001, where petitioner won over private respondents by 379 votes. May 17, 2001, petitioner proclaimed mayor of Oras by the Municipal Board of Canvassers and subsequently took his oath of office. July 19, 2001. The 2nd Division of the Cumlic granted private respondents' petition and ordered the cancellation of petitioner's certificate of candidacy on the basis the respondents' frequent or regular trips to the Philippines and stay in Oras, Eastern Samar after his retirement from the U.S. Navy in 1985 cannot be added to his actual residence thereat after November 10, 2000 until May 14, 2001 to cure his deficiency in days, months, and year to allow or render him eligible to run for an elective office in the Philippines. The 1-year residency requirement of Sections 39 of the Local Government Code of 1991 in relation to SECS 65 and 68 of the Omnibus Election Code contemplates of the actual residence of a Filipino citizen in the constituency where he seeks to be elected. Petitioner filed a motion for reconsideration, but his motion was denied by the Cumlic and Bank on January 30, 2002. Hence this petition. Issues 1. The 30-day period for appealing the resolution of the Cumlic was suspended by the filing of a motion for reconsideration by petitioner. Private respondent contention. Petition should be dismissed cause his motion for reconsideration was denied for being pro forma and did not suspend the running of the 30-day period for filing this petition, pursuant to Rule 19. 4 of the Cumlic Rules of Procedure, so and since the resolution was received on July 28, 2001 and the petition in this case was filed on February 11, 2002. The same should be considered as having been filed late and should be dismissed. Petitioner's MFR and petition for certiorari were filed within the prescribed periods. 5-day period for filing MFR under Rule 19. 2 should be counted from receipt of decision, resolution, order, or ruling of Cumlic. In this case, petitioner received a copy of Cumlic's 2nd Division July 19, 01 resolution on July 28, 2001. 5 days later, on August 2, 01, he filed his MFR. On February 6, 02, he received a copy of the order, dated January 30, 02, of the Cumlic en banc denying his MFR 5 days later, on February 11, 02, he filed this petition for certiorari. Contention that petitioner's MFR did not suspend the running of the period for filing this petition because the motion was pro forma and, thus, petition should have been filed on or before August 27, 01 is not correct. It was actually filed, however, only on February 11, 2002. The MFR was not pro forma and its filing did suspend the period for filing the petition for certiorari in this case. The mere reiteration in a motion for reconsideration of the issues raised by the parties and passed upon by the court does not make a motion pro forma, otherwise. The movant's remedy would not be a reconsideration of the decision but a new trial or some other remedy. In the cases where MFR was held to be pro forma, the motion was so held because it was a second motion for reconsideration. Or it did not comply with the rule that the motion must specify the findings and conclusions alleged to be contrary to law or not supported by the evidence, or it failed to substantiate the alleged errors. Or it merely alleged that the decision in question was contrary to law, or the adverse party was not given notice thereof. Petitioner's MFR suffers from none of these defects, and Cumlic erred in ruling that petitioner's MFR was pro forma because the allegations raised therein are a mere rehash of his earlier pleadings or did not raise new matters. Hence, the filing of the motion suspended the running of the 30-day period to file the petition in this case, which, as earlier shown, was done within the reglementary period provided by law. 1. Cumlic retained jurisdiction to decide this case notwithstanding the proclamation of petitioner. RA number 6646, Sector 6 and 7, candidates who are disqualified by final judgment before the election shall not be voted for and the votes cast for them shall not be counted. But those against whom no final judgment of disqualification had been rendered may be voted for and proclaimed, unless, on motion of the complainant, the Cumlic suspends their proclamation because the grounds for their disqualification or cancellation of their certificates of candidacy are strong. Meanwhile, the proceedings for disqualification of candidates or for the cancellation or denial of certificates of candidacy, which have been begun before the elections, should continue even after such elections and proclamation of the winners. Inabella v. Cumlic and Salcedo 2 v. Cumlic, the SC, in the first case, affirmed and, in the second, reversed the decisions of the Cumlic rendered after the proclamation of candidates. Not on the ground that the latter had been divested of jurisdiction upon the candidate's proclamation but on the merits. One petitioner had been a resident of Oras, Eastern Samar at least 1 year before the elections held on May 14, 2001 as he represented in his certificate of candidacy. No. First, 39 of the Local Government Code provides, an elective local official must be a citizen of the Philippines, a registered voter in the barangay, municipality, city, or province or, in the case of a member of the Sangguniang Panlalawigan, Sangguniang Panlungsod, or Sangguniang Bayan, the district where he intends to be elected, a resident therein for at least 1 year immediately preceding the day of the election, and able to read and write Filipino or any other local language or dialect. Residence is to be understood as referring to domicile or legal residence, the place where a party actually or constructively has his permanent home, where he, no matter where he may be found at any given time, eventually intends to return and remain. A domicile of origin is acquired by every person at birth. It is usually the place where the child's parents reside and continues until the same is abandoned by acquisition of new domicile. In the case at bar, petitioner lost his domicile of origin in Oras by becoming a U.S. citizen after enlisting in the U.S. Navy in 1965. From then on and until November 10, 2000, when he reacquired Philippine citizenship, petitioner was an alien without any right to reside in the Philippines save as our immigration laws may have allowed him to stay as a visitor or as a resident alien. If immigration to the United States by virtue of a green card, which entitles one to reside permanently in that country, constitutes abandonment of domicile in the Philippines, cause IV. Ca. Much more does naturalization in a foreign country result in an abandonment of domicile in the Philippines, as was the case with the petitioner. Petitioner was repatriated not under RA number 2630, which applies to the repatriation of those who lost their Philippine citizenship by accepting commission in the armed forces of the U.S., but under RA number 8171, which provides for the repatriation of, among others, natural-born Filipinos who lost their citizenship on account of political or economic necessity. In any event, the fact is that, by having been naturalized abroad, he lost his Philippine citizenship and with it his residence in the Philippines and had not reacquired it until November 10, 2002. Petitioner did not re-establish residence in this country in 1998 when he came back to prepare for the mayoralty elections of Oras by securing a community tax certificate in that year and by constantly declaring to his townmates of his intention to seek repatriation and run for mayor in the May 14, 2001 elections. The status of being an alien and a non-resident can be waived either separately, when one acquires the status of a resident alien before acquiring Philippine citizenship, or at the same time when one acquires Philippine citizenship. As an alien, an individual may obtain an immigrant visa under 13 of the Philippine Immigration Act of 1948 and an immigrant certificate of residence and thus waive his status as a non-resident. On the other hand, he may acquire Philippine citizenship by naturalization under CA number 473, as amended, or, if he is a former Philippine national, he may reacquire Philippine citizenship by repatriation or by an act of Congress, in which case he waives not only his status as an alien but also his status as a non-resident alien. In the case at bar, the only evidence of petitioner's status when he entered the country on Oct and December 98, October 99, and June 2000 is the statement Philippine Immigration Balikbayan in his 1998 to 2008 U.S. passport. As for his entry on August 5, 2000, the stamp bore the added inscription "Good for 1 year stay." Under 2 of RA number 6768, the term Balikbayan includes a former Filipino citizen who had been naturalized in a foreign country and comes or returns to the Philippines and, if so, he is entitled, among others, to a visa-free entry to the Philippines for a period of 1 year. It would appear then that when petitioner entered the country on the dates in question, he did so as a visa-free Balikbayan visitor whose stay as such was valid for 1 year only. Hence, petitioner can only be held to have waived his status as an alien and as a non-resident only on November 10, 2000 upon taking his oath as a citizen of the Philippines under RA number 8171. He lacked the requisite residency to qualify him for the mayorship of Oras. Petitioner cannot invoke the ruling in the cases Frivaldo v. Commission on Elections and Bengson as residency was not an issue in these. Third, petitioners contends that his registration as a voter of Batenga, Oras, Eastern Samar in January 2001 is conclusive of his residency as a candidate because 117 of the Omnibus Election Code requires that a voter must have resided in the Philippines for at least 1 year and in the city or municipality wherein he proposes to vote for at least 6 months immediately preceding the election. But, registration as a voter does not bar the filing of a subsequent case questioning a candidate's lack of residency. Fourth, petitioner was not denied due process because the Cumlic failed to act on his motion to be allowed to present evidence. Under 5, in relation to 7, of RA number 6646. Proceedings for denial or cancellation of a certificate of candidacy are summary in nature. The holding of a formal hearing is thus not de rigueur. In any event, petitioner cannot claim denial of the right to be heard since he filed a verified answer, a memorandum, and a manifestation, all dated March 19, 2001. Before the Cumlic in which he submitted documents relied by him in this petition, which, contrary to petitioner's claim, are complete and intact in the records. 1. Kumlik was justified in ordering the cancellation of his certificate of candidacy since the statement in petitioner's certificate of candidacy that he had been a resident of Oras Eastern Samar for 2 years at the time he filed such certificate is not true. Yes. Petitioner made a false representation of a material fact in his certificate of candidacy, thus rendering such certificate liable to cancellation. Sector 78 of the Omnibus Election Code provides that a verified petition seeking to deny due course or to cancel a certificate of candidacy may be filed by any person exclusively on the ground that any material representation contained therein is required. Under Section 74 hereof is false. In the case at bar, what is involved is a false statement concerning a candidate's qualification for an office for which he filed the certificate of candidacy. This is a misrepresentation of a material fact justifying the cancellation of petitioner's certificate of candidacy. The cancellation of petitioner's certificate of candidacy in this case is thus fully justified. Judgment, wherefore, the petition is dismissed and the resolution of the Second Division of the Commission on Elections, dated July 19, 2001, and the order, dated January 30, 2002 of the Commission on Elections and Bank are affirmed. Disqualifications cause IVCA. Facts: Private respondent Marito Miguel was elected as municipal mayor of Bolinao, Pangasinan during the local elections of January 18, 1988. His disqualification, however, was sought by herein petitioner, Mateo Cazai, on the ground that under Section 68 of the Omnibus Election Code private respondent was not qualified because he is a green card holder, hence a permanent resident of the United States of America, not of Bolinao. Issues: 1. Whether or not a green card is proof that the holder is a permanent resident of the United States. 2. Whether respondent Miguel had waived his status as a permanent resident of or immigrant to the USA prior to the local elections on January 18, 1988. Held, the Supreme Court held that Miguel's application for immigrant status and permanent residence in the U.S. and his possession of a green card attesting to such status are conclusive proof that he is a permanent resident of the U.S. Despite his occasional visits to the Philippines, the waiver of such immigrant status should be as indubitable as his application for it. Absent clear evidence that he made an irrevocable waiver of that status or that he surrendered his green card to the appropriate U.S. authorities before he ran for mayor of Bolinao in the local election on January 18, 1988, the court's conclusion is that he was disqualified to run for said public office, hence, his election thereto was null and void. Section 18, Article 11 of the 1987 Constitution provides. Sector 18. Public officers and employees owe the state and this Constitution allegiance at all times. And any public officer or employee who seeks to change his citizenship or acquire the status of an immigrant of another country during his tenure shall be dealt with by law. In the same vein, but not quite, Section 68 of the Omnibus Election Code of the Philippines provides. SEC 68. Disqualifications. Any person who is a permanent resident of or an immigrant to a foreign country shall not be qualified to run for any elective office under this code, unless said person has waived his status as permanent resident or immigrant of a foreign country in accordance with the residence requirement provided for in the election laws. In the case of Marito Miguel, the court deems it significant that in the application for immigrant visa and alien registration which Miguel filled up in his own handwriting and submitted to the U.S. Embassy in Manila before his departure for the United States in 1984, Miguel's answer to question number 21 therein regarding his length of intended stay, Miguel's answer was, permanently. On its face, the green card that was subsequently issued by the United States Department of Justice and Immigration and Registration Service to Miguel identifies him in clear bold letters as a resident alien. On the back of the card, the upper portion, the following information is printed: person identified by this card is entitled to reside permanently and work in the United States. Despite his vigorous disclaimer, Miguel's immigration to the United States in 1984 constituted an abandonment of his domicile and residence in the Philippines. For he did not go to the United States merely to visit his children or his doctor there. He entered the limited states with the intention to have there permanently, as evidenced by his application for an immigrant's visa. Based on that application of his, he was issued by the U.S. government the requisite green card or authority to reside there permanently. Immigration is the removing into one place from another, the act of immigrating, the entering into a country with the intention of residing in it. As a resident alien in the U.S., Miguel owes temporary and local allegiance to the U.S., the country in which he resides. This is in return for the protection given to him during the period of his residence therein. Section 18. Article 11 of the 1987 Constitution, which provides that any public officer or employee who seeks to change his citizenship or acquire the status of an immigrant of another country during his tenure shall be dealt with by law, is not applicable to Marito Miguel, for he acquired the status of an immigrant of the United States before he was elected to public office, not during his tenure as mayor of Bolinao, Pangasinan. Did Miguel, by returning to the Philippines in November 1987 and presenting himself as a candidate for mayor of Bolinao in the January 18, 1988 local elections, waive his status as a permanent resident or immigrant of the United States? To be qualified to run for elective office in the Philippines, the law requires that the candidate who is a green card holder must have waived his status as a permanent resident or immigrant of a foreign country. Therefore, his act of filing a certificate of candidacy for elective office in the Philippines did not of itself constitute a waiver of his status as a permanent resident or immigrant of the United States. The waiver of his green card should be manifested by some act or acts independent of and done prior to filing his candidacy for elective office in this country. Without such prior waiver, he was disqualified to run for any elective office. Miguel admits that he holds a green card, which proves that he is a permanent resident or immigrant of the United States. But the records of this case are starkly bare of proof that he had waived his status as such before he ran for election as municipal mayor of Bolinao on January 18, 1988. We, therefore, hold that he was disqualified to become a candidate for that office. The reason for Section 68 of the Omnibus Election Code is not hard to find. Residence in the municipality where he intends to run for elective office for at least 1 year at the time of filing his certificate of candidacy, is one of the qualifications that a candidate for elective public office must possess. Seconds 42, LGC. Miguel did not possess that qualification because he was a permanent resident of the United States and he resided in Bolinao for a period of only 3 months after his return to the Philippines in November 1987 and before he ran for mayor of that municipality on January 18, 1988. In banning from elective public office Philippine citizens who are permanent residents or immigrants of a foreign country, The Omnibus Election Code has laid down a clear policy of excluding from the right to hold elective public office those Philippine citizens who possess dual loyalties and allegiance. The law has reserved that privilege for its citizens who have cast their lot with our country without mental reservations or purpose of evasion. The assumption is that those who are resident aliens of a foreign country are incapable of such entire devotion to the interest and welfare of their homeland, for with one eye on their public duties here, they must keep another eye on their duties under the laws of the foreign country of their choice in order to preserve their status as permanent residents thereof. Miguel insists that even though he applied for immigration and permanent residence in the United States, he never really intended to live there permanently, for all that he wanted was a green card to enable him to come and go to the U.S. with ease. In other words, he would have this court believe that he applied for immigration to the U.S. under false pretenses, that all this time he only had one foot in the United States but kept his other foot in the Philippines. Even if that were true, this court will not allow itself to be a party to his duplicity by permitting him to benefit from it, and giving him the best of both worlds, so to speak. Miguel's application for immigrant status and permanent residence in the U.S. and his possession of a green card attesting to such status are conclusive proof that he is a permanent resident of the U.S. Despite his occasional visits to the Philippines, the waiver of such immigrant status should be as indubitable as his application for it. Absent clear evidence that he made an irrevocable waiver of that status or that he surrendered his green card to the appropriate U.S. authorities before he ran for mayor of Bolinao in the local elections on January 18, 1988, our conclusion is that he was disqualified to run for said public office, hence, his election thereto was null and void. Marquez v. Cumlic. Facts: it is averred that at the time respondent Rodriguez filed his certificate of candidacy, a criminal charge against him for 10 counts of insurance fraud or grand theft of personal property was still pending before the Municipal Court of Los Angeles, USA. A warrant issued by said court for his arrest, it is claimed, has yet to be served on private respondent on account of his alleged flight from that country. Before the May 1992 elections, a petition for cancellation of respondent's certificate of candidacy on the ground of the candidate's disqualification was filed by petitioner, but Cumlic dismissed the petition. Private respondent was proclaimed governor-elect of Quezon. Petitioner instituted quo warranto proceedings against private respondent before the Cumlic, but the latter dismissed the petition. Issue whether private respondent, who at the time of the filing of his certificate of candidacy is said to be facing a criminal charge before a foreign court and evading a warrant of arrest, comes within the term fugitive from justice. Held, the Supreme Court ruled that Article 73 of the Rules and Regulations implementing the Local Government Code of 1991 provides. Article 73. Disqualifications: the following persons shall be disqualified from running for any elective local position. XXXX fugitives from justice in criminal or non-political cases here or abroad. Fugitive from justice refers to a person who has been convicted by final judgment. It is clear from this provision that fugitives from justice refer only to persons who has been convicted by final judgment. However, Cumlic did not make any definite finding on whether or not private respondent is a fugitive from justice when it outrightly denied the petition for quo warranto. The court opted to remand the case to Cumlic to resolve and proceed with the case. The Oversight Committee evidently entertained serious apprehensions on the possible constitutional infirmity of Section 40 of RA 7160 if the disqualification therein meant were to be so taken as to embrace those who merely were facing criminal charges. A similar concern was expressed by Senator R.A.V. Sigwisig, who, during the bicameral conference committee of the Senate and the House of Representatives, made this reservation. De IPA refine lang natin yung language, especially yung, the scope of fugitive. Me dio bothered ako dun, a. The Oversight Committee finally came out with Article 73 of the Rules and Regulations implementing the Local Government Code of 1991. It provided Art. 73 Disqualifications. The following persons shall be disqualified from running for any elective local position. Fugitives from justice in criminal or non-political cases here or abroad. Fugitive from justice refers to a person who has been convicted by final judgment. Private respondent reminds us that the construction placed upon law by the officials in charge of its enforcement deserves great and considerable weight. The court certainly agrees, however, when there clearly is no obscurity and ambiguity in an enabling law, it must merely be made to apply as it is so written. An administrative rule or regulation can neither expand nor constrict the law but must remain congruent to it. The court believes and thus holds, albeit with some personal reservations of the ponent, that Article 73 of the Rules and Regulations implementing the Local Government Code of 1991, to the extent that it confines the term fugitive from justice to refer only to a person who has been convicted by final judgment, is an inordinate and undue circumscription of the law. Unfortunately, the Cumlock did not make any definite finding on whether or not, in fact, private respondent is a fugitive from justice, as such term must be interpreted and applied in the light of the court's opinion. The omission is understandable since the Cumlock dismissed outrightly the petition for quo warranto on the basis instead of Rule 73 of the Rules and Regulations promulgated by the Oversight Committee. The court itself, not being a trier of facts, is thus constrained to remand the case to the Cumlock for a determination of this unresolved factual matter. Davide, concurring. The term fugitive from justice refers not only to those who flee after conviction to avoid punishment but also to those who, after being charged, flee to avoid prosecution. In his ponencia, Mr. Justice Jose C. Vidig finds the definition given to it by the Oversight Committee, i.e., a person who has been convicted by final judgment, as appearing in Article 73 of the Rules and Regulations implementing the Local Government Code of 1991, as inordinate and as undue circumscription of the law. I agree. But this is only one side of the coin. I further submit that it also unreasonably expands the scope of the disqualification in the 1991 Local Government Code because it disqualifies all those who have been convicted by final judgment, regardless of the extent of the penalty imposed and of whether they have served or are serving their sentences or have evaded service of sentence by jumping bail or leaving for another country. The definition thus disregards the true and accepted meaning of the word fugitive. This new definition is unwarranted, for nothing in the legislative debates has been shown to sustain it, and the clear language of the law leaves no room for a re-examination of the meaning of the term. I do not share the doubt of Mr. Justice Vidig on the constitutionality of the disqualification based on the presumption of innocence clause of the Bill of Rights. There are certain fundamental considerations which do not support the applications of the presumption. Firstly, Section 1. Article V of the Constitution recognizes the authority of Congress to determine who are disqualified from exercising the right of suffrage. Since the minimum requirement of a candidate for a public office is that he must be a qualified voter, it logically follows that Congress has the plenary power to determine who are disqualified to seek election for a public office. Secondly, a public office is a public trust. Thirdly, the disqualification in question does not, in reality, involve the issue of presumption of innocence. Elsewise stated, one is not disqualified because he is presumed guilty by the filing of an information or criminal complaint against him. He is disqualified because he is a fugitive from justice, i.e., he was not brought within the jurisdiction of the court because he had successfully evaded arrest, or if he was brought within the jurisdiction of the court and was tried and convicted. He has successfully evaded service of sentence because he had jumped bail or escaped. The disqualification then is based on his flight from justice, in the face of the settled doctrine that flight is an indication of guilt. It may even be truly said that it is not the challenged disqualifying provision which overcomes the presumption of innocence but rather the disqualified person himself who has proven his guilt. Rodriguez v. Cumlock. Facts: the petitioner Eduardo T. Rodriguez was a candidate for governor in the province of Quezon in the May 8, 1995 elections. His rival candidate for the said position was Bienvenido O Marquez, Jr. Herein private respondent. Private respondent filed a petition for disqualification before the Cumlic based principally on the allegation that Rodriguez is a fugitive from justice. Private respondent revealed that a charge for fraudulent insurance claims, grand theft, and attempted grand theft of personal property is pending against the petitioner before the Los Angeles Municipal Court. Rodriguez is therefore a fugitive from justice, which is a ground for his disqualification/ineligibility under Section 40 of the Local Government Code according to Marquez. Rodriguez, however, submitted a certification from the Commission of Immigration showing that Rodriguez left the U.S. on June 25, 1985, roughly 5 months prior to the institution of the criminal complaint filed against him before the Los Angeles court. The Cumlic complied therewith by filing before the court, on December 26, 1995, a report entitled Evidence of the Parties and Commission's Evaluation, wherein the Cumlic, after calibrating the parties' evidence, declared that Rodriguez is not a fugitive from justice as defined in the main opinion in the Marquez decision, thus making a 180-degree turnaround from its finding in the consolidated resolution. In arriving at this new conclusion, the Cumlic opined that intent to evade is a material element of the Marquez decision definition. Such intent to evade is absent in Rodriguez's case because evidence has established that Rodriguez arrived in the Philippines long before the criminal charge was instituted in the Los Angeles court. But the Cumlic report did not end there. The poll body expressed what it describes as its persistent discomfort on whether it read and applied correctly the Marquez decision definition of fugitive from justice. Issue: whether or not Rodriguez is a fugitive from justice. Held no. The Supreme Court reiterated that a fugitive from justice includes not only those who flee after conviction to avoid punishment but likewise who, being charged, flee to avoid prosecution. The definition thus indicates that the intent to evade is the compelling factor that animates one's flight from a particular jurisdiction. And obviously, there can only be an intent to evade prosecution or punishment when there is knowledge by the fleeing subject of an already instituted indictment or of a promulgated judgment of conviction. The definition thus indicates that the intent to evade is the compelling factor that animates one's flight from a particular jurisdiction. And obviously, there can only be an intent to evade prosecution or punishment when there is knowledge by the fleeing subject of an already instituted indictment, or of a promulgated judgment of conviction. Rodriguez's case just cannot fit in this concept. There is no dispute that his arrival in the Philippines from the U.S. on June 25, 1985, as per certifications issued by the Bureau of Immigrations dated April 27, 3 and June 26 of 1995, preceded the filing of the felony complaint in the Los Angeles court on November 12, 1985 and of the issuance on even date of the arrest warrant by the same foreign court, by almost 5 months. It was clearly impossible for Rodriguez to have known about such felony complaint and arrest warrant at the time he left the U.S., as there was in fact no complaint and arrest warrant, much less conviction to speak of yet at such time. What prosecution or punishment then was Rodriguez deliberately running away from with his departure from the U.S.? The very essence of being a fugitive from justice, under the Marquez decision definition, is just nowhere to be found in the circumstances of Rodriguez. The circumstantial fact that it was 17 days after Rodriguez's departure that charges against him were filed cannot overturn the presumption of good faith in his favor. The same suggests nothing more than the sequence of events which transpired. A subjective fact as that of petitioner's purpose cannot be inferred from the objective data at hand in the absence of further proof to substantiate such claim. In fact, the evidence of Rodriguez sufficiently proves that his compulsion to return to the Philippines was due to his desire to join and participate vigorously in the political campaigns against former President Marcos. For indeed, not long after petitioner's arrival in the country, the upheaval wrought by the political forces and the avalanche of events which occurred resulted in one of the more colorful events in the Philippine history. And being a figure in these developments, Rodriguez began serving his home province as OIC board member of the Sangguniang Panlalawigan ng Quezon in 1986. Then, he was elected governor in 1988 and continues to be involved in politics in the same capacity as re-elected governor in 1992 and the disputed re-election in 1995. Altogether, these landmark dates hem in for petitioner a period of relentless, intensive and extensive activity of varied political campaigns, first against the Marcos government, then for the governorship. And serving the people of Quezon province as such, the position entails absolute dedication of one's time to the demands of the office. Having established petitioner's lack of knowledge of the charges to be filed against him at the time he left the United States, it becomes immaterial under such construction to determine the exact time when he was made aware thereof. While the law, as interpreted by the Supreme Court, does not countenance flight from justice in the instance that a person flees the jurisdiction of another state after charges against him or a warrant for his arrest was issued, or even in view of the imminent filing and issuance of the same, petitioner's plight is altogether a different situation. When, in good faith, a person leaves the territory of a state not his own, homeward bound, and learns subsequently of charges filed against him while in the relative peace and service of his own country, the fact that he does not subject himself to the jurisdiction of the former state does not qualify him outright as a fugitive from justice. However, Marquez and the Cumlic seem to urge the court to redefine fugitive from justice. They espouse the broader concept of the term and culled from foreign authority cited in the Marquez decision itself, i.e., that one becomes a fugitive from justice by the mere fact that he leaves the jurisdiction where a charge is pending against him, regardless of whether or not the charge has already been filed at the time of his flight. Suffice it to say that the law of the case doctrine forbids the court to craft an expanded redefinition of fugitive from justice, and proceed therefrom in resolving the instant petition. The various definitions of that doctrine have been laid down in People v. Pinuila. To elaborate, the same parties and issue are involved in the Marquez decision and the instant petition. The Marquez decision was an appeal from EPC No. 92-28. The instant petition is also an appeal from EPC No. 92-28, although the Cumlic resolved the latter jointly with SPA No. 95-089, Marquez. Petition for the disqualification of Rodriguez. Therefore, what was irrevocably established as the controlling legal rule in the Marquez decision must govern the instant petition. And we specifically refer to the concept of fugitive from justice as defined in the main opinion in the Marquez decision, which highlights the significance of an intent to evade, but which Marquez and the Cumlic, with their proposed expanded definition, seem to trivialize. Besides, to redefine fugitive from justice would only foment instability in our jurisprudence when hardly has the ink dried in the Marquez decision. Torres, Jr., petitioner returned to the Philippines from the United States on June 25, 1985, while the criminal complaint against him for fraudulent insurance claims, grand theft and attempted grand theft of personal property was filed almost 5 months later, or on November 12, 1985. Verily, it cannot be said that he fled to avoid prosecution, for at the time he left the United States, there was yet no case or prosecution to avoid. That petitioner did not know of the imminent filing of charges against him and that he did not flee to avoid prosecution are bolstered by the facts that, 1. He returned to the United States twice, on August 14 and October 7 of the same year, but arrived in the Philippines on October 26 likewise in the same year. 2. He left his wife in the United States, and 3. His wife was later on arrested for the same. Charges. Had petitioner been aware of the imminent filing of charges against him, he would never have returned to the United States and he would not have left his wife in there. Petitioner is a citizen of this country. Why should he not come home? Coming home to the Philippines was the most natural act of the petitioner, who happens to maintain his residence in the country. The fact that he remains here even after he was formally accused cannot be construed as an indication of an intent to flee, there being no compelling reason for him to go to the United States and face his accusers. On the contrary, it is his official duty, as an incumbent governor of Quezon, to remain in the country and perform his duties as the duly elected public official. Fugitive from justice must be given a meaning in the instant case having regard to the circumstances and the time it is used. Philosophers and jurists have tried unsuccessfully at an exact definition of such an abstruse term as justice. Unfortunately, whether in the metaphysical sense or otherwise, the question of justice is still unanswered as it ever was, albeit characterized by secular skepticism. If the question is asked, what standard of justice should we enforce? The American sense of justice or the Philippine sense of justice? Undoubtedly, the forum in which it is raised should be controlling. By way only of hypothesis, if an American flees to escape from Philippine laws to the United States, may we enforce in the United States our standard of justice based on Philippine laws? I am tempted to ask these questions considering our zealousness to solve legal problems in the light of laws obtaining in the United States. At any rate, an accused charged with a crime in the Philippines cannot be a candidate and at the same time flee from prosecution. Once he goes campaigning, his opponent would have him arrested. For this and the reasons above discussed, the provision on disqualification of fugitive from justice, being unnecessary and serving only to undermine one's constitutional right to equal access to opportunities for public service, should even be scantily considered. Finally, petitioner appears to have garnered 285,202 votes. According to the election results, petitioner won over private respondent by a majority of 140,000 votes more or less. As it is, to disqualify petitioner on the shaky ground of being a fugitive from justice would amount to disenfranchising the electorate in whom sovereignty resides. De la Torre v. Cumlic. Facts: Rolando P. de la Torre filed an instant petition for certiorari seeks the nullification of resolutions issued by the Commission on Elections allegedly with grave abuse of discretion amounting to lack of jurisdiction in a case for disqualification filed against him before the Cumlic. The first assailed resolution dated May 6, 1995 declared de la Torre disqualified from running for the position of mayor of Cavinti, Laguna in the May 8, 1995 elections, citing as the ground therefore, Section 40 of RA 7160, i.e. those sentenced by final judgment for an offence involving moral turpitude or for an offence punishable by 1 year or more of imprisonment within 2 years after serving sentence. The other is the denial of the motion for reconsideration. Issue: whether the crime of fencing involves moral turpitude. Held a crime involving moral turpitude is one which is an act of baseness, vileness, or depravity in the private duties which a man owes his fellow men, or to society in general. Contrary to the accepted and customary rule of right and duty between man and woman, or conduct contrary to justice, honesty, modesty, or good morals. The elements of the crime of fencing are: a crime of robbery or theft has been committed, the accused who is not a principal or accomplice in the crime of robbery or theft, buys, receives, possesses, keeps, acquires, conceals, sells or disposes, or buys and sells, or in any manner deals in any article, item, object or anything of value, which have been deprived from the proceeds of the said crime. The accused knows or should have known that the said article, item, object or anything of value has been derived from the proceeds of the crime of robbery or theft, and there is, on the part of the accused, intent to gain for himself or for another. Moral turpitude is deducible from the third element. Actual knowledge by the fence of the fact that property received is stolen displays the same degree of malicious deprivation of one's rightful property as that which animated the robbery or theft which, by their very nature, are crimes of moral turpitude. Thus, the cumlock did not err in disqualifying the petitioner on the ground that the offence of fencing of which he had been previously convicted by final judgment was one involving moral turpitude. Moral turpitude is deducible from the third element. Actual knowledge by the fence of the fact that good morals, the duty not to appropriate, or to return anything acquired either by mistake or with malice is so basic it finds expression in some key provisions of the Civil Code on Human Relations and Solutio Indebiti. Verily, circumstances normally exist to forewarn, for instance, a reasonably vigilant buyer that the object of the property received is stolen displays the same degree of malicious deprivation of one's rightful property as that which animated the robbery or theft which, by their very nature, are crimes of moral turpitude. And although the participation of each felon in the unlawful taking differs in point in time and in degree, both the fence and the actual perpetrator/s of the robbery or theft invaded one's peaceful dominion for gain, thus deliberately reneging in the process private duties they owe their fellow men or society in a manner contrary to XXX accepted and customary rule of right and duty XXX, justice, honesty XXX or sale may have been derived from the proceeds of robbery or theft. Such circumstances include the time and place of the sale, both of which may not be in accord with the usual practices of commerce. The nature and condition of the goods sold, and the fact that the seller is not regularly engaged in the business of selling goods may likewise suggest the illegality of their source, and therefore should caution the buyer. This justifies the presumption found in Section 5 of PD number 1612 that mere possession of any goods, XXX, object or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing, a presumption that is, according to the court, reasonable, for no other natural or logical inference can arise from the established fact of XXX possession of the proceeds of the crime of robbery or theft. All told, the cumlock did not err in disqualifying the petitioner on the ground that the offence of fencing of which he had been previously convicted by final judgment was one involving moral turpitude. Anent the second issue, where petitioner contends that his probation had the effect of suspending the applicability of Section 40 of the Local Government Code. Suffice it to say that the legal effect of probation is only to suspend the execution of the sentence. Petitioner's conviction of fencing, which we have heretofore declared as a crime of moral turpitude and thus falling squarely under the disqualification found in Section 40, subsists and remains totally unaffected notwithstanding the grant of probation. In fact, a judgment of conviction in a criminal case ipso facto attains finality when the accused applies for probation, although it is not executory pending resolution of the application for probation. Clearly then, petitioner's theory has no merit. Magno v. Cumlock. Facts: this is a petition for the disqualification of Nestor Magno as mayoralty candidate of San Isidro, Nueva Ecija during the May 14, 2001 elections on the ground that petitioner was previously convicted by the Sandiganbayan of 4 counts of direct bribery. Thereafter, petitioner applied for probation and was discharged on March 5, 1998 upon order of the Regional Trial Court of Gapan, Nueva Ecija. The cumlock ruled that petitioner was disqualified from running for the position of mayor by virtue of Section 12 of BP 881. Crime involving moral turpitude, shall be disqualified to be a candidate and to hold any office, unless he has been given plenary pardon, or granted amnesty. According to the cumlock, inasmuch as petitioner was considered to have completed the service of his sentence on March 5, 1998, his 5-year disqualification will end only on March 5, 2003. The MR was denied the by cumlock. Issue 1. Direct bribery is a crime involving moral turpitude. Held yes ratio. Petitioner argues that direct bribery is not a crime involving moral turpitude. Likewise, he cites Section 40 of RA 7160, which he claims is the law applicable to the case at bar, not BP 881 or the Omnibus Election Code as claimed by the Cumlic. Said provision reads Section 40. Disqualifications. The following persons are disqualified from running for any elective local position: those sentenced by final judgment for an offence involving moral turpitude or for an offence punishable by 1 year or more of imprisonment within 2 years after serving sentence. Petitioner insists that he had already served his sentence as of March 5, 1998 when he was discharged from probation. Such being the case, the 2-year disqualification period imposed by Section 40 of the Local Government Code expired on March 5, 2000. Thus, petitioner was qualified to run in the 2001 elections. Moral turpitude is an act of baseness, vileness, or depravity in the private duties which a man owes his fellow men, or to society in general. Contrary to the accepted and customary rule of right and duty between man and woman, or conduct contrary to justice, honesty, modesty, or good morals. Not every criminal act, however, involves moral turpitude. It frequently depends on the circumstances surrounding the violation of the law. In this case, we need not review the facts and circumstances relating to the commission of the crime, considering that petitioner did not assail his conviction. By applying for probation, petitioner in effect admitted all the elements of the crime of direct bribery. The offender is a public officer. The offender accepts an offer or promise or receives a gift or present by himself or through another. Such offer or promise be accepted or gift or present be received by the public officer with a view to committing some crime, or in consideration of the execution of an act which does not constitute a crime but the act must be unjust, or to refrain from doing something which it is his official duty to do, and the act which the offender agrees to perform or which he executes is connected with the performance of his official duties. Moral turpitude can be inferred from the third element: the fact that the offender agrees to accept a promise or gift and deliberately commits an unjust act or refrains from performing an official duty in exchange for some favors. Denotes a malicious intent on the part of the offender to renege on the duties which he owes his fellow men and society in general. Also, the fact that the offender takes advantage of his office and position is a betrayal of the trust reposed on him by the public. It is a conduct clearly contrary to the accepted rules of right and duty, justice, honesty, and good morals. In all respects, direct bribery is a crime involving moral turpitude. Issue: what law should apply in this case? Held Local Government Code ratio. It is the second sub-issue which is problematical. There appears to be a glaring incompatibility between the 5-year disqualification period provided in Section 12 of the Omnibus Election Code and the 2-year disqualification period in Section 40 of the Local Government Code. It should be noted that the Omnibus Election Code was approved on December 3, 1985, while the Local Government Code took effect on January 1, 1992. It is basic in statutory construction that in case of irreconcilable conflict between two laws, the later enactment must prevail, being the more recent expression of legislative will. Legis posteriors prioris contractarius abrogant. In enacting the later law, the legislature is presumed to have knowledge of the older law and intended to change it. Furthermore, the repealing clause of Section 534 of RA 7160 or the Local Government Code states that all general and special laws, acts, city charters, decrees, executive orders, proclamations and administrative regulations, or part or parts thereof which are inconsistent with any provisions of this code are hereby repealed or modified accordingly. In accordance therewith, Section 40 of RA 7160 is deemed to have repealed Section 12 of BP 881. Furthermore, Article 7 of the Civil Code provides that laws are repealed only by subsequent ones, and not the other way around. When a subsequent law entirely encompasses the subject matter of the former enactment, the latter is deemed repealed. The intent of the legislature to reduce the disqualification period of candidates for local positions from 5 to 2 years is evident. The cardinal rule in the interpretation of all laws is to ascertain and give effect to the intent of the law. The reduction of the disqualification period from 5 to 2 years is the manifest intent. Therefore, although his crime of direct bribery involved moral turpitude, petitioner nonetheless could not be disqualified from running in the 2001 elections. Article 12 of the Omnibus Election Code must yield to Article 40 of the Local Government Code. Petitioner's disqualification ceased as of March 5, 2000, and he was therefore under no such disqualification anymore when he ran for mayor of San Isidro, Nueva Ecija in the May 14, 2001 elections. Unfortunately, however, neither this court nor this case is the proper forum to rule on the validity of Sonia Lorenzo's proclamation and the declaration of petitioner as the rightful winner. Inasmuch as Sonia Lorenzo had already been proclaimed as the winning candidate, the legal remedy of petitioner would have been a timely election protest. Lingating v. Kumlik. Facts: petitioner filed a petition for the disqualification of Solong, pursuant to 40 of RA 7160, which disqualifies from running for any elective local position those removed from office as a result of an administrative case. It appears that Solong had previously won as mayor of Lapuan on January 18, 1988. In the May 11, 1992, and again in the May 8, 1995 elections, he was re-elected. In a petition for disqualification, petitioner alleged that in 1991, during his first term as mayor of Lapuan, Solong, along with a municipal councillor of Lapuan and several other individuals, was administratively charged with various offences, and that, on February 4, 1992, the Sangguniang Panlalawigan of Sambuanga del Sur found him guilty of the charges and ordered his removal from office. Petitioner claimed that this decision had become final and executory, and consequently the then Vice Mayor of Lapuan, Vicente Iming, took his oath as mayor. The Kumlik was unable to render judgment before the elections. Rolong was voted for in the elections and he won as mayor. The Kumlik then rendered a decision declaring Solong disqualified as he was guilty of violating the Anti-Graft and Corrupt Practices Act. Solong filed an MR contending that the decision has not become final and executor as the final disposition thereof was overtaken by the local elections of May 1992. The Kumlik en banc, however, reversed. It ruled that while it is true that one of the disqualifications from running in an elective position is removal from office as a result of an administrative case, said provision no longer applies if the candidate whose qualification is questioned got re-elected to another term. The re-election of Solong in the 1992 and 1995 elections would be tantamount to a condonation of the Sangguniang Panlalawigan decision, which found him guilty of dishonesty, malversation of public funds, etc. Granting said decision has become final and executory. Moreover, the people of Lapuan have already expressed their will when they cast their votes in the recent elections, as evidenced by the results which found respondent Solong to have won convincingly. Issue: 1. Solong was entitled to occupy the office thus vacated. Held yes ratio, we stated in Reyes. Petitioner invokes the ruling in Aguinaldo v. Kumlik, in which it was held that a public official could not be removed for misconduct committed during a prior term and that his re-election operated as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore. But that was because in that case, before the petition questioning the validity of the administrative decision removing petitioner could be decided, the term of office during which the alleged misconduct was committed expired. Removal cannot extend beyond the term during which the alleged misconduct was committed. If a public official is not removed before his term of office expires, he can no longer be removed if he is thereafter re-elected another term. This is the rationale for the ruling in the two Aguinaldo cases. The case at bar is the very opposite of those cases. Here, the decision in the administrative case, was served on petitioner and it thereafter became final on April 3, 1995, because petitioner failed to appeal to the office of the President. He was thus validly removed from office and, pursuant to 40 of the Local Government Code, he was disqualified from running for re-election. It is noteworthy that at the time the Aguinaldo cases were decided there was no provision similar to 40 which disqualifies any person from running for any elective position on the ground that he has been removed as a result of an administrative case. The Local Government Code of 1991 could not be given retroactive effect. However, res cannot be applied to this case because it appears that the 1992 decision of the Sangguniang Panlalawigan, finding respondent Solong guilty of dishonesty, falsification and malversation of public funds, has not until now become final. The records of this case show that the Sangguniang Panlalawigan of Zamboanga del Sur rendered judgment in AC No. 12-91 on February 4, 1992, a copy of which was received by respondent Solong on February 17, 1992, that on February 18, 1992, he filed a motion for reconsideration and/or notice of appeal, that on February 27, 1992, the Sangguniang Panlalawigan required Jim Lingating, the complainant in AC No. 12-91, to comment, and that the complainant in AC No. 12-91 has not filed a comment nor has the Sangguniang Panlalawigan resolved respondent's motion. The filing of his motion for reconsideration prevented the decision of Sangguniang Panlalawigan from becoming final. While RA number 7160 on disciplinary actions is silent on the filing of a motion for reconsideration, the same cannot be interpreted as a prohibition against the filing of a motion for reconsideration. Thus, it was held that a party in a disbarment proceeding under Rule 139b, 12 can move for a reconsideration of a resolution of the Integrated Bar of the Philippines although Rule 139b does not so provide. Although Rule 139b 12 makes no mention of a motion for reconsideration, nothing in its text or history suggests that such motion is prohibited. It may therefore be filed. Indeed, the filing of such motion should be encouraged before resort to. As a matter of exhaustion of administrative remedies, to afford the agency rendering the judgment opportunity to correct any error it may have committed through a misapprehension of facts or misappreciation of evidence. There is thus no decision finding respondent guilty to speak of. As Provincial Secretary of Zamboanga del Sur Wilfredo C. Mafranca attested, the Sangguniang Panlalawigan simply considered the matter as having become moot and academic because it was overtaken by the local elections of May 1992. Neither can the succession of the then Vice Mayor of Lapuan, Vicente Iming, and the highest-ranking municipal councillor of Lapuan, Romeo Tan, to the offices of Mayor and Vice Mayor, respectively, be considered proof that the decision in AC No. 12-91 had become final because it appears to have been made pursuant to 68 of the Local Government Code, which makes decisions in administrative cases immediately executory. Indeed, considering the failure of the Sangguniang Panlalawigan to resolve respondent's motion, it is unfair to the electorate to be told after they have voted for respondent Solong that after all he is disqualified. Especially since, at the time of the elections on May 14, 2001, the decision of the Sangguniang Panlalawigan had been rendered nearly 10 years ago. Flores v. Drylan. Facts: the constitutionality of Sector 13, PAR, of RA 7227, otherwise known as the Bases Conversion and Development Act of 1992, under which Mayor Richard J. Gordon of Olongapo City was appointed Chairman and Chief Executive Officer of the Subic Bay Metropolitan Authority, is challenged in this original petition with prayer for prohibition, preliminary injunction, and temporary restraining order. Under said provision, for the first year of its operations from the effectivity of this Act, the Mayor of the City of Olongapo shall be appointed as the Chairman and Chief Executive Officer of the Subic Authority. Petitioners, as taxpayers, contend that said provision is unconstitutional as under the following constitutional and statutory provisions: Sector 7, 1st PAR, Art. IXB, of the Constitution, which states that no elective official shall be eligible for appointment or designation in any capacity to any public officer or position during his tenure. Because the city mayor of Olongapo City is an elective official and the subject posts are public offices, Sector 16, Art. 7, of the Constitution, which provides that he President shall appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. Since it was Congress through the questioned proviso and not the President who appointed the mayor to the subject posts, and Sector 261, PAR. of the Omnibus Election Code. Issue 1. The proviso in Sector 13, PAR. of RA 7227 violates the constitutional proscription against appointment or designation of elective officials to other government posts. Held yes ratio, the rule expresses the policy against the concentration of several public positions in one person, so that a public officer or employee may serve full-time with dedication and thus be efficient in the delivery of public services. It is an affirmation that a public office is a full-time job. Hence, a public officer or employee, like the head of an executive department described in Civil Liberties Union v. Executive Secretary, GR number 83896, and Anti-Graft League of the Philippines, Inc. v. Philip LSC Juco, as Secretary of Agrarian Reform, GR number 83815, should be allowed to attend to his duties and responsibilities without the distraction of other governmental duties or employment. He should be precluded from dissipating his efforts, attention and energy among too many positions of responsibility, which may result in haphazardness and inefficiency. In the case before us, the subject proviso directs the President to appoint an elective official, i.e., the Mayor of Olongapo City, to other government posts. Since this is precisely what the constitutional proscription seeks to prevent, it needs no stretching of the imagination to conclude that the proviso contravenes Sector 7, 1st PAR, Art. IXB, of the Constitution. Here, the fact that the expertise of an elective official may be most beneficial to the higher interest of the body politic is of no moment. It is argued that Sections 94 of the LGC permits the appointment of a local elective official to another post if so allowed by law or by the primary functions of his office. But, the contention is fallacious. Section 94 of the LGC is not determinative of the constitutionality of Sector 13, PAR. of RA 7227, for no legislative act can prevail over the fundamental law of the land. Moreover, since the constitutionality of Sections 94 of LGC is not the issue here nor is that section sought to be declared unconstitutional, we need not rule on its validity. Neither can we invoke a practice otherwise unconstitutional as authority for its validity. In any case, the view that an elective official may be appointed to another post if allowed by law or by the primary functions of his office ignores the clear-cut difference in the wording of the two paragraphs of Sector 7, Art. IXB, of the Constitution. While the second paragraph authorizes holding of multiple offices by an appointive official when allowed by law or by the primary functions of his position. The first paragraph appears to be more stringent by not providing any exception to the rule against appointment or designation of an elective official to the government post, except as are particularly recognized in the Constitution itself, e.g. the President as head of the Economic and Planning Agency, the Vice President, who may be appointed member of the Cabinet, and a member of Congress who may be designated ex officio member of the Judicial and Bar Council. It is further argued that the SBMA posts are merely ex officio to the position of Mayor of Olongapo City, hence, an accepted circumstance, citing Civil Liberties Union v. Executive Secretary, where we stated that the prohibition against the holding of any other office or employment by the President, Vice President, members of the Cabinet, and their deputies or assistants during their tenure, as provided in Sector 13, Art. 7, of the Constitution, does not comprehend additional duties and functions required by the primary functions of the officials concerned, who are to perform them in an ex officio capacity as provided by law, without receiving any additional compensation therefor. This argument is apparently based on a wrong premise. Congress did not contemplate making the subject SBMA posts as ex officio or automatically attached to the office of the Mayor of Olongapo City without need of appointment. The phrase "shall be appointed" unquestionably shows the intent to make the SBMA posts appointive and not merely adjunct to the post of Mayor of Olongapo City. Had it been the legislative intent to make the subject positions ex officio, Congress would have, at least, avoided the word appointed. And, instead, ex officio would have been used. Even in the Senate deliberations, the senators were fully aware that subject proviso may contravene Sector 7, First PAR, Art. IXB, but they nevertheless passed the bill and decided to have the controversy resolved by the courts. Indeed, the senators would not have been concerned with the effects of Sector 7, First PAR, had they considered the SBMA posts as ex officio. Cognizant of the complication that may arise from the way the subject proviso was stated, Senator René Seguisig remarked that if the conference committee just said the mayor shall be the chairman, then that should foreclose the issue. It is a legislative choice. The senator took a view that the constitutional prescription against appointment of elective officials may have been sidestepped if Congress attached the SBMA posts to the Mayor of Olongapo City instead of directing the President to appoint him to the post. Without passing upon this view of Senator Seguisig, it suffices to state that Congress intended the posts to be appointive, thus nibbling in the bud the argument that they are ex officio. Petitioners also assail the legislative encroachment on the appointing authority of the President. Section 13, PAR, itself vests in the President the power to appoint the Chairman of the Board and the Chief Executive Officer of SBMA, although he really has no choice under the law but to appoint the Mayor of Olongapo City. As may be defined, an appointment is he designation of a person, by the person or persons having authority therefor, to discharge the duties of some office or trust, or he selection or designation of a person, by the person or persons having authority therefor, to fill an office or public function and discharge the duties of the same. In his treatise, Philippine Political Law, Senior Associate Justice Isagani A. Cruz defines appointment as the selection, by the authority vested with the power, of an individual who is to exercise the functions of a given office. Considering that appointment calls for a selection, the appointing power necessarily exercises a discretion. Indeed, the power of choice is the heart of the power to appoint. Appointment involves an exercise of discretion of whom to appoint. It is not a ministerial act of issuing appointment papers to the appointee. In other words, the choice of the appointee is a fundamental component of the appointing power. Hence, When Congress clothes the President with the power to appoint an officer, it cannot at the same time limit the choice of the President to only one candidate. Once the power of appointment is conferred on the President, such conferment necessarily carries the discretion of whom to appoint. Even on the pretext of prescribing the qualifications of the officer, Congress may not abuse such power as to divest the appointing authority, directly or indirectly, of his discretion to pick his own choice. Consequently, when the qualifications prescribed by Congress can only be met by one individual, such enactment effectively eliminates the discretion of the appointing power to choose and constitutes an irregular restriction on the power of appointment. In the case at bar, while Congress willed that the subject posts be filled with a presidential appointee for the first year of its operations from the effectivity of R.A. 7227, the proviso nevertheless limits the appointing authority to only one eligible, i.e., the incumbent mayor of Olongapo City. Since only one can qualify for the posts in question, the President is precluded from exercising his discretion to choose whom to appoint. Such supposed power of appointment, sans the essential element of choice, is no power at all and goes against the very nature itself of appointment. While it may be viewed that the proviso merely sets the qualifications of the officer during the first year of operations of SBMA, i.e., he must be the mayor of Olongapo City, it is manifestly an abuse of congressional authority to prescribe qualifications where only one, and no other, can qualify. Where, as in the case of Gordon, an incumbent elective official was, notwithstanding his ineligibility, appointed to other government posts, he does not automatically forfeit his elective office nor remove his ineligibility imposed by the Constitution. On the contrary, since an incumbent elective official is not eligible to the appointive position, his appointment or designation thereto cannot be valid in view of his disqualification or lack of eligibility. As incumbent elective official, Respondent Gordon is ineligible for appointment to the position of Chairman of the Board and Chief Executive of SBMA, hence his appointment thereto pursuant to a legislative act that contravenes the Constitution cannot be sustained. He however remains mayor of Olongapo City, and his acts as SBMA official are not necessarily null and void. He may be considered a de facto officer, one whose acts, though not those of a lawful officer, the law, upon principles of policy and justice, will hold valid so far as they involve the interest of the public and third persons, where the duties of the office were exercised under color of a known election or appointment, void because the officer was not eligible, or because there was a want of power in the electing or appointing body, or by reason of some defect or irregularity in its exercise. Such ineligibility, want of power or defect being unknown to the public, under color of an election, or appointment, by or pursuant to a public unconstitutional law, before the same is adjudged to be such. Election cases involving local elective officials. Galido v. Cumlick. Facts: Galido and private respondent Gallion were candidates during the January 1988 local elections for mayor of Garcia Hernandez, Bohol. Petitioner was proclaimed the duly elected mayor. Private respondent filed an election protest before the RDC. After hearing, the said court upheld the proclamation of petitioner. Private respondent appealed the RDC decision to the Cumlick. Its first division reversed the RDC decision and declared private respondent the duly elected mayor. After the Cumlick en banc denied the petitioner's motion for reconsideration and affirmed the decision of its first division. The Cumlick held that the 15 ballots in the same precinct containing the initial C after the name Galido were marked ballots and, therefore, invalid. Undaunted by his previous failed actions, the petitioner filed the present petition for certiorari and injunction before the Supreme Court and succeeded in getting a temporary restraining order. In his comment to the petition, private respondent moved for dismissal, citing Article 9, Section 2, Paragraph 2 of the 1987 Constitution, that final decisions Orders or rulings of the Cumlic in election contests involving elective municipal offices are final and executory, and not appealable. Issue: whether or not a Cumlic decision may, if it sets aside the trial court's decision involving marked ballots, be brought to the Supreme Court by a petition for certiorari by the aggrieved party. Held, yes. Ratio: the fact that decisions, final orders, or rulings of the Cumlic in contests involving elective municipal and barangay offices are final, executory and not appealable, does not preclude a recourse to this court by way of a special civil action of certiorari. Under Article 9, Section 7 of the Constitution, which petitioner cites, it is stated, unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt thereof. We resolve this issue in favor of the petitioner. The petition involves pure questions of fact as they relate to appreciation of evidence which is beyond the power of review of this court. The Cumlic found that the writing of the letter C after the word Galado in the 15 ballots of Precinct 14 is a clear and convincing proof of a pattern or design to identify the ballots and/or voters. This finding should be conclusive on the court. The Commission on Elections has exclusive original jurisdiction over all contests relating to the elections, returns, and qualifications of all elective regional, provincial, and city officials, and has appellate jurisdiction over all contests involving elective municipal officials decided by trial courts of general jurisdiction or involving elective barangay officials decided by trial courts of limited jurisdiction. Section 2, Paragraph 1 of the 1987 Constitution. In the present case, after a review of the trial court's decision, the respondent Cumlic found that 15 ballots in the same precinct containing the letter C after the name Galado are clearly marked ballots. May this Cumlic decision be brought to this court by a petition for certiorari by the aggrieved party? Under Article 9, Section 7 of the Constitution, which petitioner cites in support of this petition, it is stated, unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. On the other hand, private respondent relies on Article 9, Section 2, Paragraph 2 of the Constitution, which provides that decisions, final orders, or rulings of the Commission on Elections in contests involving elective municipal and barangay offices shall be final, executory, and not appealable. We resolve this issue in favor of the petitioner. The fact that decisions, final orders, or rulings of the Commission on Elections in contests involving elective municipal and barangay offices are final, executory and not appealable, does not preclude a recourse to this court by way of a special civil action of certiorari. The proceedings in the Constitutional Commission on this matter are enlightening. We do not, however, believe that the Cumlic committed grave abuse of discretion amounting to lack or excess of jurisdiction in rendering the questioned decision. It is settled that the function of a writ of certiorari is to keep an inferior court or tribunal within the bounds of its jurisdiction or to prevent it from committing a grave abuse of discretion amounting to lack or excess of jurisdiction. As correctly argued by the Cumlic, it has the inherent power to decide an election contest on physical evidence, equity, law, and justice, and apply established jurisprudence in support of its findings and conclusions, and that the extent to which such precedents apply rests on its discretion, the exercise of which should not be controlled unless such discretion has been abused to the prejudice of either party. Finally, the records disclose that private respondent had already assumed the position of Mayor of Garcia Hernandez as the duly elected mayor of the municipality by virtue of the Cumlic decision. The main purpose of prohibition is to suspend all action and prevent the further performance of the act complained of. In this light, the petition at bar has become moot and academic. Facts: Juan Garcia Rivera and Juan Mitre Garcia II were candidates for the position of mayor of Guinobatan, Albay, during the local elections in January 1988. The Municipal Board of Canvassers proclaimed Rivera as the duly elected mayor by a majority of 10 votes. Garcia filed an election protest with the RDC, which rendered its verdict finding Garcia to have obtained 6,376 votes as against Rivera's 6,222. On appeal to the Cumlic sustained with modification the judgment. It ruled that Juan Garcia was the duly elected municipal mayor by a majority of 153 votes over Juan Rivera instead of plurality of 154 votes. Upon MR, the Cumlic affirmed the decision. Garcia commenced to discharge the duties and functions of mayor of Guinobatan on October 10, 1990, by virtue of a writ of execution implementing the Cumlic decision of September 6, 1990. He continued as mayor until November 10, 1990, when he was served notice of this court's temporary restraining order, issued upon Rivera's motion. In this petition, Rivera prayed for the issuance of a restraining order, arguing that the judgment had not yet become final and executory. He cites Article IXC, Section 2, PAR of the 1987 Constitution, in relation to Part 7, Rule 39, Section 1 of the Cumlic Rules of Procedure. He also contends that since the Cumlic decision has not yet become final and executory, the Cumlic has no authority to issue the assailed order and writ of execution. Petitioner maintains further that he has a period of 30 days from September 6, 1990 or until October 6, 1990 within which to elevate the Cumlic decision, on certiorari, to this court, pursuant to Section 1. Rule 39 of the Cumlic Rules of Procedure. He submits that the questioned Cumlic decision is not one that became final and executory unless restrained by this court as provided under Section 3, Rule 39 of the Cumlic Rules. As said rule applies only to decisions in pre-proclamation cases and petitions to deny due course or to disqualify a candidate, and postpone or suspend elections. Lastly, according to petitioner, Section 13 of Rule 18 and Section 1 of Rule 39, review by the Supreme Court of Cumlic decisions. Orders and rulings, of the Cumlic Rules of Procedure, should be read in the context of Section 7, Article IXA of the Constitution. Garcia contends that the Constitution declares that the Cumlic decision on election contests involving elective municipal and barangay officials are to be final, executor and not appealable. Issue 1. The decisions of the Cumlic in election contests involving elective municipal and barangay officials, being final and executory and not appealable, preclude the filing of a special civil action of certiorari. Held yes ratio, under Article 9, Section 7 of the Constitution, which petitioner cites in support of this petition, it is stated, unless otherwise provided by the Constitution or by law, any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. On the other hand, private respondent relies on Article 9, Section 2, Paragraph 2 of the Constitution, which provides that decisions, final orders, or rulings of the Commission on Elections in contests involving elective municipal and barangay offices shall be final, executory and not appealable. We resolve this issue in favor of the petitioner. The fact that decisions, final orders, or rulings of the Commission on Elections in contests involving elective municipal and barangay offices are final, executory and not appealable does not preclude a recourse to this court by way of a special civil action of certiorari. The proceedings in the Constitutional Commission on this matter are enlightening. Flores vs. Cumlic, obviously, the provision of Article IXC, Section 2 of the Constitution that decisions, final orders, or rulings of the Commission on Election contests involving elective municipal and barangay offices shall be final, executory, and not appealable applies only to questions of fact and not of law. That provision was not intended to divest the Supreme Court of its authority to resolve questions of law as inherent in the judicial power conferred upon it by the Constitution. We eschew a literal reading of that provision that would contradict such authority. Actually, the main thrust of the present petition for certiorari is that the Cumlic and Bank committed grave abuse of discretion when it affirmed the decision of its First Division, promulgated on May 2, 1990. Annulling the proclamation of the petitioner as the duly elected mayor of Guinobaton, Albay, and when it did not exclude from the total votes of Garcia at least 10 votes which were allegedly misappreciated in Garcia's favor. We have closely scrutinized the challenged Cumlic decision and find that the said decision was not arrived at capriciously or whimsically by respondent Cumlic. A painstaking re-evaluation of the question 67 ballots was made by the Cumlic and Bank. In fact, 14 ballots originally adjudicated in Garcia's favor were overruled by the Commission and Bank, thus reducing the number of votes in his favor to 894 votes out of the 2,445 contested ballots. On the other hand, 16 ballots were added in Rivera's favor, thus increasing the votes in his favor to 1,087 votes. Moreover, the appreciation and re-evaluation of ballots are factual determinations. It is settled that in a petition for certiorari, findings of fact of administrative bodies are final unless grave abuse of discretion has marred such factual determinations. We find none in this case. Regalado, concurring, what the foregoing observations actually boil down to is that the decisions, orders, or rulings of said constitutional commissions are not subject to appellate review, that is, with this court acting in the exercise of appellate jurisdiction and exercising its power of review over alleged errors of law and, sometimes, of fact or both. Such decisions, orders, or rulings are not, however, invulnerable to an original civil action of certiorari, prohibition, or mandamus invoking the original jurisdiction of this court. Under its power of control and supervision over the lower courts, to pass upon errors of jurisdiction imputed to said commissions. This is inevitable and justified because no appeal or any other plain, speedy or adequate remedy in the ordinary course of law lies from said adjudications. Narvaeza, dissenting, it bears stressing that the final, executory and unappealable character of the Cumlic's rulings, orders, or decisions in election contests involving elective municipal and barangay offices is pronounced not by statute or presidential issuance, but by the Constitution itself. This is a relevant consideration because while Congress is granted by Section 2, Article 8 of the Constitution the power to define, prescribe, and apportion the jurisdiction of the various courts, may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 of the same Article 8, and said Section 5 declares it to be one of the powers of the Supreme Court to review, reverse, modify, or affirm on appeal or certiorari, as the law or the rules of court may provide, final judgments and orders of lower courts in. It is in truth this fundamental limitation on the legislative prerogative to define, prescribe, and apportion the jurisdiction of courts which is that the Supreme Court may not be deprived by law of jurisdiction over certain particular cases that underlay this court's doctrines allowing review by the special civil action of certiorari under Rule 65 of Judgments and final orders of the National Labor Relations Commission under the Labor Code, and the Central Board of Assessment Appeals, from which no appeal is prescribed by law. It cannot be gainsaid, however, that while Congress may not deprive the Supreme Court of its constitutionally stated powers, that self-same Constitution may itself effect that deprivation. And this appears to be precisely the purpose and intent of said Section 2, Article IXC of the Constitution as written, to remove from this Court's power to review, revise, reverse, modify, or affirm on appeal or certiorari final judgments and orders of the Cumlic in election contests involving elective municipal and barangay offices. Rivera v. Cumlic. Facts: in the May 2004 synchronized national and local elections, Marino Morales ran as candidate for mayor of Mabalacat. On January 5, 2004, he filed his certificate of candidacy. On January 10, petitioners filed before the Cumlic a petition to cancel Morales' certificate of candidacy on the ground that the was elected and had served 3 previous consecutive terms as mayor of Mabalacat, contrary to RA 43 of RA 7160. Morales admitted that he was elected mayor of Mabalacat for the term commencing July 1, 1995 to June 30, 1998 and July 1, 2001 to June 30, 2004, but he served the second term from July 1, 1998 to June 30, 2001 only as a caretaker of the office or as a de facto officer. Because he was not validly elected, as his proclamation as mayor was declared void by the RDC and thereafter, he was preventively suspended by the Ombudsman. The Cumlic ruled that Morales was disqualified to run for public office. Morales' MR was however granted. The Cumlic ruled that his proclamation before was void and that the discharge of the duties is that of a de facto mayor. In the other case filed by Anthony D., after Morales was proclaimed as the duly elected mayor, Anthony D. filed a petition for quo warranto before the RDC. D. reiterated the previous arguments of petitioners. The RDC dismissed D's petition for quo warranto on the ground that Morales did not serve the 3-term limit since he was not the duly elected mayor of Mabalacat, but D. in the May 1998 elections for the term 1998 to 2001. Cumlic affirmed. Issue 1. Morales is disqualified from running for mayor. Held yes ratio. This court, through Mr. Justice Cancio C. Garcia, resolved the same issue in Ong v. Allegra with identical facts, thus. For the 3-term limit for elective local government officials to apply, 2 conditions or requisites must concur, to wit, that the official concerned has been elected for 3 consecutive terms in the same local government post, and that he has fully served 3 consecutive terms. We hold that such assumption of office constitutes, for Francis, service for the full term, and should be counted as a full term served in contemplation of the 3-term limit prescribed by the constitutional and statutory provisions. Supra, barring local elective officials from being elected and serving for more than 3 consecutive terms for the same position. It is true that the RDC et Camerons Norte ruled in election protest case number 6850, that it was Francis' opponent who won in the 1998 mayoralty race and, therefore, was the legally elected mayor of San Vicente. However, that disposition, it must be stressed, was without practical and legal use and value, having been promulgated after the term of the contested office has expired. Petitioner Francis' contention that he was only a presumptive winner in the 1998 mayoralty derby as his proclamation was under protest did not make him less than a duly elected mayor. His proclamation by the Municipal Board of Canvassers of San Vicente as the duly elected mayor in the 1998 mayoralty election, coupled by his assumption of office and his continuous exercise of the functions thereof from start to finish of the term, should legally be taken as service for a full term in contemplation of the 3-term rule. The absurdity and the deleterious effect of a contrary view is not hard to discern. Such contrary view would mean that Allegra would under the three-term rule be considered as having served a term by virtue of a veritably meaningless electoral protest ruling. When another actually served such term pursuant to a proclamation made in due course after an election. It bears stressing that in Ong v. Allegra cited above, Francis Ong was elected and assumed the duties of the mayor of San Vicente, Camarines Norte for 3 consecutive terms. But his proclamation as mayor in the May 1998 election was declared void by the RDC of Daet, Camarines Norte in its decision dated July 4, 2001. As ruled by this court, his service for the term 1998 to 2001 is for the full term. Clearly, the 3-term limit rule applies to him. Indeed, there is no reason why this ruling should not also apply to Respondent Morales, who is similarly situated. Here, Morales invoked not only Lanzanita v. Cumlic, but also Borgia, J.R. v. Commission on Elections, which is likewise inapplicable. In Borgia, the court held that Capco's assumption of the office of mayor upon the death of the incumbent may not be regarded as a term under Section 8, Article X of the Constitution and Section 43 of R.A. No. 7160. He held the position from September 2, 1989 to June 30, 1992, a period of less than 3 years. Moreover, he was not elected to that position. Similarly, in Adormio v. Cumlic, this court ruled that assumption of the office of mayor in a recall election for the remaining term is not the term contemplated under Section 8, Article X of the Constitution and Section 43 of R.A. No. 7160. As the court observed, there was a break in the service of private respondent Ramon T. Talanga as mayor. He was a private citizen for a time before running for mayor in the recall elections. Here, Morales was elected for the term July 1, 1998 to June 30, 2001. He assumed the position. He served as mayor until June 30, 2001. He was mayor for the entire period, notwithstanding the decision of the RDC in the electoral protest case filed by petitioner D. ousting him as mayor. To reiterate, as held in Ong v. Allegra, such circumstance does not constitute an interruption in serving the full term. Section 8, Article X of the Constitution cannot be more clear and explicit. Respondent Morales is now serving his 4th term. He has been mayor of Mabalacat continuously without any break since July 1, 1995. In just over a month, by June 30, 2007, he will have been mayor of Mabalacat for 12 continuous years. This court reiterates that the framers of the Constitution specifically included an exception to the people's freedom to choose those who will govern them in order to avoid the evil of a single person accumulating excessive power over a particular territorial jurisdiction as a result of a prolonged stay in the same office. To allow petitioner Latissa to vie for the position of city mayor after having served for 3 consecutive terms as municipal mayor would obviously defeat the very intent of the framers when they wrote this exception. Should he be allowed another 3 consecutive term as mayor of the city of Dagos, petitioner would then be possibly holding office as chief executive over the same territorial jurisdiction and inhabitants for a total of 18 consecutive years. This is the very scenario sought to be avoided by the Constitution, if not abhorred by it. This is the very situation in the instant case. Morales maintains that he served his 2nd term only as a caretaker of the office or as a de facto officer. Section 8, Article X of the Constitution is violated and its purpose defeated when an official serves in the same position for 3 consecutive terms. Whether as caretaker or de facto officer, he exercises the powers and enjoys the prerequisites of the office which enables him to stay on indefinitely. Morales should be promptly ousted from the position of mayor of Mabalacat. Having found Respondent Morales ineligible, his certificate of candidacy dated December 30, 2003 should be cancelled. In the light of the foregoing, Morales cannot be considered a candidate in the May 2004 elections. Not being a candidate, the votes cast for him should not be counted and must be considered stray votes. Since respondent Morales is disqualified from continuing to serve as mayor of Mabalacat, the instant petition for quo warranto has become moot. Issue 1. It is the vice mayor or petitioner D who shall serve for the remaining portion of the 2004 to 2007 term. Held yes ratio, in Labo v. Cumlick, this court has ruled that a second-place candidate cannot be proclaimed as a substitute winner. As a consequence of petitioner's ineligibility, a permanent vacancy in the contested office has occurred. This should now be filled by the vice mayor in accordance with Section 44 of the Local Government Code. Monteben v. Cumlick. Facts: Monteben, Ondoy and Potencioso, Jr. were candidates for municipal councillor of the municipality of Tuburan, Cebu for the May 14, 2007 elections. Petitioners and other candidates filed a petition for disqualification against respondent with the Cumlick alleging that respondent had been elected and served 3 consecutive terms as municipal councillor in 1998 to 2001, 2001 to 2004, and 2004 to 2007. Thus, he is proscribed from running for the same position in the 2007 elections as it would be his 4th consecutive term. Respondent admitted having been elected, but claimed that the service of his second term in 2001 to 2004 was interrupted on January 12, 2004 when he succeeded as vice mayor of Tuburan due to the retirement of Vice Mayor Petronilo L. Mendoza. Consequently, he is not disqualified from vying for the position of municipal councillor in the 2007 elections. Petitioners, on the other hand, contended that voluntary renunciation of the office shall not be considered an interruption in the continuity of service for the full term for which the official concerned was elected. The Cumlick denied the petition for disqualification. On appeal, the Cumlick en banc affirmed and ruled that there was no voluntary renunciation of office, but rather, an effective disruption in the full service of his second term as councillor. Issue 1. Respondent's assumption of office as vice mayor in January 2004 interrupted his 2001 to 2004 term as municipal councillor. Held yes ratio, in Lonzanita v. Commission on Elections, the court held that the 2 conditions for the application of the disqualification must concur: 1. That the official concerned has been elected for 3 consecutive terms in the same local government post, and 2. That he has fully served 3 consecutive terms. In Borja, Jr. v. Commission on Elections, the court emphasized that the term limit for elective officials must be taken to refer to the right to be elected as well as the right to serve in the same elective position. Thus, for the disqualification to apply, it is not enough that the official has been elected 3 consecutive times, he must also have served 3 consecutive terms in the same position. While it is undisputed that respondent was elected municipal councillor for 3 consecutive terms, the issue lies on whether he is deemed to have fully served his second term in view of his assumption of office as vice mayor of Tuburan on January 12, 2004. Succession in local government offices is by operation of law. Section 44 of Republic Act No. 7160, otherwise known as the Local Government Code, provides that if a permanent vacancy occurs in the office of the vice mayor, the highest-ranking Sangguniang member shall become vice mayor. In this case, a permanent vacancy occurred in the office of the vice mayor due to the retirement of Vice Mayor Mendoza. Respondent, being the highest-ranking municipal councillor, succeeded him in accordance with law. It is clear therefore that his assumption of office as vice mayor can in no way be considered a voluntary renunciation of his office as municipal councillor. In Lonzanita v. Commission on Elections, the court explained the concept of voluntary renunciation as follows. The second sentence of the constitutional provision under scrutiny states, "Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of service for the full term for which he was elected." The clear intent of the framers of the Constitution to bar any attempt to circumvent the three-term limit by a voluntary renunciation of office and at the same time respect the people's choice and grant their elected official full service of a term is evident in this provision. Voluntary renunciation of a term does not cancel the renounced term in the computation of the three-term limit, conversely. Involuntary severance from office for any length of time short of the full term provided by law amounts to an interruption of continuity of service. Thus, respondent's assumption of office as vice mayor in January 2004 was an involuntary severance from his office as municipal councillor, resulting in an interruption in the service of his 2001 to 2004 term. It cannot be deemed to have been by reason of voluntary renunciation because it was by operation of law. Succession by law to a vacated government office is characteristically not voluntary since it involves the performance of a public duty by a government official, the non-performance of which exposes said official to possible administrative and criminal charges of dereliction of duty and neglect in the performance of public functions. It is therefore more compulsory and obligatory rather than voluntary. Borgia v. Kumlik. Facts: Jose Capco, Jr. was elected vice mayor of Pateros on January 18, 1988 for a term ending June 30, 1992. On September 2, 1989, he became mayor, by operation of law, upon the death of the incumbent, Cesar Borgia. On May 11, 1992, he ran and was elected mayor for a term of 3 years which ended on June 30, 1995. On May 8, 1995, he was re-elected mayor for another term of 3 years ending June 30, 1998. Jose Capco filed a certificate of candidacy for mayor of Pateros relative to the May 11, 1998 elections. Benjamin Borgia, Jr., who was also a candidate for mayor, sought Capco's disqualification on the theory that the latter would have already served as mayor for 3 consecutive terms by June 30, 1998 and would therefore be ineligible to serve for another term after that. Kumlik ruled in favor of petitioner and declared Capco disqualified from running for re-election as mayor of Pateros. On motion, the Kumlik en banc reversed the decision and declared Capco eligible to run for mayor. It ruled that Capco's succession into office is not counted as one term for purposes of the computation of the 3-term limitation under the Constitution and Local Government Code. Capco was voted for in the elections. He received 16,558 votes against petitioner's 7,773 votes and was proclaimed elected by the Municipal Board of Canvassers. Issue: 1. Capco is eligible to run for mayor held yes ratio. First, to prevent the establishment of political dynasties is not the only policy embodied in the constitutional provision in question. The other policy is that of enhancing the freedom of choice of the people. To consider, therefore, only stay in office regardless of how the official concerned came to that office, whether by election or by succession by operation of law, would be to disregard one of the purposes of the constitutional provision in question. Thus, a consideration of the historical background of Art. X. 8 of the Constitution reveals that the members of the Constitutional Commission were as much concerned with preserving the freedom of choice of the people as they were with preventing the monopolization of political power. Indeed, they rejected a proposal put forth by Commissioner Edmundo F. Garcia that after serving 3 consecutive terms or 9 years there should be no further re-election for local and legislative officials. Instead, they adopted the alternative proposal of Commissioner Christian Monsid that such officials be simply barred from running for the same position in the succeeding election following the expiration of the 3rd consecutive term. Monsid warned against pre-screening candidates whom the people will choose as a result of the proposed absolute disqualification. Considering that the draft Constitution provision recognizing people's power. 2 ideas thus emerge from a consideration of the proceedings of the Constitutional Commission. The first is the notion of service of term, derived from the concern about the accumulation of power as a result of a prolonged stay in office. The second is the idea of election, derived from the concern that the right of the people to choose those whom they wish to govern them be preserved. It is likewise noteworthy that, in discussing term limits, the drafters of the Constitution did so on the assumption that the officials concerned were serving by reason of re-election. Indeed, a fundamental tenet of representative democracy is that the people should be allowed to choose whom they please to govern them. To bar the election of a local official because he has already served 3 terms, although the first as a result of succession by operation of law rather than election, would therefore be to violate this principle. Second, not only historical examination but textual analysis as well supports the ruling of the Cumlic that Art. X. 8 contemplates service by local officials for 3 consecutive terms as a result of election. The first sentence speaks of the term of office of elective local officials and bars such officials from serving for more than 3 consecutive terms. The second sentence, in explaining when an elective local official may be deemed to have served his full term of office, states that voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. The term served must therefore be one for which was elected. The purpose of this provision is to prevent a circumvention of the limitation on the number of terms an elective official may serve. Conversely, if he is not serving a term for which he was elected because he is simply continuing the service of the official he succeeds, such official cannot be considered to have fully served the term notwithstanding his voluntary renunciation of office prior to its expiration. Reference is made to Commissioner Byrne's comment on Art. 6, 7, which similarly bars members of the House of Representatives from serving for more than 3 terms. Commissioner Byrne states that if one is elected representative to serve the unexpired term of another, that unexpired term, no matter how short, will be considered one term for the purpose of computing the number of successive terms allowed. This is actually based on the opinion expressed by Commissioner Davide, yes, because we speak of term and if there is a special election, he will serve only for the unexpired portion of that particular term plus 1 more term for the senator and 2 more terms for the members of the lower house. There is a difference, however, between the case of a vice mayor and that of a member of the House of Representatives who succeeds another who dies, resigns, becomes incapacitated, or is removed from office. The vice mayor succeeds to the mayorship by operation of law. On the other hand, the representative is elected to fill the vacancy. In a real sense, therefore, such representative serves a term for which he was elected. As the purpose of the constitutional provision is to limit the right to be elected and to serve in Congress, his service of the unexpired term is rightly counted as his first term. Rather than refute what we believe to be the intendment of Art. X. 8 with regard to elective local officials, the case of a representative who succeeds another confirms the theory. Petitioner also cites Art. 7. 4 of the Constitution which provides for succession of the Vice President to the presidency in case of vacancy in that office. This provision says that no person who has succeeded as president and has served as such for more than 4 years shall be qualified for election to the same office at any time. Petitioner contends that, by analogy, the vice mayor should likewise be considered to have served a full term as mayor if he succeeds to the latter's office and serves for the remainder of the term. The framers of the Constitution included such a provision because, without it, the vice president, who simply steps into the presidency by succession, would be qualified to run for president even if he has occupied that office for more than 4 years. The absence of a similar provision in Art. X. 8 on elective local officials throws in bold relief the difference between the 2 cases. It underscores the constitutional intent to cover only the terms of office to which one may have been elected for purpose of the 3-term limit on local elective officials, disregarding for this purpose service by automatic succession. There is another reason why the vice president who succeeds to the presidency and serves in that office for more than 4 years is ineligible for election as president. The vice president is elected primarily to succeed the president in the event of the latter's death, permanent disability, removal, or resignation. While he may be appointed to the cabinet, his becoming so is entirely dependent on the good graces of the president. In running for vice president, he may thus be said to also seek the presidency. For their part, the electors likewise choose as vice president the candidate who they think can fill the presidency in the event it becomes vacant. Hence, service in the presidency for more than 4 years may rightly be considered as service for a full term. This is not so in the case of the vice mayor. Under the local government code, he is the presiding officer of the Sanggunian and he appoints all officials and employees of such local assembly. He has distinct powers and functions, succession to mayorship in the event of vacancy therein being only one of them. It cannot be said of him, as much as of the vice president in the event of a vacancy in the presidency, that in running for vice mayor, he also seeks the mayorship. His assumption of the mayorship in the event of vacancy is more a matter of chance than of design. Hence, his service in that office should not be counted in the application of any term limit. To recapitulate, the term limit for elective local officials must be taken to refer to the right to be elected as well as the right to serve in the same elective position. Consequently, it is not enough that an individual has served 3 consecutive terms in an elective local office, he must also have been elected to the same position for the same number of times before the disqualification can apply. Borgia Supplement. Case number 1. Suppose A is a vice mayor who becomes mayor by reason of the death of the incumbent. 6 months before the next election, he resigns and is twice elected thereafter. Can he run again for mayor in the next election? Yes, because although he has already first served as mayor by succession and subsequently resigned from office before the full term expired, he has not actually served 3 full terms in all for the purpose of applying the term limit. Under Art. X. 8, voluntary renunciation of the office is not considered as an interruption in the continuity of his service for the full term only if the term is one for which he was elected. Since A is only completing the service of the term for which the deceased and not he was elected, A cannot be considered to have completed one term. His resignation constitutes an interruption of the full term. Case number 2. Suppose B is elected mayor and, during his first term, he is twice suspended for misconduct for a total of 1 year. If he is twice re-elected after that, can he run for one more term in the next election? Yes, because he has served only 2 full terms successively. In both cases, the mayor is entitled to run for re-election because the 2 conditions for the application of the disqualification provisions have not concurred, namely, that the local official concerned has been elected 3 consecutive times and that he has fully served 3 consecutive terms. In the first case, even if the local official is considered to have served 3 full terms notwithstanding his resignation before the end of the first term, the fact remains that he has not been elected 3 times. In the second case, the local official has been elected 3 consecutive times, but he has not fully served 3 consecutive terms. Case number 3. The case of Vice Mayor C who becomes mayor by succession involves a total failure of the 2 conditions to concur for the purpose of applying Art. X8. Suppose he is twice elected after that term, is he qualified to run again in the next election? Yes, because he was not elected to the office of the mayor in the first term but simply found himself thrust into it by operation of law. Neither had he served the full term because he only continued the service, interrupted by the death, of the deceased mayor. To consider C in the third case to have served the first term in full and therefore ineligible to run a third time for re-election would be not only to falsify reality but also to unduly restrict the right of the people to choose whom they wish to govern them. If the vice mayor turns out to be a bad mayor, the people can remedy the situation by simply not re-electing him for another term. But if, on the other hand, he proves to be a good mayor, there will be no way the people can return him to office if his service of the first term is counted as one of the purpose of applying the term limit. To consider C as eligible for re-election would be in accord with the understanding of the Constitutional Commission that while the people should be protected from the evils that a monopoly of political power may bring about, care should be taken that their freedom of choice is not unduly curtailed. Adornio v. Cumlick. Facts: petitioner and private respondent were the only candidates for mayor of Lucena City in the May 14, 2001 elections. Talaga, Jr. was elected mayor in May 1992. He served the full term. Again, he was re-elected in 1995 to 1998. In the election of 1998, he lost to Bernard G. Tagarao. In the recall election of May 12, 2000, he again won and served the unexpired term of Tagarao until June 30, 2001. Petitioner filed with the Office of the Provincial Election Supervisor, Lucena City a petition to deny due course to or cancel certificate of candidacy and/or disqualification of Ramon Y. Talaga, Jr. on the ground that the latter was elected and had served as city mayor for 3 consecutive terms as follows: in the election of May 1992, where he served the full term, in the election of May 1995, where he again served the full term, and, in the recall election of May 12, 2000, where he served only the unexpired term of Tagarao after having lost to Tagarao in the 1998 election. Petitioner contended that Talaga's candidacy as mayor constituted a violation of Section 8, Article X of the 1987 Constitution. On March 9, 2001, private respondent responded that he was not elected city mayor for 3 consecutive terms but only for 2 consecutive terms. He pointed to his defeat in the 1998 election by Tagarao. Because of his defeat, the consecutiveness of his years as mayor was interrupted, and thus his mayorship was not for 3 consecutive terms of 3 years each. Respondent added that his service from May 12, 2001 until June 30, 2001 for 13 months and 18 days was not a full term, in the contemplation of the law and the Constitution. The Cumlick found Talaga disqualified for the position of city mayor. The Cumlick en banc reversed and ruled that 1. Respondent was not elected for 3 consecutive terms because he did not win in the May 11, 1998 elections, 2. That he was installed only as mayor by reason of his victory in the recall elections. 3. That his victory in the recall elections was not considered a term of office and is not included in the 3-term disqualification rule, and 4. That he did not fully serve the 3 consecutive terms, and his loss in the May 11, 1998 elections is considered an interruption in the continuity of his service as mayor of Lucena City. Issue 1. Talaga is disqualified to run for mayor held no ratio. The issue before us was already addressed in Borja, Jr. vs. Cumlick, 295 SCRA 157, 169. Where we held, to recapitulate, the term limit for elective local officials must be taken to refer to the right to be elected as well as the right to serve in the same elective position. Consequently, it is not enough that an individual has served 3 consecutive terms in an elective local office, he must also have been elected to the same position for the same number of times before the disqualification can apply. This point can be made clearer by considering the following case or situation. Case number 2. Suppose B is elected mayor and, during his first term, he is twice suspended for misconduct for a total of 1 year. If he is twice re-elected after that, can he run for one more term in the next election? Yes, because he has served only 2 full terms successively. To consider C as eligible for re-election would be in accord with the understanding of the Constitutional Commission that while the people should be protected from the evils that a monopoly of political power may bring about, care should be taken that their freedom of choice is not unduly curtailed. Likewise, in the case of Lanzanita vs. Cumlick, 311 SCRA 602, 611, we said, this court held that the 2 conditions for the application of the disqualification must concur. A. That the official concerned has been elected for 3 consecutive terms in the same local government post, and 2. That he has fully served 3 consecutive terms. Accordingly, Cumlick's ruling that private respondent was not elected for 3 consecutive terms should be upheld. For nearly 2 years he was a private citizen. The continuity of his mayorship was disrupted by his defeat in the 1998 elections. Patently untenable is petitioner's contention that Cumlick, in allowing respondent Talaga, Jr. to run in the May 1998 election, violates Article X, Section 8 of 1987 Constitution. To bolster his case, respondent adverts to the comment of Fr. Joaquin Bernas, a Constitutional Commission member, stating that in interpreting said provision that if one is elected representative to serve the unexpired term of another, that unexpired, no matter how short, will be considered one term for the purpose of computing the number of successive terms allowed. As pointed out by the Cumlick and Bank, Fr. Bernas' comment is pertinent only to members of the House of Representatives. Unlike local government officials, there is no recall election provided for members of Congress. Neither can respondents' victory in the recall election be deemed a violation of Section 8, Article X of the Constitution as voluntary renunciation, for clearly it is not. In Lanzanita vs. Cumlick, we said. The second sentence of the constitutional provision under scrutiny states, voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of service for the full term for which he was elected. The clear intent of the framers of the Constitution to bar any attempt to circumvent the 3-term limit by a voluntary renunciation of office and at the same time respect the people's choice and grant their elected official full service of a term is evident in this provision. Voluntary renunciation of a term does not cancel the renounced term in the computation of the 3-term limit. Conversely, involuntary severance from office for any length of time short of the full term provided by law amounts to an interruption of continuity of service. The petitioner vacated his post a few months before the next mayoral elections, not by voluntary renunciation but in compliance with the legal process of writ of execution issued by the Cumlick to that effect. Such involuntary severance from office is an interruption of continuity of service, and thus, the petitioner did not fully serve the 1995 to 1998 mayoral term. Socrates v. Cumlick. Facts: on July 2, 2002, 312 out of 528 members of the incumbent barangay officials of the Puerto Princesa convened into a preparatory recall assembly to initiate the recall of Victorino Dennis M. Socrates. The members of the PRA designated Mark David M. Hagedorn, President of the Association of Barangay Captains, as interim chair of the PRA. The PRA passed a resolution declaring its loss of confidence in Socrates and called for his recall. Socrates filed a petition to deny due course to the recall resolution, but the Cumlick and Bank dismissed the case for lack of merit. Edward M. Hagedorn filed his certificate of candidacy for mayor in the recall election. Ma. Flores F. Adavo and Merle E. Jallo filed a petition before the Cumlick to disqualify Hagedorn from running in the recall election and to cancel his certificate of candidacy. The petitions were all anchored on the ground that Hagedorn is disqualified from running for a fourth consecutive term. Having been elected and having served as mayor of the city for 3 consecutive full terms immediately prior to the instant recall election for the same post, the Cumlic declared Hagedorn qualified to run in the recall election. GR number 154512. Socrates sought to nullify the Cumlic and Bank resolution which gave due course to the recall resolution and scheduled the recall election on September 7, 2002. Socrates cites the following circumstances as legal infirmities attending the convening of the PRA and its issuance of the recall resolution. Not all members of the PRA were notified of the meeting to adopt the resolution. The proof of service of notice was palpably and legally deficient. The members of the PRA were themselves seeking a new electoral mandate from their respective constituents. The adoption of the resolution was exercised with grave abuse of authority, and the PRA proceedings were conducted in a manner that violated his and the public's constitutional right to information. GR number 154683. Vicente S. Sandoval, Jr. sought to annul Cumlic Resolution number 5673 insofar as it fixed the recall election on September 7, 2002, giving the candidates only a 10-day campaign period. He prayed that the Cumlic be enjoined from holding the recall election on September 7, 2002 and that a new date be fixed giving the candidates at least an additional 15 days to campaign. The court gave the candidates an additional 15 days within which to campaign. Thus, the Cumlic reset the recall election to September 24, 2002. GRNOS 155083-84. Petitioners Adavo, Gelo, and Ale assail the Cumlic's resolutions declaring Hagedorn qualified to run for mayor in the recall election. The court ordered the Cumlic to desist from proclaiming any winning candidate in the recall election until further orders from the court. In the meantime, Hagedorn garnered the highest number of votes in the recall election with 20,238 votes. Rival candidates Socrates and Sandoval obtained 17,220 votes and 13,241 votes, respectively. Issue 1. The recall resolution was valid. Held yes ratio. Petitioner Socrates argues that the Cumlic committed grave abuse of discretion in upholding the recall resolution despite the absence of notice to 130 PRA members and the defective service of notice to other PRA members. The Cumlic, however, found that the proponents for the recall of incumbent city mayor Victorino Dennis M. Socrates sent notices of the convening of the PRA to the members thereof pursuant to Section 70 of the Local Government Code. Notices of the convening of the Puerto Princesa PRA were also sent to the following: a list of 25 names of provincial elective officials, print and broadcast media practitioners, PNP officials, Cumlic City, regional and national officials, and DILG officials. The court is bound by the findings of fact of the Cumlic on matters within the competence and expertise of the Cumlic, unless the findings are patently erroneous. In the instant case, we do not find any valid reason to hold that the Cumlic's findings of fact are patently erroneous. Socrates also claims that the PRA members had no authority to adopt the recall resolution on July 2, 2002 because a majority of PRA members were seeking a new electoral mandate in the barangay elections scheduled on July 15, 2002. This argument deserves scant consideration, considering that when the PRA members adopted the recall resolution their terms of office had not yet expired. They were all de jure sangguniang barangay members with no legal disqualification to participate in the recall assembly under Section 70 of the Local Government Code. Socrates bewails that the manner private respondents conducted the PRA proceedings violated his constitutional right to information on matters of public concern. Socrates, however, admits receiving notice of the PRA meeting and of even sending his representative and counsel who were present during the entire PRA proceedings. Proponents of the recall election submitted to the Cumlic the recall resolution, minutes of the PRA proceedings, the journal of the PRA Assembly, attendance sheets, notices sent to PRA members. An authenticated master list of barangay officials in Puerto Princesa. Socrates had the right to examine and copy all these public records in the official custody of the Cumlic. Socrates, however, does not claim that the Cumlic denied him this right. There is no legal basis in Socrates' claim that respondents violated his constitutional right to information on matters of public concern. Thus, we rule that the Cumlic did not commit grave abuse of discretion in upholding the validity of the recall resolution and in scheduling the recall election on September 24, 2002. Issue: 1. Hagedorn is qualified to run for mayor in the recall election. Held no ratio. The constitutional and statutory provisions have two parts. The first part provides that an elective local official cannot serve for more than 3 consecutive terms. The clear intent is that only consecutive terms count in determining the 3-term limit rule. The second part states that voluntary renunciation of office for any length of time does not interrupt the continuity of service. The clear intent is that involuntary severance from office for any length of time interrupts continuity of service and prevents the service before and after the interruption from being joined together to form a continuous service or consecutive terms. After 3 consecutive terms, an elective local official cannot seek immediate re-election for a 4th term. The prohibited election refers to the next regular election for the same office following the end of the 3rd consecutive term. Any subsequent election, like a recall election, is no longer covered by the prohibition for 2 reasons. First, a subsequent election like a recall election is no longer an immediate re-election after 3 consecutive terms. Second, the intervening period constitutes an involuntary interruption in the continuity of service. When the framers of the Constitution debated on the term limit of elective local officials, the question asked was whether there would be no further election after 3 terms, or whether there would be no immediate re-election after 3 terms. What the Constitution prohibits is an immediate re-election for a 4th term following 3 consecutive terms. The Constitution, however, does not prohibit a subsequent re-election for a 4th term as long as the re-election is not immediately after the end of the 3rd consecutive term. A recall election midway in the term following the 3rd consecutive term is a subsequent election but not an immediate re-election after the 3rd term. Neither does the Constitution prohibit one barred from seeking immediate re-election to run in any other subsequent election involving the same term of office. What the Constitution prohibits is a consecutive 4th term. The debates in the Constitutional Commission evidently show that the prohibited election referred to by the framers of the Constitution is the immediate re-election after the 3rd term, not any other subsequent election. If the prohibition on elective local officials is applied to any election within the 3-year full term following the 3-term limit, then senators should also be prohibited from running in any election within the 6-year full term following their 2-term limit. The constitutional provision on the term limit of senators is worded exactly like the term limit of elective local officials. The framers of the Constitution thus clarified that a senator can run after only 3 years following his completion of 2 terms. The framers expressly acknowledged that the prohibited election refers only to the immediate re-election, and not to any subsequent election, during the 6-year period following the 2-term limit. The framers of the Constitution did not intend the period of rest of an elective official who has reached his term limit to be the full extent of the succeeding term. In the case of Hagedorn, his candidacy in the recall election on September 24, 2002 is not an immediate re-election after his 3rd consecutive term which ended on June 30, 2001. The immediate re-election that the Constitution barred Hagedorn from seeking referred to the regular elections in 2001. Hagedorn did not seek re-election in the 2001 elections. Hagedorn was elected for 3 consecutive terms in the 1992, 1995, and 1998 elections and served in full his 3 consecutive terms as mayor of Puerto Princesa. Under the Constitution and the Local Government Code, Hagedorn could no longer run for mayor in the 2001 elections. The Constitution and the Local Government Code disqualified Hagedorn, who had reached the maximum 3-term limit, from running for a 4th consecutive term as mayor. Thus, Hagedorn did not run for mayor in the 2001 elections. Socrates ran and won as mayor of Puerto Princesa in the 2001 elections. After Hagedorn ceased to be mayor on June 30, 2001, he became a private citizen until the recall election of September 24, 2002, when he won by 3,018 votes over his closest opponent, Socrates. From June 30, 2001 until the recall election on September 24, 2002, the mayor of Puerto Princesa was Socrates. During the same period, Hagedorn was simply a private citizen. This period is clearly an interruption in the continuity of Hagedorn's service as mayor, not because of his voluntary renunciation, but because of a legal prohibition. Hagedorn's 3 consecutive terms ended on June 30, 2001. Hagedorn's new recall term from September 24, 2002 to June 30, 2004 is not a seamless continuation of his previous 3 consecutive terms as mayor. One cannot stitch together Hagedorn's previous 3 terms with his new recall term to make the recall term a 4th consecutive term, because factually it is not. An involuntary interruption occurred from June 30, 2001 to September 24, 2002, which broke the continuity or consecutive character of Hagedorn's service as mayor. In Hagedorn's case, the nearly 15-month period he was out of office, although short of a full term of 3 years, constituted an interruption in the continuity of his service as mayor. The Constitution does not require the interruption or hiatus to be a full term of 3 years. The clear intent is that interruption for any length of time, as long as the cause is involuntary, is sufficient to break an elective local official's continuity of service. Adormio established the rule that the winner in the recall election cannot be charged or credited with the full term of 3 years for purposes of counting the consecutiveness of an elective official's terms in office. In the same manner, Hagedorn's recall term does not retroact to include the tenure in office of Socrates. Hagedorn can only be disqualified to run in the September 24, 2002 recall election if the recall term is made to retroact to June 30, 2001, for only then can the recall term constitute a 4th consecutive term. But to consider Hagedorn's recall term as a full term of 3 years, retroacting to June 30, 2001, despite the fact that he won his recall term only last September 24, 2002, is to ignore reality. This court cannot declare as consecutive or successive terms of office which historically and factually are not. Worse, to make Hagedorn's recall term retroact to June 30, 2001 creates a legal fiction that unduly curtails the freedom of the people to choose their leaders through popular elections. The concept of term limits is in derogation of the sovereign will of the people to elect the leaders of their own choosing. Term limits must be construed strictly to give the fullest possible effect to the sovereign will of the people. A necessary consequence of the interruption of continuity of service is the start of a new term following the interruption. An official elected in recall election serves the unexpired term of the recalled official. This unexpired term is in itself one term for purposes of counting the three-term limit. This is clear from the following discussion in the Constitutional Commission. Although the discussion referred to special elections for senators and representatives of the House, the same principle applies to a recall election of local officials. Otherwise, an elective local official who serves a recall term can serve for more than 9 consecutive years comprising of the recall term plus the regular 3 full terms. A local official who serves a recall term should know that the recall term is in itself one term although less than 3 years. This is the inherent limitation he takes by running and winning in the recall election. Davide, concurring and dissenting. The ponencia is then correct when it holds that the 3-term limit bars an immediate re-election for a 4th term. But I disagree when it rules that in the case of Hagedorn he did not seek an immediate re-election for a 4th term because he was not a candidate for re-election in the May 2001 election. It forgets that what would have been his 4th term by virtue of the May 2001 election was for the period from June 30, 2001 to June 30, 2004. The flaw in the ruling results from an apparent confusion between term and election, the root cause of which is the attempt to distinguish voluntary renunciation of office from involuntary severance from office and the term of office to which it relates. I wish to add that the Constitutional Commission debates on the issue of no immediate re-election after 3 consecutive terms for members of Congress clearly indicated that the no immediate re-election after the 3-term limit would equally apply to the elective local officials. This accounted for the immediate acceptance by the Committee on Local Governments of the aforementioned amendment of Commissioner Davide, which is now Section 8 of Article X of the Constitution. These debates clearly showed the intent of the Commission that the ban against an immediate re-election after 3 consecutive terms applies to the 4th term, i.e., the term immediately following the 3 consecutive terms, to be filled up by the regular election for such 4th term. For one to be able to run again after 3 consecutive terms, he has to rest for the entire immediately succeeding 4th term. On the next 5th term he can run again to start a new series of 3 consecutive terms. The dichotomy made in the ponencia between voluntary renunciation of the office as used in Section 8 of Article X of the Constitution and Section 43 of RA No. 7160 and involuntary severance from office is unnecessary, if not misplaced. From the discussion in the ponencia, the latter is made to apply to the banned term, i.e., the 4th term immediately following 3 consecutive terms. Speaking now of Hagedorn, he cannot have suffered involuntary severance from office because there was nothing to be severed. He was not a holder of an office either in a de jure or de facto capacity. He knew he was disqualified from seeking a 3rd re-election to office. Disqualification is, definitely, not synonymous with involuntary severance. Even if we concede that involuntary severance is an act which interrupts the continuity of a term for purposes of applying the 3-term principle, the rule laid down in Lonzanita vs. Kumlik, cited in the ponencia, page 17, is not applicable in the case of Hagedorn. The involuntary severance referred to in that case was one that took place during any of the 3 terms, hence, the term during which it occurred should be excluded in the computation. In the case of Hagedorn, no such involuntary severance took place during any of his 3 terms brought about by his election in 1992 and re-elections in 1995 and 1998. More importantly, the voluntary renunciation referred to in Section 8, Article X of the Constitution and Section 43 of RA No. 7160 is one that takes place at any time during either the 1st, 2nd, or 3rd term of the 3 consecutive terms. This is very clear from the last clause of Section 8, Article X of the Constitution, which reads, "shall not be considered as an interruption in the continuity of his service for the full term for which he was elected." The purpose of the provision is to prevent an elective local official from voluntarily resigning from office for the purpose of circumventing the rule on the belief that the term during which he resigned would be excluded in the counting of the 3-term rule. In short, the provision excluded is intended to impose a penalty on one who flouts the rule or make a mockery of it by the simple act of resigning. Thus, applying it in the case of Hagedorn, even if he voluntarily resigned on his third term, he would still be barred from seeking re-election in the May 2001 election. Hagedorn cannot likewise avail of the ruling in Adormio vs. Kumlik because in that case Talaga did not win in his second re-election bid, or for a third term, in the May 1998 elections. He won in the recall election of May 12, 2000. Hagedorn, as earlier stated, fully served 3 successive terms. Mendoza v. Kumlik. For resolution is a petition for certiorari filed by petitioners Melanio L. Mendoza and Mario E. Ibarra, seeking to set aside the resolution of the Commission on Elections, dated August 15, 2001, in EPC No 2001-5 and to declare respondent Leonardo B. Roman's election as governor of Bataan on May 14, 2001 as null and void for allegedly being contrary to Art. X. 8 of the Constitution, which provides that the term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years and no such official shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. After due deliberation, the court voted 8-7 to dismiss the petition. Vidug, J., joined by Inares Santiago, J., voted to dismiss the petition. He contended that as revealed by the records of the Constitutional Commission, the Constitution envisions a continuous and an uninterrupted service for 3 full terms before the proscription applies. Therefore, not being a full term, a recall term should not be counted or used as a basis for the disqualification whether served prior or subsequent to the 9-year, full 3-term limit. Mendoza, J., in whose opinion Quisuming, J. joined, voted to dismiss the petition on the ground that, in accordance with the ruling in Borja, J.R. v. Kumlik, 295 SCRA 157, Arcos v. Kumlik, GR number 133639, October 6, 1998, Res. Lanzanita v. Kumlik, 311 SCRA 602, and Adormio v. Kumlik, GR number 147927, February 4, 2002, a term during which succession to a local elective office takes place or a recall election is held should not be counted in determining whether an elective local official has served more than 3 consecutive terms. He argued that the Constitution does not prohibit elective local officials from serving for more than 3 consecutive terms because, in fact, it excludes from the 3-term limit interruptions in the continuity of service. So long as such interruptions are not due to the voluntary renunciation of the office by an incumbent. Hence, the period from June 28, 1994 to June 30, 1995, during which respondent Leonardo B. Roman served as governor of Bataan by virtue of a recall election held in 1993, should not be counted. Since on May 14, 2001 respondent had previously served as governor of Bataan for only 2 consecutive terms, his election on that day was actually only his 3rd term for the same position. Panganaban, J., joined by Puno, J., also voted to dismiss the petition. He argued that a recall term should not be considered as 1 full term, because a contrary interpretation would in effect cut short the elected official's service to less than 9 years and shortchange his constituents. The desire to prevent monopoly of political power should be balanced against the need to uphold the voter's obvious preference who, in the present case, is Roman who received 97% of the votes cast. He explained that, in Socrates, he also voted to affirm the clear choice of the electorate, because in a democracy the people should, as much as legally possible, be governed by leaders freely chosen by them in credible elections. He concluded that, in election cases, when two conflicting legal positions are of almost equal weight, the scales of justice should be tilted in favor of the people's overwhelming choice. Age Cunha, J., joined by Belosillo, J., also voted to dismiss, arguing that it is clear from the constitutional provision that the disqualification applies only if the terms are consecutive and the service is full and continuous. Hence, service for less than a term, except only in case of voluntary renunciation, should not count to disqualify an elective local official from running for the same position. This case is different from Socrates, where the full 3 consecutive terms had been continuously served so that disqualification had clearly attached. On the other hand, Sandoval Gutierrez, J., with whom Davide, Jr., CJ, and Austria Martinez, Corona, and Callejo, SR, JJ, concurred, holds the view that the recall term served by Respondent Roman, comprising the period June 28, 1994 to June 30, 1995, should be considered as one term. Since he thereafter served for 2 consecutive terms from 1995 to 1998 and from 1998 to 2001, his election on May 14, 2001 was actually his 4th term and contravenes Art. X. 8 of the Constitution. For this reason, she voted to grant the petition and to declare respondent's election on May 14, 2001 as null and void. Carpio, J., joined by Carpio Morales, J., also dissented and voted to grant the petition. He held that a recall term constitutes one term and that to totally ignore a recall term in determining the 3-term limit would allow local officials to serve for more than 9 consecutive years, contrary to the manifest intent of the framers of the Constitution. He contended that Respondent Roman's election in 2001 cannot exempt him from the 3-term limit imposed by the Constitution. Tenure of office Osmina v. Kumlik. Facts. The petition calls for a determination of the validity and constitutionality of Republic Act 7056, an act providing for the national and local elections in 1992. Pave the way for synchronized and simultaneous elections beginning 1995, and authorizing appropriations therefor, which was signed into law on June 20, 1991. The suit was instituted by Governor Emilio M. Osmina, Gov. Roberto Pagdanganon on behalf of the League of Governors of the Philippines, Representatives Pablo P. Garcia, Raul V. Del Mar, Antonio T. Bacaltos, Wilfredo G. Caingled, and Romeo Guanzon, by way of a petition for prohibition, mandamus, an injunction with temporary restraining order and/or preliminary injunction to prevent the implementation of said Republic Act 7056 and the consequent expenditure of public funds, and to compel the Kumlik to immediately end, with all deliberate speed, set up the machinery and make the necessary preparation for the holding of synchronized national and local elections on the 2nd Monday of May, 1992. The petitioners claim they have actual and material legal interest in the subject matter of this case, not only because, as public officials, they have taken an oath to support and defend the Constitution, but also because, as taxpayers, they have an interest in seeing to it that public funds are properly and, more importantly, lawfully disbursed. They pray for this court to declare Republic Act No. 7056 as unconstitutional and, therefore, invalid and inoperative because, 1. Republic Act 7056 violates the mandate of the Constitution for the holding of synchronized national and local elections on the 2nd Monday of May 1992. 2. Republic Act 7056, particularly the second paragraph of Section 3 thereof, providing that all incumbent provincial, city and municipal officials shall hold over beyond June 30, 1992 and shall serve until their successors shall have been duly elected and qualified, violates Section 2, Article 18 of the Constitution. 3. The same paragraph of Section 3 of Republic Act 7056, which in effect, shortens the term or tenure of office of local officials to be elected on the second Monday of November, 1992 violates Section 8, Article X of the Constitution. 4. Section 8 of Republic Act 7056, providing for the campaign periods for presidential, vice presidential, and senatorial elections, violates the provision of Section 9, Article 9 under the title Commission on Elections of the Constitution. 5. The so-called many difficult if not insurmountable problems mentioned in Republic Act 7056 to synchronized national and local elections set by the Constitution on the second Monday of May, 1992, are not sufficient, much less valid justification for postponing the local elections to the second Monday of November 1992, and in the process violating the Constitution itself. If, at all, Congress can devise ways and means, within the parameters of the Constitution, to eliminate or at least minimize these problems, and if this, still, is not feasible, resort can be made to the self-correcting mechanism built in the Constitution for its amendment or revision. The Solicitor General prays for the denial of the petition on the ground that the question is political in nature and that the petitioners are merely asking for an advisory opinion from the court, there being no justiciable controversy for resolution. On the merits of the case, the Solicitor General contends that Republic Act 7056 is a valid exercise of legislative power by Congress and that the regular amending process prescribed by the Constitution does not apply to its transitory provisions. Issue 1. The court has competence to act on the matter at bar. Held yes ratio. What is involved here is the legality, not the wisdom of RA 7056. And even if we were to assume that the issue presented before us is political in nature, we would still not be precluded from resolving it under the expanded jurisdiction conferred upon us that now covers in proper cases even political questions, provided naturally, that the question is not solely and exclusively political but one which really necessitates a forthright determination of constitutionality, involving as it does a question of national importance. On the other procedural issues raised, we held as early as in the emergency power cases that where serious constitutional questions are involved, the transcendental importance to the public of these cases demands that they be settled promptly and definitely, brushing aside if we must, technicalities of procedure. It would appear undeniable, therefore, that before us is an appropriate invocation of our jurisdiction to prevent the enforcement of an alleged unconstitutional statute. We are left with no choice then, we must act on the matter. To summarize, on the procedural issue, we hold in view of the foregoing considerations, that the issue presented to us in the case at bar, is justiciable rather than political. Even if the question were political in nature, it would still come within our powers of review under the expanded jurisdiction conferred upon us by Article 8, Section 1 of the 1987 Constitution, which includes the authority to determine whether grave abuse of discretion amounting to excess or lack of jurisdiction has been committed by any branch or instrumentality of the government. As for the other alleged procedural flaws, lack of court standing, etc., assuming the existence of such flaws, the same may be brushed aside, conformably with existing doctrines so that the important constitutional issue raised may be addressed. Accordingly, we are left with no other alternative but to uphold the jurisdiction of the court over the present cases. It goes without saying that we do this not because the court is superior to the executive and/or legislative but simply because the executive, the legislative and this court are subject to the Constitution as the supreme law. Issue 1. RA 7056 is unconstitutional. Held yes ratio. It is evident from the wording of Article 18. Sections 2 and 5 of the 1987 Constitution that the term of synchronization is used synonymously as the phrase holding simultaneously, since this is the precise intent in terminating their office tenure on the same day or occasion. This common termination date will synchronize future elections to once every 3 years. That the election for senators, members of the House of Representatives and the local officials, under Sector 2, Art. 18, will have to be synchronized with the election for President and Vice President is likewise evident from the following records of the proceedings in the Constitutional Commission. It thus becomes very evident that the Constitution has mandated a synchronized national and local election prior to June 30, 1992, or more specifically as provided for in Article 18, Seconds 5 on the second Monday of May, 1992. On this point, it has to be stressed that the term of office of elective local officials, except barangay officials, is fixed by the Constitution at 3 years. The incumbent local officials were elected in January 1988. Therefore, their term would have expired on February 2, 1991. But their term was adjusted to expire at noon of June 30, 1992. The reason for the said adjustment, as well as those of the senators, members of the House of Representatives, President and Vice President, is the same: to synchronize the national and local elections. Upon the other hand, and contrary to the express mandate of the 1987 Constitution, RA 7056 provides for 2 separate elections in 1992 as follows: Seconds 2. Start of synchronization. To start the process of synchronization of election in accordance with the policy hereinbefore declared, there shall be held an election for President and Vice President of the Philippines. 24 senators and all elective members of the House of Representatives on the second Monday of May, 1992, and an election of all provincial, city and municipal elective officials on the second Monday of November, 1992. The purpose of Republic Act 7056 is as stated in Section 1 thereof under the heading Statement of Policy. To start, as much as practicable, the synchronization of the elections so that the process can be completed in the 1995 elections, with the result that beginning 1995 there shall be only one simultaneous regular elections for national and local elective officials every 3 years. With the clear mandate of the 1987 Constitution to hold synchronized national and local elections in the second Monday of May, 1992. The inevitable conclusion would be that Republic Act 7056 is clearly violative of the Constitution because it provides for the holding of a desynchronized election. Stated differently, Republic Act 7056, particularly Sections 1 and 2 thereof, contravenes Article 18, Sections 2 and 5 of the 1987 Constitution. But this is not all. There are other provisions of the Constitution violated by RA 7056. For one, there is Section 2, Article 18 of the Constitution, which provides that the local official first elected under the Constitution shall serve until noon of June 30, 1992. But under Seconds 3 of RA 7056, these incumbent local officials shall hold over beyond June 30, 1992 and shall serve until their successors shall have been duly elected and qualified. It has been held that it is not competent for the legislature to extend the term of officers by providing that they shall hold over until their successors are elected and qualified where the Constitution has in effect or by clear implication prescribed the term and when. The Constitution fixes the day on which the official term shall begin. There is no legislative authority to continue the office beyond that period, even though the successors fail to qualify with the time. If the local election will be held on the second Monday of November 1992 under RA 7056, those to be elected will be serving for only 2 years and 7 months, that is, from November 30, 1992 to June 30, 1995. Not 3 years as provided for by the Constitution. Then also, Section 9, Article 9 of the Constitution provides that, unless otherwise fixed by the Commission in special cases, the election period shall commence 90 days before the day of election and shall end 30 days thereafter. Under this provision, the filing of the certificate of candidacy and the ensuing campaign period must be embraced or circumscribed within that election period of 90 days, except when in special cases. The Cumlic alters the period. But RA 7056 provides for a different campaign period, as follows: Sector 8. For President arid Vice Presidential elections 130 days before the day of election. For senatorial elections, 90 days before the day of the election, and for the election of members of the House of Representatives and local elective provincial, city and municipal officials 45 days before the day of the elections. All these the postponement of the holding of a synchronized national and local election from 1992 to 1995, the holdover provision for incumbent local officials. The reduction of the term of office of local officials to be elected on the second Monday of November 1992 and the change in the campaign periods, are violative of the 1987 Constitution. The contention of the Solicitor General that the method of amendment or revision prescribed by the Constitution does not apply to the transitory provisions because in the nature of things transitory provisions are to be carried out as soon as practicable, and Congress can, in the exercise of its legislative power, enact the needed legislation, in this case RA 7056, deserves no consideration at all. The 1987 Constitution has stated in clear and categorical language that the 6-year term of the incumbent president and vice president elected in the February 7, 1986 election is, for purposes of synchronization of elections, hereby extended to noon of June 30, 1992. As discussed earlier, the elections referred to be synchronized with the election of the President and Vice President on the second Monday of May 1992, is the election for senators, members of the House of Representatives and local officials. It is noteworthy that the Solicitor General evaded the issue of the constitutionality of RA 7056. Although he made a lengthy discussion on the procedural issues and on the legislative power of Congress, he failed to refute the arguments of the petitioners that RA 7056 violated several provisions of the 1987 Constitution, more importantly, the provision on synchronization of election. Vacancies and Succession. Janel v. Cumlic, GR number 147927. Facts: Petitioner Janel Julhatab J. Talib were duly certified candidates for Mayor of Indinan, Sulu in the May 10, 2004 elections. During the canvassing, Talib objected to the inclusion of certain returns before the Municipal Board of Canvassers. On May 20, 2004, petitioner was proclaimed by the MBC as the winning candidate with a margin of 1,018 votes. On May 23, Talib filed a pre-proclamation case with the Cumlic praying for the annulment of election returns pertaining to 21 precincts representing 2,788 votes. He alleged that the watchers were asked to leave the precincts before the counting and preparation of the election returns. Also, the returns were not signed by the members of the Board of Election Inspectors. Also, the number of votes exceeded the number of voters in 2 precincts. Petitioner prayed for the dismissal of the case, contending that the allegations are not the proper subject of an election protest. The Cumlic annulled the election returns in 9 precincts. The proclamation of Janel was also annulled. Hence, petitioner filed the instant petition, including Hussi Ahajan as private respondent in his capacity as vice mayor who, under the provisions of the Local Government Code, will fill up the vacancy created by the annulment of petitioner's proclamation. Issue 1. Talib should have followed the procedure outlined in Section 20 of RA 7166 for contesting election returns held no ratio. Sector 20 of RA number 7166 provides for the steps, outlined below, to be undertaken by a party contesting the inclusion or exclusion of any election return. Submitting oral objections and thereupon entering the objections in the form for written objections to be prescribed by the Cumlic, submitting evidence in support of the objections within 24 hours. Informing the MBC of his intention to appeal from the MBC ruling on his objections, filing with the MBC a written and verified notice of appeal within 48 hours from suspension of the canvass, and taking an appeal to the Cumlic within an inextendable period of 5 days from filing the notice of appeal. However, the provision also requires the MBC to perform certain acts, to wit, recording the oral objections in the minutes of the canvass, automatically deferring the canvass of the contested returns and proceeding to canvass the uncontested returns, summarily and immediately ruling on the objections upon receipt of the evidence, entering its ruling in the prescribed form and authenticating the same, entering in the minutes of the canvass a party's signified intention to appeal the ruling to the Cumlic, suspending the canvass after canvassing all the uncontested returns and ruling upon the contested returns, and making an appropriate report to the Cumlic immediately upon receipt of the notice of appeal, elevating therewith the complete records and evidence submitted in the canvass, and furnishing the parties with copies of the report. Petitioner does not state in what respect and on what basis Talib failed to comply with Sector 20 of RA 7166. It is incumbent upon petitioner to prove the alleged non-compliance. In the absence of such proof, there is no aspect in the proceedings before the MBC which legally precludes Talib from filing his petition before the Cumlic in accordance with the Cumlic Rules of Procedure. In fact, petitioner did not even raise this issue of non-compliance with Sector 20 of RA No. 7166 in his answer and memorandum filed before the Cumlic. The general rule is that a pre-proclamation case before the Cumlic is, logically, no longer viable after a proclamation has been made. However, this rule admits of exceptions, as when the proclamation is null and void. The proclamation of petitioner in this case is void for 3 reasons. It was based on a canvass that should have been suspended with respect to the contested election returns. It was done without prior Cumlic authorization, which is required in view of the unresolved objections of Talib to the inclusion of certain returns in the canvass. And it was predicated on a canvass that included unsigned election returns involving such number of votes as will affect the outcome of the election. In this regard, it has long been recognized that among the reliefs that the Cumlic may grant is to nullify a proclamation or suspend the effects of one. Assuming, however, that Sector 20 of RA number 7166 was not complied with, Talib cannot be faulted or made to suffer for such non-compliance, as it was the MBC who did not comply with its duties under Sector 20 of RA number 7166. When Talib made his objections to the inclusion of the contested election returns, there was no other recourse for the MBC except to rule on the objections, suspend the canvass of the contested election returns, and suspend the proclamation of petitioner, in that sequence. Instead of doing so, the MBC, after ruling on the objections, included the contested returns in the canvass and immediately proclaimed petitioner. These actions of the MBC rendered it impossible for Talib to comply with Sector 20 of RA number 7166 any further. It should be noted that the 48-hour period for filing a verified notice of appeal with the MBC is reckoned from suspension of the canvass. The appeal to the Cumlic is also reckoned 5 days from suspension of the canvass. Understandably, Talib had no other recourse but to go directly to the Cumlic. It is worthy of note that what was filed with and resolved by the poll body is a pre-proclamation case. Pre-proclamation cases refer to any question pertaining to or affecting the proceedings of the Board of Canvassers which may be raised by any candidate or by any registered political party or coalition of political parties before the Board or directly with the Commission, or any matter raised under Sections 233, 234, 235 and 236 in relation to the preparation, transmission, receipt, custody, and appreciation of election returns. Issue 1. The order of the RDC of Holo, Sulu in election protest case No May 4, 04 upholding petitioner's proclamation as mayor of Indanan, Sulu precludes the Cumlic from issuing the assailed resolutions held no ratio. Note that election protest case No May 4, 04 is an election protest case filed by Isnaji, the third candidate for the position of mayor against petitioner and Talib. Being an election protest or a post-proclamation case, it is markedly different from the case filed by Talib before the Cumlic, which is a pre-proclamation case. Verily, the order of the trial court in the election protest case does not conflict with nor diminish the legal effect of the Cumlic and Bank resolution, invalidating 8 of the 9 questioned election returns. Particularly, the order is not inconsistent with the directive of the Cumlic to the election officer of Indanan to convene the Bay in the concerned precincts for a recount. After notice to the parties and after ensuring that the integrity of the ballot boxes are not compromised, the order of the trial court directed a dismissal of the election protest on a technicality, that is, for failure of Isnaji as Protestant to prosecute the protest. No election returns were examined and no ballots revised. The questioned election returns could not have been examined before the trial court because they were already with the Cumlic at that time in connection with Talib's pre-proclamation case. The trial court perfunctorily considered the report of the revision committee and on that basis concluded that it was no longer necessary to continue with the case because of petitioner's enormous lead over Isnaji, not Talib. Although denominated as a respondent in election protest case No May 4, 04, Talib could not be expected to participate therein because of his pending pre-proclamation case with the Cumlic. Had he participated in the election protest, his pre-proclamation case would have been deemed abandoned because the general rule is that the filing of an election protest or a petition for quo warranto precludes the subsequent filing of a pre-proclamation controversy, or amounts to the abandonment of one earlier filed. Without a doubt, the dismissal of election protest case No May 4, 04 could not have cast an adverse or prejudicial effect on Talib's pending pre-proclamation case. Issue 1. The Cumlic observed the procedure outlined in Section 235 of BP 881 held yes ratio. Contrary to petitioner's contention, the Cumlic fully complied with this court's exhortation in Daglock v. Cumlic that the provision be followed to ascertain the will of the electorate. Indeed, the Cumlic did not instantaneously nullify the questioned election returns as claimed by petitioner. Utilizing the first procedure contained in the first sentence of Sector 235, the Cumlic used other copies of said suspect election returns, namely the election returns submitted by Talib. When this was not enough, it even resorted to an examination of the Cumlic copies. And when it was evident that the election returns for the 9 precincts were manufactured or fabricated because the printed names and signatures of the members of the Bay were absent, it was only then that the Cumlic annulled the said election returns and petitioner's proclamation. The Cumlic thereafter ordered the election officer of Indanan to convene the Bay in the concerned precincts for a recount, if possible, or to report to the Cumlic the impossibility of a recount so that a special election can be immediately scheduled. Clearly, the issuances of the Cumlic can hardly be described as precipitate and premature. Issue 1. It was proper for Cumlic to pierce the veil of election returns held no ratio. It is a well-entrenched rule in jurisprudence that in a pre-proclamation controversy, the Board of Canvassers and the Cumlic are not to look beyond or behind election returns which are on their face regular and authentic returns. In Chu v. Cumlic, aside from reiterating the rule against piercing the veil of returns, this court intimated that a pre-proclamation case is the proper remedy if the defects and irregularities are apparent from a physical inspection of the election returns. In the case at bar, the Cumlic did not have to look at other evidence to conclude that the election returns were manufactured because the defects were apparent on the face of the election returns themselves. In fact, a detailed description of each questioned election return was provided in the resolution of the Cumlic. Forum shopping, the relief sought in the extreme urgent ex parte manifestation is basically the same as the prayer for a temporary restraining order in the present petition, which was still pending resolution by this court at the time the extreme urgent ex parte manifestation was filed before the Cumlic. However, for as long as the present petition, including the prayer for injunctive relief, pens before this court, the assailed Cumlic resolutions remain presumptively valid. With the filing of the present petition, only this court has jurisdiction to nullify the Cumlic resolutions or suspend their enforcement. Another violation of the ban against forum shopping lies in petitioners' failure to inform this court of its filing of the extreme urgent ex parte manifestation with the Cumlic. What is worse than petitioners' forum shopping is the poll body's favorable action on petitioners' extreme urgent ex parte manifestation despite knowledge of the pending petition with this court. Such action on the part of Cumlic should not be countenanced and deserves disapprobation. Position of municipal mayor. The local government code is clear on the matter of succession. Sector 44 of RA number 7160 and Art. 83, Rule 14 of the implementing rules of the Local Government Code governing vacancies and succession, quoted below, apply. Sector 44. Permanent vacancies in the offices of the Governor, Vice-Governor, Mayor, and Vice-Mayor. If a permanent vacancy occurs in the office of the Governor or Mayor, the Vice-Governor or Vice-Mayor concerned shall become the Governor or Mayor. If a permanent vacancy occurs in the offices of the Governor, Vice-Governor, Mayor, or Vice-Mayor, the highest-ranking Sangunian member or, in case of his permanent inability, the second highest-ranking Sangunian member shall become the Governor, Vice-Governor, Mayor, or Vice-Mayor as the case may be. Subsequent vacancies in the said office shall be filled automatically by the other Sangunian members according to their ranking as defined herein. If a permanent vacancy occurs in the office of the Punang Barangay, the highest-ranking Sangunian Barangay member or, in case of his permanent inability, the second highest-ranking Sangunian member, shall become the Punang Barangay. A tie between or among the highest-ranking Sangunian members shall be resolved by the drawing of lots. The successors as defined herein shall serve only the unexpired terms of their predecessors. For purposes of this chapter, a permanent vacancy arises when an elective local official fills a higher vacant office, refuses to assume office, fails to qualify, dies, is removed from office, voluntarily resigns, or is otherwise permanently incapacitated to discharge the functions of his office. For purposes of succession as provided in this chapter, ranking in the Sangunian shall be determined on the basis of the proportion of votes obtained by each winning candidate to the total number of registered voters in each district in the immediately preceding local election. Verily, the vacancy created by the nullification of petitioner's proclamation is in the nature of a permanent vacancy and may be qualified as a permanent incapacity to discharge the functions of his office. Ahajan's assumption of the office of mayor should be understood as subject to the result of the recount to be conducted in accordance with the issuances of the Cumlic. Thus, there is an immediate need for the Cumlic to speedily ascertain the true will of the electorate in the 8 precincts whose election returns were nullified. Labo, J.R.V. Cumlic, Supra. The doctrine of residential judicata does not apply to questions of citizenship. Modes of losing Philippine citizenship. Naturalization in a foreign country, express renunciation of citizenship, subscribing to an oath of allegiance to support the constitution or laws of a foreign country. The annulment of Labo's Australian citizenship as a result of the finding that his marriage to an Australian national was bigamous did not automatically restore his Philippine citizenship. Menzin v. Petala 197 SCRA 251. Facts: on February 16, 1988, by virtue of the fact that no governor had been proclaimed in the province of Leyte, the Secretary of Local Government Luis Santos designated the Vice-Governor, Leopoldo E. Petala, as acting governor of Leyte. On March 25, 1988, Aurelio D. Menzin, a senior member of the Sangguniang Panlalawigan, was also designated by Secretary Luis Santos to act as the vice-governor for the province of Leyte. Menzin took his oath of office before Senator Alberto Romulo. The provincial administrator, Tentu Quintero, inquired from the Undersecretary of the DILG as to the legality of the appointment of the petitioner to act as the vice-governor of Leyte. Undersecretary Rubler stated that since BP 337 has no provision relating to succession in the office of the vice-governor in case of a temporary vacancy, the appointment of the petitioner as the temporary vice-governor is not necessary, since the vice-governor who is temporarily performing the functions of the governor could concurrently assume the functions of both offices. As a result of the foregoing communications between Tentu Quintero and Jacinto T. Rubilar, Jr., the Sangguniang Panlalawigan, in a special session held on July 7, 1989, issued Resolution No. 505, where it held invalid the appointment of the petitioner as acting vice-governor of Leyte. The petitioner, through the acting LDP Regional Council, Attorney Zosimo Alegre, sought clarification from Undersecretary Rubilar, Jr. regarding the June 22, 1989 opinion. Undersecretary Rubilar replied and explained his opinion, on the basis of the foregoing and considering that the law is silent in case of temporary vacancy, in the office of the vice-governor. It is our view that the peculiar situation in the province of Leyte, where the electoral controversy in the office of the governor has not yet been settled, calls for the designation of the Sangguniang member to act as vice-governor temporarily. In view of the clarificatory letter of Undersecretary Rubilar, the regional director of the DILG, Region 8, Resurrection Salvatierra, on July 17, 1989, wrote a letter addressed to the acting governor of Leyte, Leopoldo E. Petala, requesting the latter that Resolution No. 505 of the Sangguniang Panlalawigan be modified accordingly. Despite these several letters of request, the acting governor and the Sangguniang Panlalawigan refused to correct Resolution No. 505 and correspondingly to pay the petitioner the emoluments attached to the office of vice-governor. Thus, petitioner filed before this court a petition for certiorari and mandamus. The petition sought the nullification of Resolution No. 505 and for the payment of his salary for his services as the acting vice-governor of Leyte. In the meantime, however, the issue on the governorship of Leyte was settled and Adelino Larrazabal was proclaimed the governor of the province of Leyte. Issue 1. There was a vacancy held yes ratio. The law on public officers is clear on the matter. There is no vacancy whenever the office is occupied by a legally qualified incumbent. A sensu contrario, there is a vacancy when there is no person lawfully authorized to assume and exercise at present the duties of the office. Applying the definition of vacancy to this case, it can be readily seen that the office of the vice-governor was left vacant when the duly elected vice-governor Leopoldo Petala was appointed acting governor. In the eyes of the law, the office to which he was elected was left barren of a legally qualified person to exercise the duties of the office of the vice-governor. There is no satisfactory showing that Petala, notwithstanding his succession to the office of the governor, continued to simultaneously exercise the duties of the vice-governor. The nature of the duties of a provincial governor call for a full-time occupant to discharge them. More so when the vacancy is for an extended period. Precisely, it was Petala's automatic assumption to the acting governorship that resulted in the vacancy in the office of the vice-governor. The fact that the Secretary of Local Government was prompted to appoint the petitioner shows the need to fill up the position during the period it was vacant. The department secretary had the discretion to ascertain whether or not the provincial governor should devote all his time to that particular office. Moreover, it is doubtful if the provincial board, unilaterally acting, may revoke an appointment made by a higher authority. Issue 1. The Secretary of Local Government had the authority to designate the petitioner. Held yes ratio. The Local Government Code is silent on the mode of succession in the event of a temporary vacancy in the office of the Vice Governor. However, the silence of the law must not be understood to convey that a remedy in law is wanting. The circumstances of the case reveal that there is indeed a necessity for the appointment of an acting Vice Governor. For about 2 years after the gubernatorial elections, there had been no de jure permanent governor for the province of Leyte. Governor Adelino Larrazabal, at that time, had not yet been proclaimed due to a pending election case before the Commission on Elections. The 2-year interregnum which would result from the respondents' view of the law is disfavored as it would cause disruptions and delays in the delivery of basic services to the people and in the proper management of the affairs of the local government of Leyte. Definitely, it is incomprehensible that to leave the situation without affording any remedy was ever intended by the Local Government Code. Under the circumstances of this case and considering the silence of the Local Government Code, the court rules that, in order to obviate the dilemma resulting from an interregnum created by the vacancy, the President, acting through her alter ego, the Secretary of Local Government, may remedy the situation. We declare valid the temporary appointment extended to the petitioner to act as the Vice Governor. The exigencies of public service demanded nothing less than the immediate appointment of an acting Vice Governor. It may be noted that under Commonwealth Act No. 588 and the Revised Administrative Code of 1987, the President is empowered to make temporary appointments in certain public offices, in case of any vacancy that may occur. Albeit both laws deal only with the filling of vacancies in appointive positions. However, in the absence of any contrary provision, in the Local Government Code and in the best interest of public service, we see no cogent reason why the procedure thus outlined by the two laws may not be similarly applied in the present case. The respondents contend that the provincial board is the correct appointing power. This argument has no merit. As between the President who has supervision over local governments as provided by law and the members of the board who are junior to the Vice Governor, we have no problem ruling in favor of the President, until the law provides otherwise. A vacancy creates an anomalous situation and finds no approbation under the law, for it deprives the constituents of their right of representation and governance in their own local government. In a republican form of government, the majority rules through their chosen few, and if one of them is incapacitated or absent, etc., the management of governmental affairs to that extent may be hampered. Necessarily, there will be a consequent delay in the delivery of basic services to the people of Leyte if the governor or the vice governor is missing. The appointment of the petitioner, moreover, is in full accord with the intent behind the Local Government Code. There is no question that Section 49 in connection with Section 52 of the Local Government Code shows clearly the intent to provide for continuity in the performance of the duties of the vice governor. By virtue of the surrounding circumstance of this case, the mode of succession provided for permanent vacancies may likewise be observed in case of a temporary vacancy in the same office. In this case, there was a need to fill the vacancy. The petitioner is himself the member of the Sangguniang Panlalawigan who obtained the highest number of votes. The department secretary acted correctly in extending the temporary appointment. In view of the foregoing, the petitioner's right to be paid the salary attached to the office of the vice-governor is indubitable. The compensation, however, to be remunerated to the petitioner, following the example in Commonwealth Act No. 588 and the Revised Administrative Code, and pursuant to the proscription against double compensation, must only be such additional compensation as, with his existing salary, shall not exceed the salary authorized by law for the office of the vice-governor. And finally, even granting that the President, acting through the Secretary of Local Government, possesses no power to appoint the petitioner, at the very least, the petitioner is a de facto officer entitled to compensation. There is no denying that the petitioner assumed the office of the vice-governor under color of a known appointment. As revealed by the records, the petitioner was appointed by no less than the alter ego of the President, the Secretary of Local Government. After which he took his oath of office before Senator Alberto Romulo in the office of Department of Local Government Regional Director Residential Salvatierra. Conceitedly, the appointment has the color of validity. The respondents themselves acknowledged the validity of the petitioner's appointment and dealt with him as such. It was only when the controversial Resolution No. 505 was passed by the same persons who recognized him as the acting vice-governor that the validity of the appointment of the petitioner was made an issue and the recognition withdrawn. The petitioner, for a long period of time, exercised the duties attached to the office of the vice-governor. He was acclaimed as such by the people of Leyte. Upon the principle of public policy on which the de facto doctrine is based and basic considerations of justice, it would be highly iniquitous to now deny him the salary due him for the services he actually rendered as the acting vice-governor of the province of Leyte. Docena v. Sang. Panlalawigan of Eastern Samar. Facts: Luis Capito, elected and serving as member of the Sangguniang Panlalawigan, died in office. Petitioner Agustin Docena was appointed to succeed Capito. This appointment was issued by Department of Local Government Secretary Santos on November 19, 1990. November 27, for unknown reasons, respondent Socrates Aller was also appointed by Secretary Santos to the position already occupied by Docena. December 18, the SP passed Resolution No. 75 recognizing Aller rather than Docena as legitimate successor of the late Capito. December 19. Secretary Santos sent a letter to Aller, informing the latter of the prior appointment of Docena and recalling Aller's appointment. Issue: 1. Docena should be the appointed member to the Sangguniang Panlalawigan. Held: yes. Ratio: the pertinent legal provision is Section 50, LGC. SEC 50. Permanent vacancies in local Sanggunians. Except for the Sangguniang Barangay, the appointee shall come from the political party of the Sanggunian member who caused the vacancy, and shall serve the unexpired term of the vacant office. 1. From the tenor of the appointment extended to Docena on November 19, 1990, there is no question that it was intended to be permanent. Petitioner's appointment had already become complete and enforceable at the time it was supposed to have been superseded by the appointment in favor of Aller. Docena had already acquired security of tenure in the position and could be removed therefrom only for any of the causes, and conformably to the procedure, prescribed by the Local Government Code. These requirements could not be circumvented by the simple process of recalling his appointment. 2. The respondents are ambivalent about the power of the Secretary of Local Government to recall his appointments. They described the December 19 recall of Aller as whimsical, capricious and wishy-washy for lack of a previous hearing. A point of local officials common to all municipalities, cities, and provinces. Durama v. Ca. Facts: Petitioner Conrado L. Derrama, Mayor of Pagbilao, Quezon, wrote a letter to the Civil Service Commission seeking the recall of the appointments of 14 municipal employees. Petitioner Derrama justified his recall request on the allegation that the appointments of said employees were midnight appointments of the former mayor, Ma. Evelyn S. Abeja, done in violation of Article 7, Section 15 of the 1987 Constitution. 3 of the said employees, namely, Elsa Marino, Morel Ayala, and Flor Eliza Oriazel, filed with the CSC a claim for payment of their salaries, alleging that although their appointments were declared permanent by Conrado Guilhem, Director 2 of the CSC field office based in Quezon, Petitioner Derrama withheld the payment of their salaries and benefits pursuant to Office Order No. 95-01. Based on the documents submitted by Marino, Ayala, and Oriazel, the Legal and Quasi-Judicial Division of the CSC issued an order finding that since the claimants' employees had assumed their respective positions and performed their duties pursuant to their appointments, they are entitled to receive the salaries and benefits appurtenant to their positions. The CSC Legal and Quasi-Judicial Division ruled that the said employees cannot be deprived of their salaries and benefits by the unilateral act of the newly assumed mayor. CSC denied petitioner's request for the recall of appointments of the 14 employees, for lack of merit, and declared that the appointments of the said employees were issued in accordance with pertinent laws and cannot be withdrawn or revoked by the appointing authority until disproved by the CSC. Furthermore, CSC dismissed petitioner's allegation that these were midnight appointments. Constitutional provision prohibits only those appointments made by an outgoing president and cannot apply to local elective officials. CSC upheld the validity of the appointments, and petitioner's failure to present evidence would warrant the revocation or recall of the said appointments. Petitioner moved for the reconsideration of the CSC's resolution, averring that the CSC was without jurisdiction to refuse to revoke the subject appointments, and to uphold the validity of said appointments, even assuming there was failure to present evidence. Issue: whether or not Article 7, Section 15 of the Constitution covers local elective officials. Decision: no. Records reveal that when the petitioner brought the matter of recalling the appointments of the 14 private respondents before the CSC, the only justification he gave was that these were midnight appointments that are forbidden under Article 7, Section 15 of the Constitution. The CSC ruled, and correctly so, that the said prohibition applies only to presidential appointments. In truth, there is no law that prohibits local elective officials from making appointments during the last days of his or her tenure. Dissenting opinion, Mendoza. What the majority overlooks is that Article 7, Section 15 is simply an application of a broader principle that after the appointing authority has lost the elections, his is the duty of a prudent caretaker of the office. And therefore, he should not fill positions in the government unless required by the imperatives of public service. Leagues of Local Barangay Units and Elective Officials David V. Cumlic. Facts: in his capacity as Barangay Chairman of Barangay 77, Zone 7, Caloocan City and as President of the Liga NGMGA Barangay SA Pilipinas, Alex L. David filed a petition for prohibition to prohibit the holding of the barangay election scheduled on the second Monday of May 1997. Petitioner Liga NGMGA Barangay Quezon City Chapter represented by its President Bonifacio M. Rilan filed a petition to seek a judicial review by certiorari to declare as unconstitutional 1 Section 43 of R.A. 7160, which reads as follows. The term of office of barangay officials and members of the Sangguniang Kabataan shall be for 3 years, which shall begin after the regular election of barangay officials on the second Monday of May 1994. 2 Cumlic Resolution NOS 2880 and 2887 fixing the date of the holding of the barangay elections on May 12, 1997 and other activities related thereto. 3. The budgetary appropriation of P400 million contained in Republic Act No. 8250, otherwise known as the General Appropriations Act of 1997, intended to defray the costs and expenses in holding the 1997 barangay elections. Both petitions, though worded differently, raise the same ultimate issue. How long is the term of office of barangay officials? Petitioners contend that under Sector 2 of RA 6653, the term of office of barangay officials shall be for 5 years. This is reiterated in RA 6679. Petitioners further aver that although Sector 43 of RA 7160 reduced the term of office of all local elective officials to 3 years, such reduction does not apply to barangay officials because RA 6679 is a special law applicable only to barangays, while RA 7160 is a general law which applies to all other local government units. RA 7160 does not expressly or impliedly repeal RA 6679 insofar as the term of barangay officials is concerned, while Sections 8 of Article X of the 1987 Constitution fixes the term of elective local officials at 3 years. The same provision states that the term of barangay officials shall be determined by law, and thus it follows that the constitutional intention is to grant barangay officials any term, except 3 years, otherwise there would be no rhyme or reason for the framers of the Constitution to accept barangay officials from the 3-year term found in Sections 8. Article X of the Constitution. Cumlick maintains that RA 7160 repealed all other special laws relied upon by the petitioner. Issue 1. The term of the barangay officials should be limited only to 3 years. Held yes ratio. In light of the brief historical background, the intent and design of the legislature to limit the term of barangay officials to only 3 years as provided under the Local Government Code emerges as bright as the sunlight. The cardinal rule in the interpretation of all laws is to ascertain and give effect to the intent of the law. And 3 years is the obvious intent. First, RA 7160, the Local Government Code, was enacted later than RA 6679. It is basic that in case of an irreconcilable conflict between 2 laws of different vintages, the later enactment prevails. Legis posteriors priores contractarius abrogant. The rationale is simple: a later law repeals an earlier one because it is the later legislative will. It is to be presumed that the lawmakers knew the older law and intended to change it. In enacting the older law, the legislators could not have known the newer one and hence could not have intended to change what they did not know. Under the Civil Code, laws are repealed only by subsequent ones and not the other way around. Under Sections 43C of RA 7160, the term of office of barangay officials was fixed at 3 years, which shall begin after the regular election of barangay officials on the second Monday of May 1994. This provision is clearly inconsistent with and repugnant to Sector 1 of RA 6679, which states that such term shall be for 5 years. Note that both laws refer to the same officials who were elected on the second Monday of May 1994. Second, RA 6679 requires the barangay voters to elect 7 kagawads, and the candidate obtaining the highest number of votes shall automatically be the punang barangay. RA 6653 empowers the 7 elected barangay kagawads to select the punang barangay from among themselves. On the other hand, the Local Autonomy Code mandates a direct vote on the barangay chairman by the entire barangay electorate, separately from the 7 kagawads. Hence, under the code, voters elect 8 barangay officials, namely, the punang barangay plus the 7 kagawads. Under both RA 6679 and 6653, they vote for only 7 kagawads, and not for the barangay chairman. Third, during the barangay elections held on May 9, 1994, the voters actually and directly elected 1 punang barangay and 7 kagawads. If we agree with the thesis of petitioners, it follows that all the punang barangays were elected illegally, and thus, petitioner Alex David cannot claim to be a validly elected barangay chairman, much less president of the National League of Barangays, which he purports to represent in this petition. It then necessarily follows also that he is not the real party in interest, and on that ground, his petition should be summarily dismissed. Fourth, in enacting the General Appropriations Act of 1997, Congress appropriated the amount of P400 million to cover expenses for the holding of barangay elections this year. Likewise, under Sections 7 of RA 8189, Congress ordained that a general registration of voters shall be held immediately after the barangay elections in 1997. These are clear and express contemporaneous statements of Congress that barangay officials shall be elected this May, in accordance with Sector 43C of RA 7160. Fifth, in Paras vs. Cumlic, this court said that the next regular election involving the barangay office concerned is barely 7 months away, the same having been scheduled in May 1997. This judicial decision, per Article 8 of the Civil Code, is now a part of the legal system of the Philippines. Sixth, petitioners pompously claim that RA 6679, being a special law, should prevail over RA 7160, all alleged general law pursuant to the doctrine of generalis specialibus non derogant. Petitioners are wrong. RA 7160 is a codified set of laws that specifically applies to local government units. It specifically and definitively provides in its Sector 43C that the term of office of barangay officials shall be for 3 years. It is a special provision that applies only to the term of barangay officials who were elected on the second Monday of May 1994. With such particularity, the provision cannot be deemed a general law. Petitioner may be correct in alleging that RA 6679 is a special law, but they are incorrect in stating that RA 7160 is necessarily a general law. It is a special law insofar as it governs the term of office of barangay officials. In its repealing clause, RA 7160 states that all general and special laws, which are inconsistent with any of the provisions of this code, are hereby repealed or modified accordingly. There being a clear repugnance and incompatibility between the two specific provisions, they cannot stand together. The later law, RA 7160, should thus prevail in accordance with its repealing clause. When a subsequent law encompasses entirely the subject matter of the former enactments, the latter is deemed repealed. Issue 1. The 3-year term is in accord with the Constitution. Held yes ratio, Petitioner Liga NGMGA Barangay Quezon City Chapter posits that by accepting barangay officials whose term shall be determined by law from the general provision fixing the term of elective local officials at 3 years, the Constitution thereby impliedly prohibits Congress from legislating a 3-year term for such officers. We find this theory rather novel but nonetheless logically and legally flawed. Undoubtedly, the Constitution did not expressly prohibit Congress from fixing any term of office for barangay officials. It merely left the determination of such term to the lawmaking body, without any specific limitation or prohibition, thereby leaving to the lawmakers full discretion to fix such term in accordance with the exigencies of public service. It must be remembered that every law has in its favor the presumption of constitutionality. 38. For a law to be nullified, it must be shown that there is a clear and unequivocal breach of the Constitution. 39. To strike down a law as unconstitutional, there must be a clear and unequivocal showing that what the fundamental law prohibits, the statute permits. The petitioners have miserably failed to discharge this burden and to show clearly the unconstitutionality they aver. There is absolutely no doubt in our mind that Sector 43C of RA 7160 is constitutional. Seconds. 8. Article X of the Constitution limiting the term of all elective local officials to 3 years. Except that of barangay officials, which shall be determined by law, was an amendment proposed by Constitutional Commissioner Ilario G. Davide, Jr. according to Fr. Joaquin G. Bernas, S.J., the amendment was readily accepted without much discussion and formally approved. Indeed, a search into the record of the Constitutional Commission yielded only a few pages of actual deliberations. Issue 1. Petitioners are stopped from challenging their 3-year terms. Held yes ratio. Respondent Commission on Elections submitted as Annex A of its Memorandum, 43 a machine copy of the Certificate of Candidacy of Petitioner Alex L. David in the May 9, 1994 barangay elections, the authenticity of which was not denied by said petitioner. In said Certificate of Candidacy, he expressly stated under oath that he was announcing his candidacy for the office of Punang Barangay for Barangay 77, Zone 7 of Caloocan City, and that he was eligible for said office. The COMELEC also submitted as Annex B 44 to its said memorandum, a certified statement of the votes obtained by the candidates in said elections. If, as claimed by petitioners, the applicable law is RA 6679, then petitioner David should not have run and could not have been elected chairman of his barangay because under RA 6679, there was to be no direct election for the Punang barangay. The Kagawad candidate who obtained the highest number of votes was to be automatically elected barangay chairman. Thus, applying said law, the Punang barangay should have been Ruben Magalona, who obtained the highest number of votes among the Kagawads 150, which was much more than David's 112. The electorate should have elected only 7 Kagawads and not 1 Punang barangay plus 7 Kagawads. In other words, following petitioner's own theory, the election of petitioner David as well as all the barangay chairmen of the 2 Liga petitioners was illegal. The sum total of these absurdities in petitioner's theory is that barangay officials are stopped from asking for any term other than that which they ran for and were elected to, under the law governing the very claim to such offices. Namely, RA 7160. The Local Government Code. Petitioners' belated claim of ignorance as to what law governed their election to office in 1994 is unacceptable because under Art. 3 of the Civil Code, ignorance of the law excuses no one from compliance therewith. Private counsel/lawyers for elective local officials Alinsig v. RDC and Mayor Ponseca. Facts: Zonceta Alinsig had been a regular employee of the municipal government of Escalante, Negros Occidental. When she received a permanent appointment as Clerk 3 in the office of the Municipal Planning and Development Coordinator of the same municipality, Mayor Rolando Ponseca detailed her to the office of the mayor. On June 19, 1992, Zonceta absented herself from work allegedly to attend to family matters. She had asked permission from the personnel officer but not from the mayor. Mayor Ponsica issued Office Order No. 31, suspending Zonzetta for 1 month and 1 day commencing on June 24, 1992 for a simple misconduct which can also be categorized as an act of insubordination. The order also stated that the suspension carries with it forfeiture of benefits such as salary and para and leave credits during the duration of its effectivity. Zonzetta filed with the RDC a petition for injunction with damages. She alleged that her suspension was an act of political vendetta. Mayor Ponsica, through private practitioner Samuel S. M. Lezama, claimed that Zonzetta had not yet exhausted administrative remedies and that her suspension was in accordance with law. The foregoing elicited a motion from the petitioner, praying that the answer be disregarded and expunged from the record, and that the respondents be all declared in default on the ground that since the respondents were sued in their official capacities, not including their private capacities, they should have been represented by either the municipal legal officer or the provincial legal officer or prosecutor as provided for by Sector 481N of the Local Government Code. It also cited Sector 1 of Rep. Act No. 10 and Art. 177 of the RPC, which penalizes usurpation of public authority. The respondents opposed the motion, manifesting that the municipality of Escalante has no legal officer. They asserted that both the Local Government Code and the Administrative Code of 1987 do not have any provision relative to the duty of any provincial legal officer or prosecutor to represent a municipality or its officials in suits filed against them by an employee or a private individual. They contended that it was unnecessary to provide such a provision because their administrative and judicial rulings sustaining the validity of the employment of a private counsel by municipal officials. The lower court issued the order denying the motion on the thesis that since the appointment of a legal officer was optional on the part of the municipal government, Art. 481, third paragraph, Local Government Code, and the municipality of Escalante had not, in fact, designated any such legal officer. Petitioners moved to declare respondents in default for having retained a private counsel was not thereby legally sustainable. Issue 1. A private counsel may represent municipal officials sued in their official capacities. Ratio. It appears that the law allows a private counsel to be hired by a municipality only when the municipality is an adverse party in a case involving the provincial government or another municipality or city within the province. This provision has its apparent origin in the ruling in Digia v. the Auditor General, where the court held that the municipality's authority to employ a private attorney is expressly limited only to situations where the provincial fiscal would be disqualified to serve and represent it. With Sector 1683 of the old Administrative Code as legal basis, the court therein cited Enriquez, Sr. v. Gimenez, which enumerated instances when the provincial fiscal is disqualified to represent in court a particular municipality. If and when original jurisdiction of case involving the municipality is vested in the Supreme Court, when the municipality is a party adverse to the provincial government or to some other municipality in the same province, and when, in a case involving the municipality, he, or his wife, or child, is pecuniarily involved, as heir legatee, creditor, or otherwise. Thereafter, in Ramos v. Court of Appeals, the court ruled that a municipality may not be represented by a private law firm which had volunteered its services gratis, in collaboration with the municipal attorney and the fiscal, as such representation was violative Sector 1683 of the old Administrative Code. This strict coherence to the letter of the law appears to have been dictated by the fact that the municipality should not be burdened with expenses of hiring a private lawyer and that the interests of the municipality would be best protected if a government lawyer handles its litigations. But would these proscriptions include public officials? Not necessarily. It can happen that a government official, ostensibly acting in his official capacity and sued in that capacity, is later held to have exceeded his authority. On the one hand, his defense would have then been underwritten by the people's money, which ordinarily should have been his personal expense. On the other hand, personal liability can attach to him without, however, his having had the benefit of assistance of a counsel of his own choice. In Korea v. CFI of Bullock and 10, the court held that in the discharge of governmental functions, municipal corporations are responsible for the acts of its officers, except if and when, the only to the extent that they have acted by authority of the law, and in conformity with the requirements thereof. In such instance, this court has sanctioned that representation by private counsel. In one case, we held that where rigid adherence to the law on representation of local officials in court actions could deprive a party of his right to redress for a valid grievance, the hiring of a private counsel would be proper. And, in Albura v. Torres, this court also said that a provincial governor sued in his official capacity may engage the services of private counsel when the complaint contains other allegations in a prayer for moral damages, which, if due from the defendants, must be satisfied by them in their private capacity. The key then to resolving the issue of whether a local government official may secure the services of private counsel, in an action filed against him in his official capacity, lies on the nature of the action and the relief that is sought. While the petition below was filed against respondents as public officials, its allegations were also aimed at questioning certain acts that can well bring the case beyond the mere confines of official functions, thus too. 12. These accusations of the respondent mayor in detailing petitioner to his office and eventually suspending her from work, particularly the latter, are no doubt respondent mayor's political vendetta of petitioner. A vengeance unleashed on her for her children's and family's not going with and voting for him in the May 11, 1992 election and instead supporting the candidacy of their relative candidate in said election, who was his great worry at that time. 2. 13. The aforesaid acts of respondent mayor are clearly, apparently, and obviously a political harassment and persecution, oppressive, acts of vindictiveness, a grave abuse of executive discretion, despotic, unjust, unwarranted, condemnable and actionable. The indefinite detail order and, especially the suspension, were not done in good faith, not for a valid cause, and done without giving petitioner opportunity to be heard, hence null and void for being violative of petitioner's legal and constitutional right to due process. The petition then went on to claim moral and exemplary damages, as well as litigation expenses, as shown by its prayer. Moral damages cannot generally be awarded unless they are the proximate result of a wrongful act or omission. Exemplary damages, on the other hand, are not awarded if the defendant had not acted in a wanton, oppressive, or malevolent manner nor in the absence of gross or reckless negligence. A public official, who in the performance of his duty acts in such fashion, does so in excess of authority, and his actions would be ultra vires that can thereby result in an incurrence of personal liability. Municipality of Pililaya, Rizal VCA. Facts: the RDC rendered judgment in favor of petitioner Municipality of Pilila, Rizal, against private respondent Philippine Petroleum Corporation, ordering therein defendant to pay said plaintiff the amount of P5,301,385.00 representing the tax on business due from the defendant under Section 9 of Municipal Tax Ordinance No. 1 of said municipality for the period from 1979 to 1983. The SC affirmed the judgment with modification. Attorney Felix E. Mendiola filed a motion in behalf of plaintiff municipality with the RDC for the examination of defendant corporation's gross sales for the years 1976 to 1978 and 1984 to 1991 for the purpose of computing the tax on business imposed under the Local Tax Code, as amended. The corporation filed a manifestation to the effect that the mayor already received the sum as evidenced by the release and quit claim documents executed by said mayor. The court below issued an order denying plaintiff municipality's motion for examination and execution of judgment on the ground that the judgment in question had already been satisfied. When attorney Mendiola filed a petition for certiorari with the SC, PPC filed a motion questioning Attorney Mendiola's authority to represent petitioner municipality. The CA dismissed the petition for having been filed by a private counsel in violation of law and jurisprudence, but without prejudice to the filing of a similar petition by the municipality of Pilila through the proper provincial or municipal legal officer. Issue 1. Attorney Mendiola has authority to file a petition in behalf of the municipality. Held no ratio, the Court of Appeals is correct in holding that Attorney Mendiola has no authority to file a petition in behalf of and in the name of the municipality of Pilila. The matter of representation of a municipality by a private attorney has been settled in Ramos vs Court of Appeals, ETL, and reiterated in Province of Cebu vs Intermediate Appellate Court, ETL, where we ruled that private attorneys cannot represent a province or municipality in lawsuits. Under the above provision, complemented by Section 3, Republic Act No. 2264, the Local Autonomy Law, only the provincial fiscal and the municipal attorney can represent a province or municipality in their lawsuits. The provision is mandatory. The municipality's authority to employ a private lawyer is expressly limited only to situations where the provincial fiscal is disqualified to represent it. For the aforementioned exception to apply, the fact that the provincial fiscal was disqualified to handle the municipality's case must appear on record. In the instant case, there is nothing in the records to show that the provincial fiscal is disqualified to act as counsel for the municipality of Pilila on appeal, hence the appearance of herein private counsel is without authority of law. The submission of Attorney Mendiola that the exception is broad enough to include situations wherein the provincial fiscal refuses to handle the case cannot be sustained. The fiscal's refusal to represent the municipality is not a legal justification for employing the services of private counsel. Unlike a practicing lawyer who has the right to decline employment, a fiscal cannot refuse to perform his functions on grounds not provided for by law without violating his oath of office. Instead of engaging the services of a special attorney, the municipal council should request the Secretary of Justice to appoint an acting provincial fiscal in place of the provincial fiscal who has declined to handle and prosecute its case in court. Pursuant to Section 1679 of the Revised Administrative Code. It is also significant that the lack of authority of herein counsel, Attorney Mendiola, was even raised by the municipality itself in its comment in opposition to said council's motion for execution of his lien, which was filed with the court a quo by the Office of the Provincial Prosecutor of Rizal in behalf of said municipality. The contention of Attorney Mendiola that private respondent cannot raise for the first time on appeal his lack of authority to represent the municipality is untenable. The legality of his representation can be questioned at any stage of the proceedings. In the cases hereinbefore cited, the issue of lack of authority of private counsel to represent a municipality was only raised for the first time in the proceedings for the collection of attorney's fees for services rendered in the particular case, after the decision in that case had become final and executory and/or had been duly executed. Furthermore, even assuming that the representation of the municipality by Attorney Mendiola was duly authorized, said authority is deemed to have been revoked by the municipality when the latter, through the municipal mayor and without said council's participation, entered into a compromise agreement with herein private respondent with regard to the execution of the judgment in its favor and thereafter filed personally with the court below two pleadings entitled and constitutive of a satisfaction of judgment and a release and quit claim. A client, by appearing personally and presenting a motion by himself, is considered to have impliedly dismissed his lawyer. Herein counsel cannot pretend to be authorized to continue representing the municipality since the latter is entitled to dispense with his services at any time. Both at common law and under Section 26, Rule 138 of the Rules of Court, a client may dismiss his lawyer at any time or at any stage of the proceedings. And there is nothing to prevent a litigant from appearing before the court to conduct his own litigation. The client has also an undoubted right to compromise a suit without the intervention of his lawyer. 22. Even the lawyers' right to fees from their clients may not be invoked by the lawyers themselves as a ground for disapproving or holding in abeyance the approval of a compromise agreement. The lawyers concerned can enforce their rights in the proper court in an appropriate proceeding in accordance with the rules of court, but said rights may not be used to prevent the approval of the compromise agreement. The apprehension of herein counsel that it is impossible that the municipality will file a similar petition, considering that the mayor who controls its legislative body will not take the initiative, is not only conjectural but without factual basis. Contrary to his pretensions, there is presently a manifestation and motion pending with the trial court filed by the aforesaid municipal mayor for the withdrawal of the satisfaction of judgment and the release and quit claim 24 previously filed in the case therein as earlier mentioned. Ramos v. Ca. Facts: on April 18, 1990, petitioners filed a petition before the court a quo for the declaration of nullity of Municipal Ordinances No. 91 and No. 7 and the contract of lease over a commercial arcade to be constructed in the municipality of Baileyug, Bulacan. Meanwhile, the provincial fiscal and the provincial attorney, Oliviano D. Regalado, filed an answer on behalf of respondent municipality. At the pre-trial conference, Attorney Roberto B. Romanillos appeared, manifesting that he was counsel for the municipality. On the same date, Attorney Romanillos filed a motion to dissolve injunction and a motion to admit an amended answer with motion to dismiss. The provincial attorney appeared as collaborating counsel of Attorney Romanillos. The provincial fiscal did not appear. It was Attorney Romanillos who submitted the reply to petitioners' opposition to respondents' motion to dissolve injunction. It was also Attorney Romanillos who submitted a written formal offer of evidence for the municipality. Despite the hearing, petitioners questioned the personality of Attorney Romanillos to appear as counsel of the municipality. Meanwhile, Attorney Romanillos and Attorney Regalado filed a joint stating that Attorney Romanillos was withdrawing as counsel for respondent municipality and that Attorney Regalado, as his collaborating counsel for respondent municipality, is adopting the entire proceedings participated in / undertaken by Attorney Romanillos. The judge denied the petitioner's motion to disqualify. Issue: who is authorized to represent a municipality in its lawsuits? Ratio: in the recent case of Municipality of Pilila, Rizal vs. Ca., this court, through Mr. Justice Florence D. Regalado, set in clear-cut terms the answer to the question of who may legally represent a municipality in a suit for or against it. Thus, the matter of representation of a municipality by a private attorney has been settled in Ramos vs. Ca. et.al. and reiterated in Province of Cebu vs. IAC, et.al., where we ruled that private attorneys cannot represent a province or municipality in lawsuits. Section 1683 of the Revised Administrative Code provides. Sector 1683. Duty of fiscal to represent provinces and provincial subdivisions in litigation. The provincial fiscal shall represent the province and any municipality or municipal district thereof in any court, except in cases whereof original jurisdiction is vested in the Supreme Court or in cases where the municipality or municipal district in question is a party adverse to the provincial government or to some other municipality or municipal district in the same province. When the interests of a provincial government and of any political division thereof are opposed, the provincial fiscal shall act on behalf of the province. When the provincial fiscal is disqualified to serve any municipality or other political subdivision of a province, a special attorney may be employed by its council. Under the above provision, complemented by Section 3, RA 2264, the Local Autonomy Law, only provincial fiscal and the municipal attorney can represent a province or municipality in their lawsuits. The provision is mandatory. The municipality's authority to employ a private lawyer is expressly limited only to situations where the provincial fiscal is disqualified to represent it. For the aforementioned exception to apply, the fact that the provincial fiscal was disqualified to handle the municipality's case must appear on record. In the instant case, there is nothing in the records to show that the provincial fiscal is disqualified to act as counsel for the municipality of Pailila on appeal, hence the appearance of herein private counsel is without authority of law. The provincial fiscal's functions as legal officer and advisor for the civil cases of a province and corollarily, of the municipalities thereof, were subsequently transferred to the provincial attorney. The foregoing provisions of law and jurisprudence show that only the provincial fiscal, provincial attorney, and municipal attorney should represent a municipality in its lawsuits. Only in exceptional instances may a private attorney be hired by a municipality to represent it in lawsuits. These exceptions are enumerated in the case of Alinsig vs. RDC-BR 58, San Carlos City, Negros Occidental, to wit. Indeed, it appears that the law allows a private counsel to be hired by a municipality only when the municipality is an adverse party in a case involving the provincial government or another municipality or city within the province. This provision has its apparent origin in the ruling in Digia v. the Auditor General, where the court held that the municipality's authority to employ a private attorney is expressly limited only to situations where the provincial fiscal would be disqualified to serve and represent it. With Sector 1683 of the Old Administrative Code as legal basis, the court therein cited Enriquez, Sr. v. Jimenez, which enumerated instances when the provincial fiscal is disqualified to represent in court a particular municipality, if and when original jurisdiction of case involving the municipality is vested in the Supreme Court, when the municipality is a party adverse to the provincial government or to some other municipality in the same province, and when, in a case involving the municipality, he, or his wife, or child, is pecuniarily involved, as heir legatee, creditor, or otherwise. Thereafter, in Ramos vs. Ca., the court ruled that a municipality may not be represented by a private law firm which had volunteered its services gratis, in collaboration with the municipal attorney and the fiscal, as such representations was violative of Sector 1683 of the Old Administrative Code. This strict coherence to the letter of the law appears to have been dictated by the fact that the municipality should not be burdened with expenses of hiring a private lawyer, and that the interests of the municipality would be best protected if a government lawyer handles its litigations. None of the foregoing exceptions is present in this case. It may be said that Attorney Roman Illos appeared for respondent municipality inasmuch as he was already counsel of Christie Corporation, which was sued with respondent municipality in this same case. The order of the trial court dated September 19, 1990, stated that Attorney Roman Illos entered his appearance as collaborating counsel of the provincial prosecutor and the provincial attorney. This collaboration is contrary to law and hence should not have been recognized as legal. It has already been ruled in this wise. The fact that the municipal attorney and the fiscal are supposed to collaborate with a private law firm does not legalize the latter's representation of the municipality of Hagonoy in Civil Case No. 5095-M. While a private prosecutor is allowed in criminal cases, an analogous arrangement is not allowed in civil cases wherein a municipality is the plaintiff. As already stated, private lawyers may not represent municipalities on their own. Neither may they do so even in collaboration with authorized government lawyers. This is anchored on the principle that only accountable public officers may act for and in behalf of public entities, and that public funds should not be expanded to hire private lawyers. Petitioners cannot be held in estoppel for questioning the legality of the appearance of Attorney Roman Illos, notwithstanding that they questioned the witnesses of respondent municipality during the hearing of its motion to dissolve the preliminary injunction. Municipality of Pailila, Resolve S. Court of Appeals held that the legality of the representation of an unauthorized counsel may be raised at any stage of the proceedings. Elementary fairness dictates that parties unaware of the unauthorized representation should not be held in estoppel just because they did not question on the spot the authority of the counsel for the municipality. The rule on appearances of a lawyer is that until the contrary is clearly shown, an attorney is presumed to be acting under authority of the litigant whom he purports to represent. His authority to appear for and represent petitioner in litigation, not having been questioned in the lower court, it will be presumed on appeal that counsel was properly authorized to file the complaint and appear for his client. Issue: would the adoption by attorney regalado of the proceedings participated in by attorney Roman Illos validate such proceedings? Held yes ratio, it does not appear that the adoption of proceedings participated in or undertaken by attorney Roman Illos when he was private counsel for the respondent municipality of Bailey Uig, such as the proceedings on the motion to dissolve the injunction, wherein petitioners had even cross-examined the witnesses presented by attorney Roman Illos in support of said motion and had even started to present their witnesses to sustain their objection to the motion would have resulted in any substantial prejudice to petitioner's interest. As we see it, to declare the said proceedings null and void notwithstanding the formal adoption thereof by attorney regalado as provincial attorney of Bulacan in court, and to require trial anew to cover the same subject matter, to hear the same witnesses and to admit the same evidence adduced by the same parties cannot enhance the promotion of justice. This court believes that conferring legitimacy to the appearance of attorney Roman Illos would not cause substantial prejudice on petitioners. Requiring new trial on the mere legal technicality that the municipality was not represented by a legally authorized counsel would not serve the interest of justice. After all, this court does not see any injustice committed against petitioners by the adoptions of the work of private counsel, nor any interest of justice being served by requiring retrial of the case by the duly authorized legal representative of the town. In sum, although a municipality may not hire a private lawyer to represent it in litigations, in the interest of substantial justice however, we hold that a municipality may adopt the work already performed in good faith by such private lawyer, which work is beneficial to it provided that no injustice it thereby heaped on the adverse party, and provided further that no compensation in any guise is paid therefor by said municipality to the private lawyer. Unless so expressly adopted, the private lawyer's work cannot bind the municipality. Issue 1 joint motion need not comply with Rule 15 held yes ratio. We also agree with the justification of public respondent that a motion to withdraw the appearance of an unauthorized lawyer is a non-adversarial motion that need not comply with Section 4 Rule 15 as to notice to the adverse party. The disqualification of attorney Roman Illos was what petitioners were really praying for when they questioned his authority to appear for the municipality. The disqualification was granted, thereby serving the relief prayed for by petitioners. Such being the case, no notice directed to the parties concerned and served at least 3 days before the hearing thereof 30 need be given petitioners, the questioned motion not being contentious. Besides, what petitioners were questioning as to lack of authority was remedied by the adoption of proceedings by an authorized counsel, attorney regalado. The action of the trial court allowing the motion of respondent municipality effectively granted petitioner's motion to disqualify Attorney Roman Illos. In People vs. Levist, we ruled that while it is true any motion that does not comply with the requirements of Rule 15 should not be accepted for filing and, if filed, is not entitled to judicial cognizance. This court has likewise held that where a rigid application of the rule will result in a manifest failure or miscarriage of justice, technicalities may be disregarded in order to resolve the case. Litigations should, as much as possible, be decided on the merits and not on technicalities. As this court held in Galvez vs. Court of Appeals, an order of the court granting the motion to dismiss despite the absence of a notice of hearing, or proof of service thereof, is merely an irregularity in the proceedings, which cannot deprive a competent court of jurisdiction over the case. It should be remembered that rules of procedure are but tools designed to facilitate the attainment of justice, such that when rigid application of the rules tend to frustrate rather than promote substantial justice, this court is empowered to suspend their operation. Sala Lima v. Ginguna 257 SCRA 55. Facts: this refers to the administrative complaint filed against Albay Governor Romeo Sala Lima, Vice Governor Danilo Azafla, Albay Sangguniang Panlalawigan members Juan Victoria, Lorenzo Riag, Jesus Mark Elana, Arturo Ozia, Clenio Cabarido, Ramon Fernandez, Jr., Masacap Fontanilla, Vicente Go, Sr., and Nemesio Baclao relative to the retainer contract for legal services entered into between the province of Albay, on the one hand, and attorney Jesus R. Cornigo and the Cortez and Reina law firm, on the other, and the disbursement of public fund in payment thereof. The complaint alleges that by entering into the retainer agreement with private lawyers and paying P7, 380, 410, 31 to the said private lawyers, respondents violated several provisions of law which warrants the imposition of administrative penalties against them. It is to be noted that respondents Victoria, Riag, Cabarido, Mark Elana, and Ozia were not yet members of the Sangguniang Panlalawigan when Resolution No. 129 was passed. However, the complaint alleges that these respondents were named in the complaint because they approved the supplemental budget/appropriation ordinances providing for the payment of the attorney's fees. Issue: 1. Respondents have incurred administrative liability in entering into the retainer agreement with attorney Cornigo and the Cortez and Reina law firm and in making payments pursuant to said agreement for purposes of the case filed by NPC with the Supreme Court against the province. Held yes ratio, Sector 481 of the Local Government Code, RA No. 7160, requires the appointment of a legal officer for the province whose functions include the following: represent the local government unit in all civil actions and special proceedings wherein the local government unit or any official thereof, in his official capacity, is a party, provided that, in actions or proceeding where a component city or municipality is a party adverse to the provincial government or to another component city or municipality, a special legal officer may be employed to represent the adverse party. The Supreme Court has ruled in Municipality of Baco, ETLV Manatok, that local government units cannot be represented by private lawyers and it is solely the provincial fiscal who can rightfully represent them. This ruling applies squarely to the case at hand because Sections 481 of the Local Government Code is based on Sector 1681 of the Revised Administrative Code, which was the subject of interpretation in the case of Municipality of Baco, ETLV Manatok. In hiring private lawyers to represent the province of Albay, respondents exceeded their authority and violated the above-quoted section of the Local Government Code and the doctrine laid down by the Supreme Court. Moreover, the entire transaction was attended by irregularities. First, the disbursements to the lawyers amounting to P7,380,410, 31 were disallowed by the provincial auditor on the ground that these were made without the prior written conformity of the Solicitor General and the written concurrence of the Commission on Audit. As required by COA Circular No. 86-25-5 dated April 2, 1986. The respondents attempted to dispute this finding by presenting the Solicitor General's conformity dated July 15, 1993. This conformity was, however, obtained after the disbursements were already made in 1990 and 1992. What is required by COA Circular No. 86-255 is a prior written conformity and acquiescence of the Solicitor General. Another irregularity in the transaction concerns the lawyers. Resolution No. 01-90 authorized the respondent governor to sign and confirm a retainer contract for legal services with the Cortez and Reyna law firm at 202 East Rodriguez Sr. Boulevard, Quezon City. The retainer contract signed by respondent governor was, however, not only with the Cortez and Reyna law firm but also with attorney Jesus R. Cornigo of J. McCaw Building, 280 Tomas Morato Avenue, Quezon City. That attorney, Jesus R. Cornigo, and the Cortez and Reyna law firm are two separate entities is evident from the retained contract itself. In entering into a retainer agreement not only with the Cortez and Reyna law firm but also with attorney Jose R. Cornigo, respondent governor exceeded his authority under Resolution No. 01-90. Complicating further the web of deception surrounding the transaction is the fact that it was only attorney Cornigo who appeared as collaborating counsel of record of the province in the Supreme Court case. Even the Solicitor General, in his letter to respondent governor dated July 15, 1993, noted that the province is represented in the Supreme Court by Addis Ricafort Cornigo and Glenn Manahan but not by the Cortez and Reyna law firm. Furthermore, the memorandum with the Supreme Court filed for the province was signed by attorney Cornigo and not by the Cortez and Reyna law firm. Consequently, the Cortez and Reyna law firm was not counsel of record of the province in Gr. Number 87,479. And yet, 6 of the 10 checks paid by the province and amounting to more than P3.6 million were issued in favor of the Cortez and Reyna law firm through attorney Antonio Jose Cortez. In other words, respondents disbursed money to the Cortez and Reyna law firm although the latter did not appear as counsel for the province in the Supreme Court in Gr. number 87,479. Finally, the attorney's fees agreed upon by respondent Salalima and confirmed by the other respondents are not only unreasonable but also unconscionable. The contingent fee of 18% of the P2L4 million claim of the province against NPC amounts to P38.5 million. The word unconscionable, as applied to attorney's fee, means nothing more than that the fee contracted for, standing alone and unexplained would be sufficient to show that an unfair advantage had been taken of the client, or that a legal fraud had been taken of the client, or that a legal fraud had been perpetrated on him. The province has a legal officer, attorney Ricafort, who had already filed a comment on NPC's petition against the province. The comment filed by attorney Ricafort already covers the basic issues raised in the petition. When attorney Cornigo filed an appearance and subsequently a memorandum for the province, the petition was already been given due course by the Supreme Court and the only pleading to be filed by the parties before the court would issue its decision was a memorandum. Surely, one memorandum could not be worth P38.5 million. Furthermore, the professional character and social standing of attorney Cornigo are not such as would merit a P38.5 million fee for the legal services rendered for the province. During the hearing, respondent governor admitted that he had hired attorney Cornigo because they were schoolmates at San Beda College. It is evident that respondent governor hired attorney Cornigo not on the basis of his competency and standing in the legal community but purely for personal reasons. Likewise, the standing of the Cortez and Reyna law firm is not such as would merit P38.5 million for one memorandum, which, in this case, it had not even filed because it was not the counsel of record. Hence, considering the labor and time involved, the skill and experience called for in the performance of the services and the professional character and social standing of the lawyers, the attorney's fee of P3.85 million is unconscionable. By allowing such scandalously exorbitant attorney's fees, which is patently disadvantageous to the government, respondents betrayed a personal bias to the lawyers involved and committed abuse of authority. Disciplinary actions. Gonzan v. CA, Supra. Facts: DLG Secretary issued against Mayor Gonzan 3 separate orders of 60-day preventive suspensions dated AUG 11-1988, OCT 11-1988, and MAY 3-1990. A fourth order was issued on JULY 3, 1991. On August 5, 1991, SC issued order that the first 3 suspensions are affirmed provided that Gonzan may not be made to serve future suspensions on account of any of the remaining admin charges against him. Gonzan filed a petition for mandamus with manifestation in compliance, alleging that he had already fully served the suspension orders issued against him, in compliance with the August 5 SC order, and that he should be allowed to reassume his office starting September 4, 1991. Held, simultaneous service of the third and fourth orders of suspension can be allowed under the bizarre circumstances of CAB. It would work in favor of Gonzan, an elective official, and it presumably will favor the local constituency and certainly lessen if not offset the harsh effects of whatever motive may be behind the intriguing action of DLG seconds in issuing the successive suspension orders, especially when he could have pursued a consolidated effort. SC takes judicial notice of recently approved LGC which provides, under SEC 6.3 as to imposition of preventive suspensions, that SEC 6.3 that any single preventive suspension of local elective official shall not extend beyond 60 days. Provided, further, that in the event that several administrative cases are filed against an elective official, he cannot be preventively suspended for more than 90 days within a single year on the same ground or grounds existing and known at the time of the first suspension. Espiritu v. Melgar. Facts: Ramir Gehring filed a sworn letter complaint with Secretary Luis Santos of DILG charging Mayor Nelson Melgar of Najan, Oriental Mindoro, with grave misconduct, oppression, abuse of authority, culpable violation of the Constitution and conduct prejudicial to the best interest of the public service. Melgar allegedly assaulted Gehring and ordered his arrest and detention in the municipal jail of Najan without filing any charges until his release the following day. An identical letter complaint was filed by Gehring with Provincial Governor of Oriental Mindoro Benjamin Espiritu, accusing Melgar of the same violations. A third complaint filed by Gehring with the Presidential Action Center, OP. Mayor Melgar submitted his answer wherein he said that while he was delivering a speech during a graduation ceremony, Gehring suddenly clapped, causing disturbance on the part of the audience. When the mayor ended his speech, he instructed a policeman to investigate Gehring. It appeared that Gehring was drunk. The mayor also presented medical certificate proving that Gehring was not hurt. A ballison was then taken from Gehring. The mayor informed Gehring to go home, but he refused to go and only did so the following morning. The Sangguniang Panlalawigan of Oriental Mindoro passed Resolution No. 55, recommending to the provincial governor that the mayor be preventively suspended for 45 days pending the investigation of the administrative complaint. When the mayor received the order of suspension, he filed a petition for certiorari with preliminary injunction with prayer for restraining order in the RDC of Oriental Mindoro, alleging that the order of suspension was an arrogant, despotic and arbitrary abuse of power by the governor. The RDC judge issued a writ of preliminary injunction enjoining Governor Espiritu from implementing the order of suspension against Mayor Melgar on appeal. Petitioner contends that the trial judge erred in granting the preliminary injunction since the governor is empowered under Sector 63 LGC to place an elective municipal official under preventive suspension pending decision of an administrative case against the elective municipal official. Also, under Sector 61 LGC, the Sangguniang Panlalawigan has jurisdiction over the complaints against any municipal official. While Section 19 of the Judiciary Reorganization Act of 1930 withdrew from RTC's jurisdictions over such cases. Also, the mayor has a remedy of appeal under Sector 66 LGC. Issue 1. The governor has the power to suspend the mayor. Held yes ratio, under Section 63 LGC, the provincial governor of Oriental Mindoro is authorized by law to preventively suspend the municipal mayor of Najan at any time after the issues had been joined and any of the following grounds were shown to exist. When there is reasonable ground to believe that the respondent has committed the act or acts complained of, when the evidence of culpability is strong, when the gravity of the offense so warrants, or when the continuance in office of the respondent could influence the witnesses or pose a threat to the safety and integrity of the records and other evidence. There is nothing improper in suspending an officer before the charges against him are heard and before he is given an opportunity to prove his innocence. Preventive suspension is allowed so that the respondent may not hamper the normal course of the investigation through the use of his influence and authority over possible witnesses. Since the mayor believed that his preventive suspension was unjustified and politically motivated, he should have sought relief first from the Secretary of DILG, not from the courts. Mayor Melgar's direct recourse to the courts without exhausting administrative remedies was premature. The RDC had no jurisdiction over special civil action No. R 5003 and gravely abused its discretion in refusing to dismiss the case. There may exist honest differences of opinion with regard to the seriousness of the charges, or as to whether they warrant disciplinary action. However, as a general rule, the office or body that is invested with the power of removal or suspension should be the sole judge of the necessity and sufficiency of the cause. So, unless a flagrant abuse of the exercise of that power is shown, public policy and a becoming regard for the principle of separation of powers demand that the action of said officer or body should be left undisturbed. However, in this particular case, since the 60-day preventive suspension of Mayor Melgar was maintained by the temporary restraining order which we issued on August 6, 1991, and therefore has already been served, he is deemed reinstated in office without prejudice to the continuation of the administrative investigation of the charges against him. Aguinaldo v. Santos. Facts: Petitioner was the duly elected governor of the province of Cagayan. Shortly after the December 1989 coup d'état was crushed, the Secretary of Local Government sent a telegram and a letter to Petitioner requiring him to show cause why he should not be suspended or removed from office for disloyalty to the Republic. Within 48 hours from receipt thereof, a sworn complaint for disloyalty to the Republic and culpable violation of the Constitution was filed by Veronico Agatep, Manuel Mamba, and Orlando Agatep, the mayors of the municipalities of Gataran, Tuyo and Lazam, all in Cagayan, against Petitioner for acts the latter committed during the coup. In his letter, Petitioner denied being privy to the planning of the coup or actively participating in its execution, though he admitted that he was sympathetic to the cause of the rebel soldiers. The Secretary suspended Petitioner from office for 60 days from notice, pending the outcome of the formal investigation. During the hearing, Petitioner did not present any evidence and instead moved that the Secretary inhibit himself, which motion was denied. Later, the Secretary rendered a decision finding Petition guilty as charged and ordering his removal from office. The Vice-Governor, Melvin Vargas, was installed as Governor. In this appeal, the power of the Secretary to suspend officials was repealed by the 1987 Constitution and that the act of disloyalty committed by Petitioner was not proven beyond reasonable doubt. While the case was pending before the SC, petitioner filed his certificate of candidacy for the position of governor of Cagayan. 3 petitions for disqualification were filed against him on the ground that he had been removed from office. The Cumlic granted the petition. Later, this was reversed on the ground that the decision of the Secretary has not yet attained finality and is still pending review with the court. As petitioner won by a landslide margin in the elections, the resolution paved the way for his eventual proclamation as governor of Cagayan. Issue 1. The Secretary has the power to suspend or remove local government officials as alter ego of the President. Held, yes ratio. Petitioner's re-election to the position of governor of Cagayan has rendered the administrative case pending before us moot and academic. It appears that after the canvassing of votes, petitioner garnered the most number of votes among the candidates for governor of Cagayan province. As held by this court in Aguinaldo v. Cumlic et.al. The re-election to office operates as a condonation of the officer's misconduct to the extent of cutting off the right to remove him therefore. The court should never remove a public officer for acts done prior to his present term of office. To do otherwise would be to deprive the people of their right to elect their officers. When the people have elected a man to office, it must be assumed that they did this with knowledge of his life and character, and that they disregarded or forgave his fault or misconduct, if he had been guilty of any. It is not for the court, by reason of such fault or misconduct, to practically overrule the will of the people. Clearly then, the rule is that a public official cannot be removed for administrative misconduct committed during a prior term. Since his re-election to office operates as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore. The foregoing rule, however, finds no application to criminal cases pending against petitioner for acts he may have committed during the failed coup. The power of respondent secretary to remove local government of officials is anchored on both the Constitution and a statutory grant from the legislative branch. The constitutional basis is provided by Articles 7 and X of the 1987 Constitution, which vest in the President the power of control over all executive departments, bureaus and offices and the power of general supervision over local governments, and by the doctrine that the acts of the department head are presumptively the acts of the President unless expressly rejected by him. For the statutory grant found in BPBLG 337 itself has constitutional roots, having been enacted by the then Batasan Pambanza pursuant to Article 11 of the 1973 Constitution, Section 2. A similar provision is found in Section 3, Article X of the 1987 Constitution. Inasmuch as the power and authority of the legislature to enact a local government code, which provides for the manner of removal of local government officials, is found in the 1973 Constitution as well as Indiana the 1987 Constitution, then it cannot be said that BP 337 was repealed by the effectivity of the present Constitution. Moreover, in Bajabayo et al. V. Davide, Jr. BP 337 remained in force despite the effectivity of the Constitution, until such time as the proposed Local Government Code of 1991 is approved. The power of He Secretary of the DILG to remove local elective government officials is found in SECS 60 and 61 of BP 337. As to petitioner's argument of the want of authority of the Secretary to appoint Melvin Vargas as governor, we need but point to section 48 of BPBLG 337 to show the fallacy of the same. Equally without merit is petitioner's claim that before he could be suspended or removed from office, proof beyond reasonable doubt is required inasmuch as he is charged with a penal offence of disloyalty to the Republic, which is defined and penalized under Article 137 of the RPC. Petitioner is not being prosecuted criminally under the provisions of the RPC, but administratively with the end in view of removing petitioner as the duly elected governor of Cagayan Province for acts of disloyalty to the Republic where the quantum of proof required is only substantial evidence. Reyes v. Cumlic. Facts, GR number 120905. Renato Reyes was the incumbent mayor of the municipality of Bongabong, Oriental Mindoro. An administrative complaint was filed against him with the Sangguniang Panlalawigan by Dr. Ernesto Manalo. It was alleged that petitioner exacted and collected P50,000,00 from each market stallholder in the Bongabong public market. Also, that certain checks issued to him by the National Reconciliation and Development Program of the DILG were never received by the municipal treasurer nor reflected in the books of accounts of the same officer. And that he took 27 heads of cattle from beneficiaries of a cattle dispersal program after the latter had reared and fattened the cattle for 7 months. The Sangguniang Panlalawigan found petitioner guilty of the charges and ordered his removal from office. Petitioner filed a petition for certiorari, prohibition, and injunction with the RDC of Oriental Mindoro. Later, the presiding officer of the Sangguniang Panlalawigan, Vice Governor Pedrito Reyes, issued an order for petitioner to vacate the position of mayor and peacefully turn over the office to the incumbent vice mayor. But service of the order upon petitioner was also refused. Meanwhile, petitioner filed a certificate of candidacy with the Cumlic. Rogelio de Castro sought the disqualification of petitioner as candidate for mayor, citing the LGC. The Cumlic cancelled petitioner's certificate of candidacy. However, the Municipal Board of Canvassers of Bongabong, apparently unaware of the disqualification of Reyes by the Cumlic, proclaimed him the duly elected mayor. The Cumlic and Bank affirmed. Invoking the ruling in the case of Aguinaldo v. Santos, petitioner argues that his election on May 8, 1995 is a bar to his disqualification. GR number 120940. Julius Garcia, who obtained the highest number of votes next to Reyes, intervened, contending that because Reyes was disqualified, he was entitled to be proclaimed mayor of Bongabong, Oriental Mindoro. The Cumlic and Bank denied Garcia's prayer since a candidate who obtains the second highest number of votes in an election cannot be declared winner. Issue 1. The decision of the Sangguniang Panlalawigan is not yet final because he has not been served a copy thereof. Held no ratio. The failure of the Sangguniang Panlalawigan to deliver a copy of its decision was due to the refusal of petitioner and his counsel to receive the decision. As the secretary to the Sangguniang Panlalawigan, Mario Manzo, stated in his certification, repeated attempts had been made to serve the decision on Reyes personally and by registered mail, but Reyes refused to receive the decision. If a judgment or decision is not delivered to a party for reasons attributable to him, service is deemed completed and the judgment or decision will be considered validly served as long as it can be shown that the attempt to deliver it to him would be valid were it not for his or his counsel's refusal to receive it. Indeed, that petitioner's counsel knew that a decision in the administrative case had been rendered is evident in his effort to bargain with the counsel for the Sangguniang Panlalawigan not to have the decision served upon him and his client while their petition for certiorari in the RDC was pending. His refusal to receive the decision may, therefore, be construed as a waiver on his part to have a copy of the decision. The purpose of the rules on service is to make sure that the party being served with the pleading, order, or judgment is duly informed of the same so that he can take steps to protect his interests. Enable a party to file an appeal or apply for other appropriate reliefs before the decision becomes final. Petitioner was given sufficient notice of the decision. Prudence required that, rather than resist the service, he should have received the decision and taken an appeal to the office of the President in accordance with RA number 7160. 67. But petitioner did not do so. Accordingly, the decision became final on April 2, 1995, 30 days after the first service upon petitioner. The net result is that when the elections were held on May 8, 1995, the decision of the Sangguniang Panlalawigan had already become final and executory. The filing of a petition for certiorari with the regional trial court did not prevent the administrative decision from attaining finality. An original action of certiorari is an independent action and does not interrupt the course of the principal action nor the running of the reglementary period involved in the proceeding. Consequently, to arrest the course of the principal action during the pendency of the certiorari proceedings, there must be a restraining order or a writ of preliminary injunction from the appellate court directed to the lower court. In the case at bar, although a temporary restraining order was issued by the regional trial court, no preliminary injunction was subsequently issued. The temporary restraining order issued expired after 20 days. From that moment on, there was no more legal barrier to the service of the decision upon petitioner. Issue 1. Petitioner's re-election rendered the administrative charges against him moot and academic. Held no ratio, the case at bar is the very opposite of Aguinaldo vs. Cumlick. Here, although Reyes brought an action to question the decision in the administrative case, the TRO issued in the action he brought lapsed. With the result that the decision was served on petitioner and it thereafter became final on April 3, 1995, because petitioner failed to appeal to the office of the President. He was thus validly removed from office and, pursuant to 40 of the LGC, he was disqualified from running for re-election. It is noteworthy that at the time the Aguinaldo cases were decided there was no provision similar to 40 which disqualifies any person from running for any elective position on the ground that he has been removed as a result of an administrative case. RA number 7160 could not be given retroactive effect. Furthermore, the decision has not yet attained finality. As indicated earlier, the decision of the then Secretary of Local Government was questioned by the petitioner in this court and that to date, the petition remains unresolved. All in all, herein Mayor Reyes was given by the Sangguniang a period of 61 days to file his verified answer. However, he resorted to dilatory motions which in the end proved fatal to his cause. Veritably, he neither filed nor furnished the complainant a copy of his answer. Failure of the respondent to file his verified answer within 15 days from receipt of the complaint shall be considered a waiver of his rights to present evidence in his behalf. Art. 126 of Rules and Regulations implementing the Local Government Code of 1991. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Indeed, it appears that petitioner was given sufficient opportunity to file his answer. He failed to do so. Nonetheless, he was told that the complainant would be presenting his evidence and that he would then have the opportunity to cross-examine the witnesses. But on the date set, he failed to appear. He would say later that this was because he had filed a motion for postponement and was awaiting a ruling thereon. This only betrays the pattern of delay he employed to render the case against him moot by his election. Issue 1. Julius Garcia should be declared mayor in view of the disqualification of Renato Reyes. Held no ratio, that the candidate who obtains the second highest number of votes may not be proclaimed winner in case the winning candidate is disqualified is now settled. To simplistically assume that the second placer would have received the other votes would be to substitute our judgment for the mind of the voter. The second placer is just that, a second placer. He lost the elections. He was repudiated by either a majority or plurality of voters. He could not be considered the first among qualified candidates because in a field which excludes the disqualified candidate, the conditions would have substantially changed. We are not prepared to extrapolate the results under the circumstances. Garcia's plea that the votes cast for Reyes be invalidated is without merit. The votes cast for Reyes are presumed to have been cast in the belief that Reyes was qualified and for that reason cannot be treated as stray, void, or meaningless. The subsequent finding that he is disqualified cannot retroact to the date of the elections so as to invalidate the votes cast for him. As for Garcia's contention that the Cumlic committed a grave abuse of discretion in not deciding the case before the date of the election, suffice it to say that under RA No. 6646, 6, the Cumlic can continue proceedings for disqualification against a candidate even after the election and order the suspension of his proclamation whenever the evidence of his guilt is strong. For the same reason, we find no merit in the argument that the Cumlic should have seen right away that Reyes had not exhausted administrative remedies by appealing the decision of the Sangguniang Panlalawigan and, therefore, should have disqualified him before the elections. Hagad v. Gozo Datali. Facts: criminal and administrative complaints were filed against respondents, Mayor Alfredo Wano, Vice Mayor Paterno Canet and Sangguniang Panlungsod member Rafael Mayal, all public officials of Mandaue City. By Mandaue City Councilors Magno B. Dianson and Gaudiosa O. Bercid, by Mandaue City Councilors Magno B. Dianson and Gaudiosa O. Bercid with the Office of the Deputy Ombudsman for the Visayas. The respondents were charged with having violated RA No. 3019, as amended, Articles 170 and 171 RPC, and RA No. 6713. Councilors Dianson and Bercid averred that respondent officials, acting in conspiracy, had caused the alteration and/or falsification of Ordinance No. 018/92 by increasing the allocated appropriation therein from P3,494,364.57 to P7M without authority from the Sangguniang Panlungsod of Mandaue City. Aside from opposing the motion for preventive suspension, respondent officials prayed for the dismissal of the complaint on the ground that the Ombudsman supposedly was bereft of jurisdiction to try, hear and decide the administrative case filed against them since, under Section 63 LGC, the power to investigate and impose administrative sanctions against said local officials, as well as to effect their preventive suspension, had now been vested with the office of the President. Dianson and Bercid argued that the LGC could not have repealed, abrogated or otherwise modified the pertinent provisions of the Constitution granting to the Ombudsman the power to investigate cases against all public officials and that, in any case, the power of the Ombudsman to investigate local officials under the Ombudsman Act had remained unaffected by the provisions of the Local Government Code of 1991. The Office of the Deputy Ombudsman denied the motion to dismiss and recommended the preventive suspension of respondent officials, except City Budget Officer Pedro M. Guido, until the administrative case would have been finally resolved by the Ombudsman. A petition for prohibition, with prayer for a writ of preliminary injunction and temporary restraining order, was filed by respondent officials with the RDC. Acting favorably on the pleas of petitioning officials, respondent judge issued a restraining order directed at petitioner, enjoining him from enforcing and/or implementing the questioned order of preventive suspension issued in OMB Vis ADM 92-015. Issue 1. The Ombudsman has jurisdiction over the case held. Yes. Ratio. The general investigatory power of the Ombudsman is decreed by Section 13 Article X1, of the 1987 Constitution. While his statutory mandate to act on administrative complaints is contained in Section 19 of R.A. No. 6770. Section 21 of the same statute names the officials who could be subject to the disciplinary authority of the Ombudsman. Taken in conjunction with Section 24 of R.A. No. 6770, Petitioner thus contends that the office of the Ombudsman correspondingly has the authority to decree preventive suspension on any public officer or employee under investigation by it. Respondent officials, upon the other hand, argue that the disciplinary authority of the Ombudsman over local officials must be deemed to have been removed by the subsequent enactment of the Local Government Code of 1991, which vests the authority to investigate administrative charges listed under Section 60 thereof, on various offices in the case specifically of complaints against elective officials of provinces and highly urbanized cities. Thus, respondents insist, conformably with Section 63 of the Local Government Code, preventive suspension can only be imposed by the President if the respondent is an elective official of a province, a highly urbanized or an independent component city. There is nothing in the LGC to indicate that it has repealed, whether expressly or impliedly, the pertinent provisions of the Ombudsman Act. The two statutes on the specific matter in question are not so inconsistent, let alone irreconcilable, as to compel us to only uphold one and strike down the other. Well settled is the rule that repeals of laws by implication are not favored, and that courts must generally assume their congruent application. The two laws must be absolutely incompatible, and a clear finding thereof must surface, before the inference of implied repeal may be drawn. The rule is expressed in the maxim, interpretere et concordare licibus esf optimus interpretendi, i.e., every statute must be so interpreted and brought into accord with other laws as to form a uniform system of jurisprudence. The fundament is that the legislature should be presumed to have known the existing laws on the subject and not to have enacted conflicting statutes. Hence, all doubts must be resolved against any implied repeal, and all efforts should be exerted in order to harmonize and give effect to all laws on the subject. Certainly, Congress would not have intended to do injustice to the very reason that underlies the creation of the Ombudsman in the 1987 Constitution, which is to insulate said office from the long tentacles of officialdom. Quite interestingly, Sections 61 and 63 of the present Local Government Code run almost parallel with the provisions then existing under the old code. The authority to conduct administrative investigation and to impose preventive suspension over elective provincial or city officials was at that time entrusted to the Minister of Local Government until it became concurrent with the Ombudsman. Upon the enactment of RA No. 6770, specifically under Sections 21 and 24 thereof, to the extent of the common grant the Local Government Code of 1991, in fine, did not effect a change from what already prevailed, the modification being only in the substitution of the Secretary of Local Government by the office of the President. Respondent local officials contend that the 6-month preventive suspension without pay under Section 24 of the Ombudsman Act is much too repugnant to the 60-day preventive suspension provided by Section 63 of the Local Government Code to even now maintain its application. The two provisions govern differently. In order to justify the preventive suspension of a public official under Section 24 of RA No. 6770, the evidence of guilt should be strong, and the charge against the officer or employee should involve dishonestly, oppression or grave misconduct or neglect in the performance of duty, that charges should warrant removal from the service, or the respondent's continued stay in office would prejudice the case filed against him. The Ombudsman can impose the 6-month preventive suspension to all public officials, whether elective or appointive, who are under investigation. Upon the other hand, in imposing the shorter period of 60 days of preventive suspension prescribed in the Local Government Code of 1991 on an elective local official, it would be enough that there is reasonable ground to believe that the respondent has committed the act or acts complained of, the evidence of culpability is strong, the gravity of the offence so warrants, or the continuance in office of the respondent could influence the witnesses or pose a threat to the safety and integrity of the records and other evidence. The contention is without merit. The records reveal that petitioner issued the order of preventive suspension after the filing by respondent officials of their opposition on the motion for preventive suspension and by Mayor Wano of his memorandum in compliance with the directive of petitioner. Be that as it may, we have heretofore held that, not being in the nature of a penalty, a preventive suspension can be decreed on an official under investigation after charges are brought and even before the charges are heard. Naturally, such a preventive suspension would occur prior to any finding of guilt or innocence. Moreover, respondent officials were, in point of fact, put on preventive suspension only after petitioner had found, in consonance with our ruling in Buenaseda vs Flavier, that the evidence of guilt was strong. Finally, it does appear, as so pointed out by the Solicitor General, that respondent officials' petition for prohibition, being an application for remedy against the findings of petitioner contained in his September 21, 1992 order, should not have been entertained by the trial court. Sala Lima v. Ginguna, Supra. In Sala Lima v. Ginguna, Jr., the court en banc categorically ruled that the office of the President is without any power to remove elected officials. Since the power is exclusively vested in the proper courts as expressly provided for in the last paragraph of Section 60 of the LGC, it further invalidated Article 125, Rule 19 of The court nullified the rule since the Oversight Committee that prepared the rules and regulations of the Local Government Code exceeded its authority when it granted to the disciplining authority the power to remove elective officials, a power which the law itself granted only to the proper courts. Grego v. Cumlick 274 SCRA 481. Facts: on October 31, 1981, Bosco was removed from his position as deputy sheriff by the court upon a finding of serious misconduct in an administrative complaint lodged by Nina Tordesillas. Subsequently, Bosco ran as a candidate for councillor in the 2nd District of the City of Manila during the 1988 local elections. He won and, accordingly, assumed office. After his term, he sought re-election in the 1992 election. He again won. However, a case for quo warranto was filed by Senan Ronquillo, who alleged Bosco's ineligibility to be elected councillor on the basis of the Tordesillas ruling. Other complaints were filed before the Office of the Ombudsman and in the DILG. In 1995, Bosco ran again for councillor. William Grego, claiming to be a registered voter of precinct number 966, District 2, City of Manila, filed with the Cumlick a petition for disqualification, praying for Bosco's disqualification, for the suspension of his proclamation, and for the declaration of Romualdo S. Maranan as the 6th duly elected councillor of Manila's 2nd District. The Manila BOC however proclaimed Bosco as a duly elected councillor of the 2nd District of Manila. In view of the proclamation, Grego filed an urgent motion seeking to annul the illegal proclamation. The Cumlick dismissed the petition for disqualification, ruling that the administrative penalty imposed by the SC on Bosco was wiped away and condoned by the electorate who elected him. Issue 1 Section 40 of Republic Act No. 7160 apply retroactively to those removed from office before it took effect on January 1, 1992. Held no ratio, petitioner submits that although the code took effect only on January 1, 1992, Section 40 must nonetheless be given retroactive effect and applied to Bosco's dismissal from office, which took place in 1981. It is stressed that the provision of the law as worded does not mention or even qualify the date of removal from office of the candidate in order for disqualification thereunder to attach. Hence, petitioner impresses upon the court that as Long as a candidate was once removed from office due to an administrative case, regardless of whether it took place during or prior to the effectivity of the code, the disqualification applies. We do not, however, subscribe to petitioner's view. Our refusal to give retroactive application to the provision of Section 40 is already a settled issue, and there exist no compelling reasons for us to depart therefrom. Well settled is the principle that while the legislature has the power to pass retroactive laws which do not impair the obligation of contracts, or affect injuriously vested rights, it is equally true that statutes are not to be construed as intended to have a retroactive effect so as to affect pending proceedings. Unless such intent is expressly declared or clearly and necessarily implied from the language of the enactment, there is no provision in the statute which would clearly indicate that the same operates retroactively. It, therefore, follows that 40 of the Local Government Code is not applicable to the present case. Issue 1. Private respondent's election to office as City Councilor of Manila in the 1988, 1992, and 1995 elections wipe away and condone the administrative penalty against him, thus restoring his eligibility for public office. Ratio. At first glance, there seems to be a prima facie semblance of merit to petitioner's argument. However, the issue of whether or not Basco's triple election to office cured his alleged ineligibility is actually beside the point, because the argument proceeds on the assumption that he was in the first place disqualified when he ran in the 3 previous elections. This assumption, of course, is untenable considering that Basco was not subject to any disqualification at all under Section 40 of the Local Government Code, which, as we said earlier, applies only to those removed from office on or after January 1, 1992. In view of the irrelevance of the issue posed by petitioner, there is no more reason for the court to still dwell on the matter at length. Anent Basco's alleged circumvention of the prohibition in Tordesillas against reinstatement to any position in the national or local government, including its agencies and instrumentalities, as well as government-owned or controlled corporations, we are of the view that petitioner's contention is baseless. Neither does petitioner's argument that the term any position is broad enough to cover without distinction both appointive and local positions merit any consideration. Contrary to petitioner's assertion, the Tordesillas decision did not bar Basco from running for any elective position, and with prejudice to reinstatement. In this regard, particular attention is directed to the use of the term reinstatement. Under the former Civil Service Decree, 16, the law applicable at the time Basco, a public officer, was administratively dismissed from office. The term reinstatement had a technical meaning, referring only to an appointive position. In light of these definitions, there is, therefore, no basis for holding that Basco is likewise barred from running for an elective position, inasmuch as what is contemplated by the prohibition in Tordesillas is reinstatement to an appointive position. Issue 1. Private respondent's proclamation as sixth winning candidate on May 17, 1995, while the disqualification case was still pending consideration by Cumlic, is void ab initio. Ratio. The inapplicability of RA 7166 Section 20 to the present case is very much patent on its face, considering that the same refers only to a void proclamation in relation to contested returns and not to contested qualifications of a candidate. RA 6646 Section 6 does not support petitioner's contention that the Cumlic, or more properly speaking, the Manila City BOC, should have suspended the proclamation. The use of the word may indicates that the suspension of a proclamation is merely directory and permissive in nature and operates to confer discretion. What is merely made mandatory, according to the provision itself, is the continuation of the trial and hearing of the action, inquiry, or protest. Thus, in view of this discretion granted to the Cumlic, The question of whether or not evidence of guilt is so strong as to warrant suspension of proclamation must be left for its own determination, and the court cannot interfere therewith and substitute its own judgment unless such discretion has been exercised whimsically and capriciously. The Cumlic, as an administrative agency and a specialized constitutional body charged with the enforcement and administration of all laws and regulations relative to the conduct of an election, plebiscite, initiative, referendum, and recall, has more than enough expertise in its field that its findings or conclusions are generally respected and even given finality. The Cumlic has not found any ground to suspend the proclamation, and the records likewise fail to show any so as to warrant a different conclusion from this court. Hence, there is no ample justification to hold that the Cumlic gravely abused its discretion. Since Section 6 of Rep. Act 6646, the law which Section 5 of Rule 25 of the Cumlic Rules of Procedure seeks to implement, employed the word may, it is, therefore, improper and highly irregular for the Cumlic to have used instead the word shall in its rules. Moreover, there is no reason why the Manila City BOC should not have proclaimed Bosco as the sixth winning city councilor. Absent any determination of irregularity in the election returns, as well as an order enjoining the canvassing and proclamation of the winner, it is a mandatory and ministerial duty of the Board of Canvassers concerned to count the votes based on such returns and declare the result. Finally, the cases of Duremdes, Benito, and Aguam, Supra, cited by petitioner are all irrelevant and inapplicable to the factual circumstances at bar and serve no other purpose than to muddle the real issue. These three cases do not in any manner refer to void proclamations resulting from the mere pendency of a disqualification case. Issue: 1 Romualdo S. Moranin, a seventh placer, be legally declared a winning candidate. Held no ratio, obviously, he may not be declared a winner. In the first place, Bosco was a duly qualified candidate pursuant to our disquisition above. Furthermore, he clearly received the winning number of votes which put him in sixth place. Thus, petitioner's emphatic reference to Labo v. Cumlic, where we laid down a possible exception to the rule that a second placer may not be declared the winning candidate, finds no application in this case. The exception is predicated on the concurrence of two assumptions, namely, the one who obtained the highest number of votes is disqualified, and the electorate is fully aware in fact and in law of a candidate's disqualification so as to bring such awareness within the realm of notoriety but would nonetheless cast their votes in favor of the ineligible candidate. Both assumptions, however, are absent in this case. Petitioner's allegation that Bosco was well known to have been disqualified in the small community where he ran as a candidate is purely speculative and conjectural, unsupported as it is by any convincing facts of record to show notoriety of his alleged disqualification. In sum, we see the dismissal of the petition for disqualification as not having been attended by grave abuse of discretion. There is then no more legal impediment for private respondent's continuance in office as City Councilor for the 2nd District of Manila. Yusin v. Executive Secretary Torres 290 SCRA 279. Facts: Oscar C. Tinio is the Vice Governor of Nueva Ecija while Loreto P. Pangilinan, Crispilo S. Esguerra, Solita C. Santos, Vicente C. Palilio and Napoleon G. Interior are members of the Sangguniang Panlalawigan. The private respondents filed with the Office of the President a complaint charging Governor Eduardo Yusin with grave misconduct and abuse of authority. Allegedly, Yusin belligerently barged into the hall and angrily kicked the door and chairs in the hall and uttered threatening words at private respondents during a scheduled session. Private respondents claim that this incident was an offshoot of their resistance to a pending legislative measure supported by petitioner that Nueva Ecija obtain a loan of P150 million from the PNB. Yusin's acts were intended to harass them into approving this loan. which private respondents opposed the loan because the province had an unliquidated obligation of more than P70 million incurred without prior authorization from the Sangguniang Panlalawigan. Private respondents prayed for the suspension or removal of petitioner, for an emergency audit of the provincial treasury of Nueva Ecija, and for the review of the proposed loan in light of the financial condition of the province. Yusin failed to file his answer despite numerous grant of extension. Thus, DILG Undersecretary Manuel Sanchez issued an order declaring Yusin in default. Later, Yusin, through counsel, filed a motion to dismiss alleging that the letter complaint was not verified and that the DILG has no jurisdiction over the case and has no authority to require him to answer the complaint. Executive Secretary Torres issued an order placing Yusin under preventive suspension for 60 days pending investigation of the charges against him. Also, the motion to dismiss was denied. Secretary Barbers directed the PNP to assist the implementation of the order of preventive suspension. Also, Vice Governor Oscar Tinio was appointed as acting governor. Yusin filed a petition for certiorari and prohibition with the CA challenging the preventive suspension and default order. The CA dismissed the case. Yusin claimed that there was nothing in his conduct that threatened the members of the Sangguniang Panlalawigan or caused alarm to the employees. He said that like Vice Governor Tinio, he was always accompanied by his official security escorts whenever he reported for work. He also alleged that the joint affidavit of Elnora Escambian and Jacqueline Jane Perez was false. Escambian was purportedly not inside the session hall during the incident but was at her desk at the office and could not in any way have seen petitioner in the hall. Issue 1. The filing of a letter complaint before the office of the President was proper. Held yes ratio. Administrative disciplinary proceedings against elective local officials are governed by the Local Government Code of 1991. In all matters not provided in AO number 23, the rules of court and the Administrative Code of 1987 apply in a suppletory character. Section 60 of Chapter 4, Title 2, Book I of the LGC enumerates the grounds for which an elective local official may be disciplined, suspended, or removed from office. When an elective local official commits an act that falls under the grounds for disciplinary action, the administrative complaint against him must be verified and filed under Section 61. In the instant case, Yusin is an elective official of the province of Nueva Ecija. The letter complaint against him was therefore properly filed with the office of the President. According to petitioner, however, the letter complaint failed to conform with the formal requirements set by the Code. He alleges that the complaint was not verified by private respondents and was not supported by the joint affidavit of the two witnesses named therein. That private respondents later realized these defects and surreptitiously inserted the verification and sworn statement while the complaint was still pending with the office of the President. We find no merit in the contention of the petitioner. The absence of the document, page, or book number of the notarial register of the subscribing officer is insufficient to prove petitioner's claim. The lack of these entries may constitute proof of neglect on the part of the subscribing officer in complying with the requirements for notarization and proper verification. They may give grounds for the revocation of his notarial commission. But they do not indubitably prove that the verification was inserted or intercalated after the letter complaint was filed with the office of the President. Nor is the fact of intercalation sufficiently established by the affidavit of Solita Santos. Santos was one of the signatories to the letter complaint. In her affidavit, she prayed that she be dropped as one of the complainants since she had just joined the political party of Yusin. She decided to reveal the intercalation because she was disillusioned with the dirty tactics of Vice Governor Tinio to grab power from petitioner Yusin. Santos cannot in any way be considered an unbiased witness. Her motive and change of heart render her affidavit suspect. Assuming, nonetheless, that the letter complaint was unverified when submitted to the office of the President, the defect was not fatal. The requirement of verification was deemed waived by the President himself when he acted on the complaint. Verification is a formal, not jurisdictional requisite. Verification is mainly intended to secure an assurance that the allegations therein made are done in good faith or are true and correct and not mere speculation. The lack of verification is a mere formal defect. The court may order the correction of the pleading, if not verified, or act on the unverified pleading if the attending circumstances are such that a strict compliance with the rule may be dispensed with in order that the ends of justice may be served. Issue 1. The DILG has jurisdiction over the case held yes ratio. The disciplining authority is the President of the Philippines, whether acting by himself or through the Executive Secretary. The Secretary of the Interior and Local Government is the investigating authority, who may act by himself or constitute an investigating committee. The Secretary of the DILG, however, is not the exclusive investigating authority. In lieu of the DILG Secretary, the disciplining authority may designate a special investigating committee. The power of the President over administrative disciplinary cases against elective local officials is derived from his power of general supervision over local governments. The power of supervision means overseeing or the authority of an officer to see that the subordinate officers perform their duties. If the subordinate officers fail or neglect to fulfill their duties, the official may take such action or step as prescribed by law to make them perform their duties. The President's power of general supervision means no more than the power of ensuring that laws are faithfully executed, or that subordinate officers act within the law. Supervision is not incompatible with discipline. And the power to discipline and ensure that the laws be faithfully executed must be construed to authorize the President to order an investigation of the act or conduct of local officials when in his opinion the good of the public service so requires. The power to discipline evidently includes the power to investigate. As the disciplining authority, the President has the power derived from the Constitution itself to investigate complaints against local government officials. AO number 23, however, delegates the power to investigate to the DILG or a special investigating committee, as may be constituted by the disciplining authority. This is not undue delegation, contrary to Yusin's claim. The President remains the disciplining authority. What is delegated is the power to investigate, not the power to discipline. Moreover, the power of the DILG to investigate administrative complaints is based on the alter ego principle or the doctrine of qualified political agency. This doctrine is corollary to the control power of the President. Control is said to be the very heart of the power of the Presidency. As head of the executive department, the President, however, may delegate some of his powers to the cabinet members except when he is required by the Constitution to act in person or the exigencies of the situation demand that he acts personally. The members of cabinet may act for and in behalf of the President in certain matters because the President cannot be expected to exercise his control powers personally all the time. Each head of a department is, and must be, the President's alter ego in the matters of that department where the President is required by law to exercise authority. In the case at bar, petitioner claims that the DILG Secretary usurped the power of the President when he required petitioner to answer the complaint. Undisputably, the letter complaint was filed with the office of the President, but it was the DILG Secretary who ordered petitioner to answer. Strictly applying the rules, the office of the President did not comply with the provisions of AO number 23. The office should have first required petitioner to file his answer. Thereafter, the complaint and the answer should have been referred to the investigating authority for further proceedings. Be that as it may, this procedural lapse is not fatal. The filing of the answer is necessary merely to enable the President to make a preliminary assessment of the case. The President found the complaint sufficient in form and substance to warrant its further investigation. The judgment of the President on the matter is entitled to respect in the absence of grave abuse of discretion. Issue 1. Yusin was properly placed under preventive suspension. Held yes ratio in view of petitioner's inexcusable failure to file answer, the DILG did not err in recommending to the disciplining authority his preventive suspension during the investigation. Preventive suspension is authorized under Section 63 of the LGC. Preventive suspension may be imposed at any time after the issues are joined, that is, after respondent has answered the complaint, when the evidence of guilt is strong and, given the gravity of the offense, there is a great possibility that the continuance in office of the respondent could influence the witnesses or pose a threat to the safety and integrity of the records and other evidence. The failure of respondent to file his answer despite several opportunities given him is construed as a waiver of his right to present evidence in his behalf. The requisite of joinder of issues is squarely met with respondent's waiver of right to submit his answer. The act of respondent in allegedly barging violently into the session hall of the Sangguniang Panlalawigan in the company of armed men constitutes grave misconduct. The allegations of complainants are bolstered by the joint affidavit of 2 employees of the Sangguniang Panlalawigan. Respondent, who is the chief executive of the province, is in a position to influence the witnesses. Further, the history of violent confrontational politics in the province dictates that extreme precautionary measures be taken. Executive Secretary Torres found that all the requisites for the imposition of preventive suspension had been complied with. Petitioner's failure to file his answer despite several opportunities given him was construed as a waiver of his right to file answer and present evidence, and as a result of this waiver, the issues were deemed to have been joined. The Executive Secretary also found that the evidence of petitioner Yusin's guilt was strong and that his continuance in office during the pendency of the case could influence the witnesses and pose a threat to the safety and integrity of the evidence against him. Issue 1. The resolution finding Yusin guilty and imposing on him the penalty of suspension from office for 6 months without pay was proper. Held. Ratio. Settled is the rule that in administrative proceedings, technical rules of procedure and evidence are not strictly applied. The essence of due process is to be found in the reasonable opportunity to be heard and to submit evidence one may have in support of one's defense. To be heard does not only mean verbal arguments in court, one may be heard also through pleadings. Where opportunity to be heard, either through oral arguments or pleadings, is accorded, there is no denial of procedural due process. Thus, when respondent failed to submit his position paper as directed and insisted for the conduct of formal investigation, he was not denied of his right of procedural process. The denial of petitioner's motion to conduct formal investigation is erroneous. Petitioner's right to a formal investigation is spelled out in the following provisions of AO. Number 23. The records show that on August 27, 1997, petitioner submitted his answer ad cautelam where he disputed the truth of the allegations that he barged into the session hall of the capital and committed physical violence to harass the private respondents who were opposed to any move for the province to contract a P150 million loan from PNB. In his order of October 8, 1997, Under-Secretary Sanchez admitted petitioner's answer ad cautelam but treated it as a position paper. On October 15, 1997, petitioner filed a motion to conduct formal investigation. Petitioner reiterated this motion on October 29, 1997. Petitioner's motion was denied on November 11, 1997. Secretary Barbers found petitioner guilty as charged on the basis of the party's position papers. On January 8, 1998, Executive Secretary Torres adopted Secretary Barbers' findings and recommendations and imposed on petitioner the penalty of 6 months suspension without pay. The rejection of petitioner's right to a formal investigation denied him procedural due process. Section 5 of AO number 23 provides that at the preliminary conference, the investigating authority shall summon the parties to consider whether they desire a formal investigation. This provision does not give the investigating authority the discretion to determine whether a formal investigation would be conducted. The records show that petitioner filed a motion for formal investigation. As respondent, he is accorded several rights under the law. An erring elective local official has rights akin to the constitutional rights of an accused. These rights are essentially part of procedural due process. The local elective official has the right to appear and defend himself in person or by counsel, the right to confront and cross-examine the witnesses against him, and the right to compulsory attendance of witness and the production of documentary evidence. These rights are reiterated in the rules implementing the LGC and in AO number 23. Petitioner's right to a formal investigation was not satisfied when the complaint against him was decided on the basis of position papers. There is nothing in the Local Government Code and its implementing rules and regulations nor in AO number 23 that provide that administrative cases against elective local officials can be decided on the basis of position papers. AO number 23 states that the investigating authority may require the parties to submit their respective memoranda, but this is only after formal investigation and hearing. AO number 23 does not authorize the investigating authority to dispense with a hearing, especially in cases involving allegations of fact which are not only in contrast but contradictory to each other. These contradictions are best settled by allowing the examination and cross-examination of witnesses. Position papers are oftentimes prepared with the assistance of lawyers, and their artful preparation can make the discovery of truth difficult. The jurisprudence cited by the DILG in its order denying petitioner's motion for a formal investigation applies to appointive officials and employees. Administrative disciplinary proceedings against elective government officials are not exactly similar to those against appointive officials. In fact, the provisions that apply to elective local officials are separate and distinct from appointive government officers and employees. This can be gleaned from the LGC itself. In the LGC, the entire Title II of Book I of the Code is devoted to elective officials. It provides for their qualifications and election, vacancies and succession, local legislation, disciplinary actions, and recall. Appointive officers and employees are covered in Title III of Book I of the Code entitled Human Resources and Development. All matters pertinent to human resources and development in local government units are regulated by the civil service law and such rules and regulations and other issuances promulgated thereto, unless otherwise provided in the Code. The investigation and adjudication of administrative complaints against appointive local officials and employees, as well as their suspension and removal, are in accordance with the civil service law and rules and other pertinent laws, the results of which shall be reported to the Civil Service Commission. It is the Administrative Code of 1987, specifically Book V on the Civil Service, that primarily governs appointive officials and employees. Their qualifications are set forth in the Omnibus Rules implementing Book V of the said Code. The grounds for administrative disciplinary action in Book V are much more in number and are specific than those enumerated in the Local Government Code against elective local officials. The disciplining authority in such actions is the Civil Service Commission, although the secretaries and heads of agencies and instrumentalities, provinces, cities and municipalities are also given the power to investigate and decide disciplinary actions against officers and employees under their jurisdiction. When a complaint is filed and the respondent answers, he must indicate whether or not he elects a formal investigation if his answer is not considered satisfactory. If the officer or employee elects a formal investigation, the direct evidence for the complainant and the respondent consist of the sworn statement and documents submitted in support of the complaint and answer. As the case may be, without prejudice to the presentation of additional evidence deemed necessary XXX, upon which the cross-examination by respondent and the complainant, respectively, is based. The investigation is conducted without adhering to the technical rules applicable in judicial proceedings. Moreover, the appointive official or employee may be removed or dismissed summarily if the charge is serious and the evidence of guilt is strong. When the respondent is a recidivist, and when the respondent is notoriously undesirable. The provisions for administrative disciplinary actions against elective local officials are markedly different from appointive officials. The rules on the removal and suspension of elective local officials are more stringent. The procedure of requiring position papers in lieu of a hearing in administrative cases is expressly allowed with respect to appointive officials but not to those elected. An elective official, elected by popular vote, is directly responsible to the community that elected him. The official has a definite term of office fixed by law which is relatively of short duration. Suspension and removal from office definitely affects and shortens this term of office. When an elective official is suspended or removed, the people are deprived of the services of the man they had elected. Implicit in the right of suffrage is that the people are entitled to the services of the elective official of their choice. Suspension and removal are thus imposed only after the elective official is accorded his rights and the evidence against him strongly dictates their imposition. Conducto v. Monzon. Facts: complainant filed a complaint with the Sangguniang Panlungsod of San Pablo City against Benjamin Magayarang, the barangay chairman of Barangay Iiie of San Pablo City, for abuse of authority. Serious irregularity and violation of law as Magayarang appointed his sister-in-law, Mrs. Florian Magayarang, to the position of barangay secretary in violation of Section 394 of the LGC. At the same time, complainant filed a complaint for violation of Article 244 RPC with the Office of the City Prosecutor against Magayarang, which was, however, dismissed on the ground that Magayarang's sister-in-law was appointed before the effectivity of the LGC, which prohibits a punang barangay from appointing a relative within the fourth civil degree of consanguinity or affinity as barangay secretary. The order of dismissal was submitted to the Office of the Deputy Ombudsman for Luzon. Complainant obtained an opinion from Dir Jacob Montesa of the DILG declaring the appointment of Magayarang void. The Office of the Deputy Ombudsman dismissed the case but ordered Magayarang to replace his sister-in-law as barangay secretary. Later, the Office of the Deputy Ombudsman granted the MR and ordered the filing of an information for unlawful appointment against Magayarang. With prior leave from the Office of the Deputy Ombudsman, the city prosecutor filed, in criminal case number 26240, a motion for the suspension of Magayarang pursuant to Section 13 of RA number 3019. The judge denied the motion and ruled that since Magayarang was re-elected as barangay chairman, the offences committed during the previous term are not causes for removal. The Office of the Court Administrator recommended that the judge liable for ignorance of the law and that he be reprimanded with a warning that a repetition of the same or similar acts in the future shall be dealt with more severely. The OCA said that it is well settled in Section 13 of RA 3019 that the court suspends any public officer against whom a valid information was filed against him. Issue 1. The judge was grossly ignorant of the law held, yes ratio, all things considered, while conceitedly, respondent judge manifested his ignorance of the law in denying complainant's motion for suspension of BRGY. Chairman Magayarang, there was nothing shown however to indicate that he acted in bad faith or with malice. Be that as it may, it would also do well to note that good faith and lack of malicious intent cannot completely free respondent from liability. The findings and conclusions of the Office of the Court Administrator are in order. However, the penalty recommended, i.e., reprimand, is too light, in view of the fact that despite his claim that he has been continuously keeping abreast of legal and jurisprudential development in law ever since he passed the bar examinations in 1995, respondent wittingly or otherwise, failed to recall that as early as 1967 in Inco v. Sanchez this court explicitly ruled that the re-election of a public official extinguishes only the administrative, but not the criminal, liability incurred by him during his previous term of office. Thus, the ruling, therefore, that when the people have elected a man to his office it must be assumed that they did this with knowledge of his life and character and that they disregarded or forgave his faults or misconduct if he had been guilty of any - refers only to an action for removal from office and does not apply to a criminal case, because a crime is a public wrong more atrocious in character than mere misfeasance or malfeasance committed by a public officer in the discharge of his duties, and is injurious not only to a person or group of persons but to the state as a whole. This must be the reason why Article 89 of the Revised Penal Code, which enumerates the grounds for extinction of criminal liability, does not include re-election to office as one of them, at least insofar as a public officer is concerned. Also, under the Constitution, it is only the President who may grant the pardon of a criminal offense. There is a whale of a difference between the two cases. The basis of the investigation which has been commenced here, and which is sought to be restrained, is a criminal accusation the object of which is to cause the indictment and punishment of petitioner appellant as a private citizen, whereas in the cases cited, the subject of the investigation was an administrative charge against the officers therein involved and its object was merely to cause his suspension or removal from public office. While the criminal cases involves the character of the mayor as a private citizen and the people of the Philippines as a community is a party to the case. An administrative case involves only his actuations as a public officer as affect the populace of the municipality where he serves. Then on June 20, 1969, in Luciano v. the Provincial Governor, et.al. 20, this court likewise categorically declared that criminal liabilities incurred by an elective public official during his previous term of office were not extinguished by his re-election, and that Pascual v. Provincial Governor and Lizares v. Hecanova referred only to administrative liabilities committed during the previous term of an elective official. Petitioner's reliance on the loose language used in Pascual v. Provincial Board of Nueva Ecija that each term is separate from other terms and that the re-election to office operates as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore is misplaced. The court has in subsequent cases made it clear that the Pascual ruling applies exclusively to administrative and not to criminal liability and sanctions. Thus, in Inco v. Sanchez the court ruled that the re-election of a public officer for a new term does not in any manner wipe out the criminal liability incurred by him in a previous term. Punishment for a crime is a vindication for an offense against the state and the body politic. The small segment of the national electorate that constitutes the electorate of the municipality of Antipolo has no power to condone a crime against the public justice of the state and the entire body politic. Re-election to public office is not provided for in Article 89 of the Revised Penal Code as a mode of extinguishing criminal liability incurred by a public officer prior to his re-election. On the contrary, Article 9 of the Anti-Graft Act imposes as one of the penalties in case of conviction perpetual disqualification from public office and Article 30 of the Revised Penal Code declares that such penalty of perpetual disqualification entails the deprivation of the public offices and employments which the offender may have held, even if conferred by popular election. It is manifest then, that such condonation of an officer's fault or misconduct during a previous expired term by virtue of his re-election to office for a new term can be deemed to apply only to his administrative and not to his criminal guilt. As succinctly stated in then Solicitor General Felix Q. Antonio's memorandum for the state. To hold that petitioner's re-election erased his criminal liability would in effect transfer the determination of the criminal culpability of an erring official from the court to which it was lodged by law into the changing and transient whim and caprice of the electorate. This cannot be so, for while his constituents may condone the misdeed of a corrupt official by returning him back to office, a criminal action initiated against the latter can only be heard and tried by a court of justice. his nefarious act having been committed against the very state whose laws he had sworn to faithfully obey and uphold. A contrary rule would erode the very system upon which our government is based, which is one of laws and not of men. While diligence in keeping up to date with the decisions of this court is a commendable virtue of judges and, of course, members of the bar, comprehending the decisions is a different matter. For it is in that area where one's competence may then be put to the test and proven. Thus, it has been said that a judge is called upon to exhibit more than just a cursory acquaintance with statutes and procedural rules. It is imperative that he be conversant with basic legal principles and aware of well-settled and authoritative doctrines. 23. He should strive for excellence, exceeded only by his passion for truth, to the end that he be the personification of justice and the rule of law. Needless to state, respondent was, in this instance, wanting in the desired level of mastery of a revered doctrine on a simple issue. Publico v. Villapando. Facts: Solomon B. Magad, and Renato M. Fernandez. Filed with the Sangguniang Panlalawigan of Palawan an administrative complaint against Mayor Alejandro A. Villapando for abuse of authority and culpable violation of the Constitution. Villapando allegedly entered into a consultancy agreement with Orlando Tiope which amounted to an appointment to a government position within the prohibited one-year period under the Constitution. Villapando claimed that he did not appoint Tiope, but he merely hired him, and a consultant does not constitute an appointment to a government office or position as prohibited by the Constitution. The Sangguniang Panlalawigan of Palawan found respondent guilty of the administrative charge and imposed on him the penalty of dismissal from service. The office of the President affirmed the decision of the Sangguniang Panlalawigan. Villapando filed a certiorari and prohibition before the CA seeking to annul the decision of the office of the President. The CA declared void the decision of the OP and the Sangguniang Panlalawigan. Issue: 1. Local legislative bodies and/or the office of the President, on appeal, can validly impose the penalty of dismissal from service on erring elective local officials. Held: no ratio. The pertinent portion of Section 60 of the Local Government Code of 1991 provides. Section 60. Grounds for disciplinary actions. An elective local official may be disciplined, suspended, or removed from office on any of the following grounds. An elective local official may be removed from office on the grounds enumerated above by order of the proper court. It is clear from the last paragraph of the provision that the penalty of dismissal from service upon an erring elective local official may be decreed only by a court of law. Thus, in Salalima, et.al. v. Ginguna, et.al. we held that the office of the President is without any power to remove elected officials, since such power is exclusively vested in the proper courts as expressly provided for in the last paragraph of the aforequoted Section 60. Article 124, Rule 19 of the Rules and Regulations implementing the Local Government Code, however, adds that an elective local official may be removed from office on the grounds enumerated in paragraph of this article, the grounds enumerated in Section 60. Local Government Code of 1991 by order of the proper court or the disciplining authority whichever first acquires jurisdiction to the exclusion of the other. The disciplining authority referred to pertains to the Sangguniang Panlalawigan/Panlungsod/Bayan and the office of the President. As held in Salalima, this grant to the disciplining authority of the power to remove elective local officials is clearly beyond the authority of the Oversight Committee that prepared the rules and regulations. No rule or regulation may alter, amend, or contravene a provision of law, such as the LGC. Implementing rules should conform, not clash, with the law that they implement, for a regulation which operates to create a rule out of harmony with the statute is a nullity. Even Senator Aquilino Q. Pimentel, Jr., the principal author of the Local Government Code of 1991, expressed doubt as to the validity of Article 124, Rule 19 of the implementing rules. It is beyond cavil, therefore, that the power to remove erring elective local officials from service is lodged exclusively with the courts. Hence, Article 124, Rule 19, of the Rules and Regulations implementing the Local Government Code, insofar as it vests power on the disciplining authority to remove from office erring elective local officials, is void for being repugnant to the last paragraph of Section 60 of the Local Government Code of 1991. The law on suspension or removal of elective public officials must be strictly construed and applied, and the authority in whom such power of suspension or removal is vested must exercise it with utmost good faith. For what is involved is not just an ordinary public official but one chosen by the people through the exercise of their constitutional right of suffrage. Their will must not be put to naught by the caprice or partisanship of the disciplining authority. Where the disciplining authority is given only the power to suspend and not the power to remove, it should not be permitted to manipulate the law by usurping the power to remove. As explained by the court in Laxon v. Rock. The abridgment of the power to remove or suspend an elective mayor is not without its own justification, and was, we think, deliberately intended by the lawmakers. The evils resulting from a restricted authority to suspend or remove must have been weighed against the injustices and harms to the public interests which would be likely to emerge from an unrestrained discretionary power to suspend and remove. Removal only by courts sanguining Barangay of Don Mariano v. Punang Barangay Martinez. Facts. Severino Martinez was administratively charged with dishonesty and graft and corruption by petitioner through the filing of a verified complaint before the Sangguniang Bayan as the disciplining authority over elective barangay officials pursuant to Section 64 of RA 7160. The complaint was later amended for dishonesty, misconduct in office and violation of the Anti-Graft and Corrupt Practices Act. Petitioner alleged that Martinez committed the following acts. 1. Failure to submit and fully remit to the barangay treasurer the income of their solid waste management projects since 2001, particularly the sale of fertilizer derived from composting. 2. Failure to submit/remit to the barangay treasurer the sale of recyclable materials taken from garbage collection. 3. Using the garbage truck for other purposes like hauling sand and gravel for private persons without monetary benefit to the barangay because no income from this source appears in the year-end report even if payments were collected XXX. 4. Using/spending barangay funds for repair, gasoline, lubricants, wheels and other spare parts of the garbage truck instead of using the money or income of said truck from the garbage fees collected as income from its sold waste management project. XXX. 5. Unliquidated traveling expenses for seminar/Lakbayaril in 2003 because although a cash advance was made by the respondent for the said purpose, he, however, did not attend said seminar because on the dates when he was supposed to be on seminar they saw him in the barangay. XXX. 6. That several attempts to discuss said problem during sessions were all in vain because respondent declined to discuss it and would adjourn the session. XXX. For failure to file an answer, Martinez was declared in default and was placed under preventive suspension for 60 days. Thereafter, the Sangguniang Bayan rendered its decision which imposed upon Martinez the penalty of removal from office. The decision was conveyed to the mayor of Bayambang, Nueva Ecija. The mayor, however, issued a memo wherein he stated that the Sangguniang Bayan has no power to order Martinez removal from office. However, the decision remains valid until reversed. Martinez then filed a special civil action for certiorari before the RDC. The court declared the decision void and maintained that the proper courts, and not the petitioner, are empowered to remove an elective official from office. Issue 1. The Sangguniang may remove Martinez, an elective local official, from office. Held no ratio. Section 60 of the Local Government Code conferred upon the courts the power to remove elective local officials from office. During the deliberations of the Senate on the Local Government Code, the legislative intent to confine to the courts, i.e. RTCs, the Sandiganbayan, and the appellate courts, jurisdiction over cases involving the removal of elective local officials was evident. In Salalima v. Gingana, Jr. The court en banc categorically ruled that the office of the president is without any power to remove elected officials. Since the power is exclusively vested in the proper courts as expressly provided for in the last paragraph of Section 60 of the LGC, it further invalidated Article 125, Rule 19 of The court nullified the rule since the Oversight Committee that prepared the rules and regulations of the Local Government Code exceeded its authority when it granted to the disciplining authority the power to remove elective officials, a power which the law itself granted only to the proper courts. Thus, it is clear that under the law, the Sangguniang Bayan is not vested with the power to remove Martinez. Petitioner contends that administrative cases involving elective barangay officials may be filed with, heard and decided by the Sangguniang Panlungsod or Sangguniang. Bayan concerned, which can, thereafter, impose a penalty of removal from office. It further claims that the courts are merely tasked with issuing the order of removal, after the Sangguniang Panlungsod or Sangguniang Bayan finds that a penalty of removal is warranted. The aforementioned position put forward by the petitioner would run counter to the rationale for making the removal of elective officials an exclusive judicial prerogative. In Publico v. Villapando, the court declared that the law on suspension or removal of elective public officials must be strictly construed and applied, and the authority in whom such power of suspension or removal is vested must exercise it with utmost good faith. For what is involved is not just an ordinary public official but one chosen by the people through the exercise of their constitutional right of suffrage. Their will must not be put to naught by the caprice or partisanship of the disciplining authority. Where the disciplining authority is given only the power to suspend and not the power to remove, it should not be permitted to manipulate the law by usurping the power to remove. Emphasis supplied. The rule which confers to the proper courts the power to remove an elective local official from office is intended as a check against any capriciousness or partisan activity by the disciplining authority. Vesting the local legislative body with the power to decide whether or not a local chief executive may be removed from office, and only relegating to the courts a mandatory duty to implement the decision, would still not free the resolution of the case from the capriciousness or partisanship of the disciplining authority. Thus, the petitioner's interpretation would defeat the clear intent of the law. Moreover, such an arrangement clearly demotes the courts to nothing more than an implementing arm of the Sangguniang Panlungsod, or Sangguniang Bayan. This would be an unmistakable breach of the doctrine on separation of powers, thus placing the courts under the orders of the legislative bodies of local governments. The courts would be stripped of their power of review, and their discretion in imposing the extreme penalty of removal from office is thus left to be exercised by political factions which stand to benefit from the removal from office of the local elective official concerned. The very evil which Congress sought to avoid when it enacted Section 60 of the Local Government Code. As the law stands, Section 61 of the Local Government Code provides for the procedure for the filing of an administrative case against an erring elective barangay official before the Sangguniang Panlungsod or Sangguniang Bayan. However, the Sangguniang Panlungsod or Sangguniang Bayan cannot order the removal of an erring elective barangay official from office, as the courts are exclusively vested with this power under Section 60 of the Local Government Code. Thus, if the acts allegedly committed by the barangay official are of a grave nature and, if found guilty, would merit the penalty of removal from office, the case should be filed with the regional trial court. Once the court assumes jurisdiction, it retains jurisdiction over the case even if it would be subsequently apparent during the trial that a penalty less than removal from office is appropriate. On the other hand, the most extreme penalty that the Sangguniang Panlungsod or Sangguniang Bayan may impose on the erring elective barangay official is suspension, if it deems that the removal of the official from service is warranted. Then it can resolve that the proper charges be filed in court. Petitioner alleged that an interpretation which gives the judiciary the power to remove local elective officials violates the doctrine of separation of powers. This allegation runs contrary to the 1987 Constitution itself, as well as jurisprudence. The doctrine of separation of powers is not absolute in its application, rather, it should be applied in accordance with the principle of checks and balances. The removal from office of elective officials must not be tainted with partisan politics and used to defeat the will of the voting public. Congress itself saw it fit to vest that power in a more impartial tribunal, the court. Furthermore, the local government units are not deprived of the right to discipline local elective officials, rather, they are prevented from imposing the extreme penalty of dismissal. Petitioner questions the decision of the trial court for allowing the petition filed before it as an exception to the doctrine of exhaustion of administrative remedies. If, indeed, the Sangguniang Bayan had no power to remove Martinez from office, then Martinez should have sought recourse from the Sangguniang Panlalawigan. This court upholds the ruling of the trial court. The doctrine of exhaustion of administrative remedies, which is based on sound public policy and practical consideration, is not inflexible. There are instances when it may be dispensed with and judicial action may be validly resorted to immediately. Among these exceptions are, 1. Where there is estoppel on the part of the party invoking the doctrine, 2. Where the challenged administrative act is patently illegal, amounting to lack of jurisdiction. 3. Where there is unreasonable delay or official inaction that will irretrievably prejudice the complainant. 4. Where the amount involved is relatively small as to make the rule impractical and oppressive. 5. Where the question raised is purely legal and will ultimately have to be decided by the courts of justice. 6. Where judicial intervention is urgent. 7. Where its application may cause great and irreparable damage. 8. Where the controverted acts violate due process. 9. When the issue of non-exhaustion of administrative remedies has been rendered moot. 10. Where there is no other plain, speedy and adequate remedy. 11. When strong public interest is involved, and 13. In quo warranto proceedings. As a general rule, no recourse to courts can be had until all administrative remedies have been exhausted. However, this rule is not applicable where the challenged administrative act is patently illegal, amounting to lack of jurisdiction, and where the question or questions involved are essentially judicial. In this case, it is apparent that the Sangguniang Bayan acted beyond its jurisdiction when it issued the assailed order dated July 28, 2005 removing Martinez from office. Such act was patently illegal and, therefore, Martinez was no longer required to avail himself of an administrative appeal in order to annul the said order of the Sangguniang Bayan. Thus, his direct recourse to regular courts of justice was justified.